You want to step up?
Yeah.
She's great. That's the way you talk about it. Oh, that's okay. That's it. Don't worry, we're taking care of it. Are you kidding me? Okay. No, of course not. I got this. Mimosas? That's what Actually, no. So I'm trying to get rid of it. That's good as well. No.
All rise. The court is now in session. The Honorable Shirley Matthews presiding.
Good morning. You may be seated.
We actually just wanted to speak about timing, Judge.
Oh, all right. Did you get a copy of the expert witness jury
Yes,
instruction?
Judge.
Okay, if you have fill-ins for that.
I can just scratch out who we need. We don't need Dr. Bryan or Dr. Packers on this.
Does it say what Detective Waglarowski is an expert in?
Yes.
Okay. Okay. Yeah, if you give it to us, we'll change it. I want to give you a complete set of the jury instructions and make sure you agree with them.
Thank you, Judge.
All right.
May we speak with you off the record regarding timing?
Sure. All right, we had a discussion about some jury instructions where you have to make some minor tweaks, and then I'll make copies for both sides, and I'm going to provide the jury with some copies of the jury instructions as well.
Thank you, Judge.
Thank you, Your Honor.
All right. We also discussed some scheduling, and you want to recall someone, I think.
Yes, Judge. We're going to recall Special Agent Brett Brandon for very brief testimony.
All right.
Yes, Your Honor.
All right, so are you ready for the jury?
We have not heard from Mrs.
Not yet. And Mark Keast on behalf of the people.
Mario Lehman on behalf of Mr. Crumbley.
Karen McDonald on behalf of the people.
All right. Mr. Crumbley, can you hear us?
Yes, I can, thank you.
All right. All right, we're going to bring the jury in.
Thank you, Judge.
Oh, yes. Should I do that? Your Honor, just very briefly, I just wanted to make a quick record before the jury comes in that Amy Crumbley and James Crumbley Sr. will not be testifying as defense witnesses. They were on the witness list, however, they are not testifying. They are in the courtroom, which is why we're making a record.
Okay.
Mr. Keese is aware. We did talk about it before coming into the courtroom this morning.
That's correct.
All right. Thank you.
Yes, Your Honor.
All rise for the jury.
Good morning. As always, thank you for being on time. You can be seated. Prosecutor, who's your next witness?
Thank you, Judge. The people are going to briefly recall Special Agent Brett Brandon.
Could you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth so help you God?
I do, Your Honor.
All right, could you please step up and would you state your name for the record and spell your first and last name?
Yes,
please?
it's Brett Brandon, B-R-E-T-T, Brandon, B-R-A-N-D-O-N.
Go ahead.
Thank you. Good morning, sir.
Morning.
Sir, you're one of the officers in charge of this case?
Yes,
Okay. And you were here yesterday for Lieutenant Willis's testimony, is that right?
that's correct.
Okay. And you've had the opportunity as well to review surveillance footage of different facilities?
Yes,
Okay. Does that include surveillance footage of 1111 Bellevue in Detroit?
it does.
Okay. And do you recall when Lieutenant Willis was asked if he remembered if James or Jennifer Crumbley ever left the premises of 1111 Bellevue, he couldn't remember the answer?
I do recall that, yes.
Okay. Do you have a definitive answer for us?
Yes,
Tell us about that, please.
yes. So in my review of the video from 1111 Bellevue, I did not observe Mr. or Mrs. Crumbley leave the premises. They did, like we stated yesterday, go to their car several times to smoke cigarettes and come back inside, but they did not leave the premises from what I saw in the surveillance video.
Okay, so we have surveillance video admitted already about 11:30 a.m., around noon a.m. with the time difference on the surveillance camera, that James and Jennifer Crumbley arrived in the parking lot. Is that right?
I believe that time is correct.
Okay, and then we saw footage of James Crumbley pulling the vehicle out and back in the same parking spot?
Yes,
Okay, but they never left that location of 1111 Bellevue?
I did not observe them leave, no.
Okay. We heard testimony regarding certain foodstuffs were found in Suite 130 in that location.
That's correct.
In the review of your video, were you able to give us information regarding that?
Yes.
Tell us about that, please.
So in the afternoon, at some point, the owner of that art studio that they were staying in got into his vehicle, departed, returned a while later with white grocery bags, a bag of ice, and I think a case of waters that he made 3 trips in and out, carrying that into the apartment or into that unit. And then that was the person that dropped off those groceries.
Okay, thank you. I have nothing for that.
Ross?
Very briefly, Your Honor. Good morning, Agent Brandon.
Good morning.
You testified that James and Jennifer left the building, but remained on the premises.
That's correct. Yeah, they were a little out of view of the camera by the front of the vehicle, but from my observations, they would go out there for a few minutes and then walk back in.
From what you recall from your review of the information that you received during your investigation, it wasn't just once or twice, but they actually went in and out of the building multiple times that day, correct?
Yes, I don't recall the number, but it was probably north of 6, and sometimes it would be both of them. Sometimes it would just be Mr. Crumbley. You know, occasionally it would be Mr. Crumbley's particular would come out with his hood up or ball cap on and then walk back in.
And we saw it was snowing that day?
I believe it snowed in the morning, and then as the day went on, it let up. But yeah, it was approaching winter.
It was December in Michigan, so cold.
I don't recall the temperature, but yeah, it was December in Michigan.
You also, if you recall, there were times when Mr. Crumbley or his wife left the building and went back in during the day, but also at night.
Yes, it started when they arrived and then continued through the evening, yes.
As for the owner of the art studio going to get foodstuffs, I think is what the prosecution referred to it as, you don't know why he went and got it. You just know that he went and got it. Is that fair?
Correct.
No further questions, John.
No redirect, thank you.
All right, you may step down.
Thank you, Ron.
And who's the next witness?
Thank you, Judge. I did speak with counsel last night as well as this morning regarding our exhibits, and we approached earlier to talk about that. I will provide the court as well as counsel with our updated version. I have made a record before we started with testimony regarding exhibits that were admitted. I won't go through all of them, but I will rely upon the document that I provided counsel as well as the court that these exhibits are in fact admitted.
Yeah, we made an extensive record of which exhibits would be admitted last week, correct?
Correct, Your Honor.
That's correct. And the only exceptions that I did want to point out, we have an agreement to Exhibit 378. That's a redacted transcript of James and Jennifer Crumbley's interview video at the Oxford substation.
Right.
We're in a stipulation to that. That's 378.
Ms. Lehman, did you have an opportunity to review the transcript?
I did, Your Honor. I have reviewed it. I have spoken with Mr. Keast about it, and we do have an agreement to admit that as an exhibit.
You believe it's accurate?
I do believe it's accurate, Your Honor, yes.
All right, I will admit number 378 then.
Thank you, Judge. And the only other two exhibits that are currently noted as exhibits on this list are 373 and 374. Those are not admitted and at this point will be omitted from the exhibit list.
373 and 374 will not be admitted.
Yes, Judge.
All right.
And Your Honor, I would like the opportunity, and I believe Mr. Keast will do that, to give me a copy of that list to just ensure that I have the same number of exhibits that he has and to make sure that we agree.
Okay, sure.
And Judge, with that, people rest.
All right. Ms. Lehman.
Yes, Your Honor. At this time, the defense would call Karen Crumbley.
Good morning. Could you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, so help you God? Okay, and could you pull this door toward you
I got it.
and have a step up? And have a seat. And then would you state your name for the record and spell your first and last name?
Karen Crumbley, Karen,
All right, I'm going to ask you to keep your voice up.
Okay.
All right, take a deep breath.
Okay.
All right. Go ahead, Ms. Lehman.
Thank you, Your Honor. Good morning, Ms. Crumbley. Can I call you Karen?
Yes, ma'am.
Thank you. Karen, I am going to, again, ask that you keep your voice up. You are a little soft-spoken, so I want to make sure that the jury and the courtroom can hear you, okay?
Okay.
I just have a few questions. How are you feeling today?
Good.
Are you nervous?
Well, I mean, yes, a little. I mean, I'm all right.
I'm going to take you back. Well, let me start with this. Do you know James Crumbley?
Of course, yes.
How do you know him?
He is my brother.
Do you know his son?
Yes, I do.
I am going to ask that you not say his son's name. We do have some direction from the court not to use his son's name in court.
Okay.
And what is his son's relationship to you?
He is my nephew.
We're going to be fairly specific. Where do you live?
I live in Welaka, Florida.
Tell the court a little bit about yourself.
I was raised in Jacksonville, Florida. I went and graduated high school, and then I got my medical assistant degree and did a few times in New Hampshire at Dartmouth-Hitchcock Hospital, and then came back to Florida. And I was in a car accident where I lost my right leg, and now I stay in a town that is peaceful, and I have 4 children and 2 grandchildren.
How old are your kids?
17, 18, 23, and 25.
I'm going to take you back to 2021. Where are you living in 2021?
In Welaka, Florida.
Specifically, I'm going to ask you about April of 2021. Do you recall what was going on in April of 2021?
My mom was in the hospital. My mom passed away April 6th of 2021.
Do you recall if you saw James or his son in April of 2021?
Yes, I did. My brother James was there in the hospital with us when my mom passed. And then my nephew came down, I believe, the day after and stayed for the while we had those services. And then we had like a memorial thing, like get together with everybody, cookout and stuff. And then we had the services, the funeral services and things like that.
You said your mom passed away on April 6th of 2021?
Yes, ma'am.
Do you remember exactly that your nephew came down on the 7th, or are you not sure of the date? And if you don't know, it's okay.
I know that they left when they found out that my mom had passed. I believe my nephew and his
Let me stop you
mother.
for a second. Who's they?
My nephew and his mother
Okay.
drove down to Florida from Michigan when they'd find out, and believe they got there maybe around on the 7th that they arrived.
Okay. So you remember that you saw your nephew maybe the 7th. It might have been the next day, or maybe you're not sure.
Right. Yes.
But it was shortly after the 6th.
Yes. It was very shortly.
While your brother and his son were in Florida, did you spend time with them?
Yes, I did.
Okay. Obviously, it was a difficult time with your mom passing away. Do you recall seeing anything concerning about your nephew?
No.
Do you recall him saying anything concerning to you?
No.
And if I ask you about if you recall if anyone...
Will you keep your voice up? Just
Yes.
I want the jury to be able to hear.
Okay, I'm sorry.
Thank you, Judge. When I ask you if you recall hearing anything or anyone saying anything, I don't necessarily want to say what they said.
Okay.
That's not allowed. But just if you recall hearing anything.
No.
Do you recall having conversations with your brother where he expressed anything concerning to you about his son?
No.
Do you recall your brother expressing any conversations he'd had with his son that were concerning to you?
No.
Do you recall how long they were there?
I think I'm not honestly too sure. 1.5 weeks, maybe a week.
Okay.
For sure, for a week.
So it was more than a couple of days.
Of course, yes.
And you saw them more than one time.
Yes.
And when I say them, I mean both your brother James and his son.
Yes, ma'am.
Do you recall seeing James and or your nephew any other time in 2021?
Yes, I went to Michigan with my father and my stepmother to visit. It was actually he knew my father was going, but I was a surprise to my brother. And we went to Michigan. We stayed at their house for about a week.
When you
about
say
3 or 4 days, maybe.
When you say you stayed at their house, whose house did you stay at?
My brother James's house.
And was his son there?
Yes.
And you stayed there for a few days?
Yes, ma'am.
Did you spend time with James and your nephew in those few days?
Yes, ma'am.
And I'm going to ask you the same thing. Do you recall seeing anything concerning?
No.
Do you recall your nephew saying anything concerning to you?
No.
Do you recall your brother talking to you about concerning conversations he had with his son?
So I just
No.
have to object to that question. Honestly, I should object to the last question regarding April as well. She can testify as to what she observed and but not what James James said or not said.
Yeah, correct, yes.
From your observations, did you see anything concerning in June of 2021?
Absolutely not.
And did you speak with your brother after June of 2021?
Yes.
Did you speak with your nephew after June of 2021?
Not directly, no. Heard him in the background, tell him I said hi, he said hi, things like that, but not directly, no.
So based on those interactions, although they weren't direct, they were kind of in the background,
Yes.
did you observe anything concerning with your nephew between June of 21 and, we'll say, November 30th of 2021?
No.
If there had been anything concerning that you had observed, what would you have done?
I would have addressed it, and if I would have known anything, I would have talked to him, I would have took him home with me if there was any kind of inclination that anything was wrong.
Would you have made your brother aware of it?
Of course.
Did you ever make your brother aware of anything that you were concerned about?
No, because there was nothing I was concerned about.
I have no further questions, Your Honor.
Ross?
Good morning.
Good morning.
My name's Mark. I'm going to ask you some questions. If anything I ask is confusing or sometimes I kind of go on a little bit, just let me know and I can rephrase the question.
Okay.
Now, James Crumbley is your brother, obviously.
Correct.
And we refer to him as the shooter. He's your nephew.
Yes.
Okay. The last time you actually saw the shooter was June of 2021? Your nephew?
You mean in person?
In person, yeah. The last time you saw him?
I think, Your Honor, but she's hesitating. I think I know what she's hesitating about. Do you want to discuss it at the bench?
Can we approach? Yes. I think I know what it is too.
Okay. All right, go ahead, Mr. Case.
Thank you. Before the shooting on November the 30th, the last time you saw your nephew was in June of 2021?
Correct.
Okay. And the last time you saw him before that was in April 2021?
Correct.
Okay. And you, from the time of actually, you may not know this, but everybody's phones in this case were seized and analyzed. Did you know that?
Yes, sir.
Okay, including your brothers as well as your nephews?
Yes, sir.
Okay. So you're not here to tell us that you had a particularly close relationship with your brother, is that right?
We had a close relationship, but we lived in two different states, so it was mainly, it wasn't like close.
Well, you wouldn't talk very often.
At least maybe once a month.
Well, according to the phone records on your brother's phone, it was far less frequent than that. Does that sound right to you? And I'm not trying to trip you up.
No. We talked on social media as well.
Right. So there's call logs, actual device to device.
Right.
Then there's Facebook calls as well.
Correct.
And I show 2 Facebook calls.
Okay.
And then there's instant messaging, and there's 22 instant messages between you and your brother.
Okay.
And that's the entire year of 2021.
Okay.
And then there's some group Facebook messages
Right.
with other members of the family.
Okay.
Now, your nephew never wrote you a note that said, "Help me."
No,
did he?
sir.
And he never drew a picture next to that note with a gun, did he?
No.
Okay. And that would be concerning to you.
Yes.
Okay.
It would
And is
cause-
that what you meant to say, or is that what you meant when you said, what would you have done if you saw something of a concerning nature?
I would have brought it up, yes.
Yes, that would be something significant to you as a mother.
To address, yes, of course.
I think it might have glossed over. I want to clarify. On the phone log, there's only 3 actual phone calls between you and your brother in 2021.
Okay.
Does that sound right to you?
I
Okay.
guess.
Now, you were interviewed in November of 2023 by an investigator when your name was put on the defense witness list. Do you remember that interview?
Yes, sir.
Okay. And you were asked if you knew you were on the witness list, and you said that you didn't know at that point.
Right.
Okay. And then you said you would have nothing to testify on their behalf because you had no knowledge of the incident until after it happened.
Correct. I have no knowledge of the incident.
Okay. And then you said you didn't know that a gun was bought for your nephew prior to the incident.
I did not know about that weapon, no.
And during that interview, you were asked about guns in the family home back when everybody lived in Florida. And you said, well, you know, some firearms is something that wouldn't be out of the ordinary for someone to own back in Florida when you grew up.
Right,
Do
no.
you recall that?
Yes, I do
Okay.
recall that.
But then you said, having guns in the house wouldn't be out of the ordinary, but getting one for your kid would be. At 21 minutes into the interview,
Getting one as in,
like giving a gun as a
no,
gift for
not
your
giving,
kid.
but to use at a shooting range or whatnot.
Well, I'm just
I would
reading
not see a problem.
your words, and again, I'm not
Okay.
trying to trip you up.
Yeah, no, okay.
You said getting a gun for your kid, that would be out of the ordinary.
Yes.
Thank you.
Redirect?
Yes, Your Honor, thank you. The prosecutor asked you about guns in the family home. And you were aware, or let me ask you, were you aware in April or June of 2021 if there were firearms in James Crumbley's family home?
Yes.
And what do you know about those firearms, if anything?
I know that there was a Derringer because I saw and held it myself when I was there in June.
And how did you go about seeing and holding it?
He took it out of his room. I had brought it
Let me
up.
stop you. Who's
Okay,
he?
sorry. My brother,
Okay.
James, took it out of his room to show because it was, I guess it's maybe like an antique kind of ish gun. I'm not sure. I don't know really too much about them, but and I wanted to see it and I hold it, and it was very heavy. And then afterwards, he put it back in its case and brought it back into his bedroom.
Okay. You said you're not very familiar with guns, right?
Correct.
The prosecutor asked you about a statement that you made about getting a gun for your kid would be, I don't remember the word he used, odd or something along those lines. Is that right?
Yes, ma'am.
Okay. What did you mean by that? It sounded like you were trying to explain that to the prosecutor, and I don't know if we heard it.
I mean, if you're getting a gun specifically for your child to use at his leisure, that would be wrong. But with adult supervision, and I don't see any problem with it.
I have no further questions, Ian.
Just real quick, Rick Cross. When you were there in June, here in Michigan in June, I take it, right?
Yes.
Okay. And James went and showed you the .22 caliber Derringer, the small gun.
Yes?
Okay. You said he went and where he kept it in his room.
Yes, sir.
And the whole family was there.
Yes, sir.
Okay. I have nothing else. Thank you, Judge.
Well, you can step down in your excuse. I'll watch the step right here.
Yes.
All right, who's the next witness?
No further witnesses, Your Honor.
Revolve?
Just to confirm, Judge.
Yes. Oh, yeah, that's the Yes, yes,
I knew you were there.
yes.
No more violence.
No rebuttal. Thank you.
Just for the record, Ms. Crumbley, who just testified, is in the courtroom. I believe that, is there any objections?
No, she can say she's excused.
Are there any additional witnesses?
Not from the people.
Come to the defense room.
All right. Approach. apologize. I was trying to see if your lunches could be here earlier. So your lunch will arrive at 11:30. Your lunch will arrive at 11:30, and we'll be hearing closings at 12:30. All right? So I need to tell you that during the trial and between now and the time that you hear closing arguments, you must not read, listen to, or watch any news reports about this case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they can give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. Please do not go on social media. Please do not post, go on Facebook, do research, and discuss the case with anyone. We have come this far, all right? So please follow my instructions. You're going to be free to go. Your lunch will be delivered to your respective jury rooms at 11:30. But I have to caution you, there's people in the courthouse. There are other trials going on. There is a ton of media here. So I need to trust you to not interact with anyone or listen to anyone talking about the case. Or you get it, right? Do you guys get it? You get it?
Yes.
Okay. I've told you a lot of times, right? So at about 11:30, your lunch is going to be delivered to the jury room. At 12:30, we'll hear closings. It's hard to predict what's going to happen and when it's going to happen. So lunch will be at 11:30, and then we'll have closings at 12:30. Do you have any questions about the schedule?
Can we go outside?
Yes.
As long as we're cautious and don't talk.
Yes. It's a beautiful day. You can enjoy the sun, take a walk around our beautiful Oakland County campus.
I'm doing it every day.
You've been doing it? Okay, good, good. Whatever you want to do, just please avoid people because, you know, not everyone is as well behaved as you 15. Let's put it that way. All right? Anything else about that? So your lunch will be here at 11:30 and then we'll hear closings at 12:30. All right? Thank you.
All rise for the jury.
You may be seated. I'm thinking you was the jury. Okay. So, before you depart, you did change that jury instruction, and then I'm going to give you the jury instructions. If you have a certain order, I have them in an order that I think is logical, but if you want to change any of it around, you can do it.
The only one I had noticed from last time, Judge, is they have 20.30A after 1613 instead of in the middle. Last time it was in the middle. It didn't seem to really make sense. So
20.30A and 16. Okay.
yeah, and for reference, that would be right in front of 1615.
All right. Anything about the jury instructions, Ms. Miller?
No, Your Honor.
I'm going to give you a set of them to make sure that you agree with them before closings.
Thank you, Your Honor.
And Ms. Lehman, would you like to inquire of your client?
I would, Your Honor. Mr. Crumbley, will you please stand up? Thank you.
Mr. Crumbley, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, so help you God?
I do.
All right, you can put your hand down. And would you state your name?
James Robert Crumbley.
All right, go ahead, Ms. Lehman.
Thank you, Your Honor. Good morning, James.
Good morning.
You know that you and I have talked about your trial. Is that right?
That is correct.
We have talked about how the trial will go.
That is correct.
You know that when you were accused and charged with these offenses, that you have the right to remain silent.
That is correct.
We discussed that that right carries through the trial.
That is correct.
You and I have discussed the whether or not you would testify during your trial.
That is correct.
We talked about the benefits of you testifying.
That is correct.
We talked about the risks of you testifying.
That is correct.
And we've talked extensively about whether or not you would testify.
That is correct.
And knowing all of that, is it your decision to testify or is your decision to remain silent?
It is my decision to remain silent.
All right. Mr. Crumbley, do you have any questions for me or do you need any further discussion with your attorney?
No, I don't believe so. Thank you,
Okay.
Your Honor.
Okay. All right, I think we're releasing the jury right now. I want to caution everyone that's here to be cautious about interacting with anyone in the courthouse. If someone were to say something or do something in front of one of the jurors, it could be devastating to this process. So I know emotions have been running high through the whole trial, and I'm just asking everybody to please, mind where you are and what you're saying and who you're interacting with, all right? Starting over would be devastating for everyone, all right? So are they released? Okay, so the jury is released. I'm going to make sure no one's in the hallway before you take them down. So we're going to have closings at 12:30.
Yes, Your Honor.
We'll have the instructions available for you before that.
Thank you, Your Honor.
Oh, 20 point. If you put them in the order you want them in,
I'll take care of it.
Copy them. Okay. So we have them. She modified the expert witness, right?
Yes.
Okay.
Thank you.
So if you return them to us, we'll make a copy for each of you, and we'll also make a copy for the jury. All right?
Thank you, Judge.
All right, so I'll see you here at 12:30. You can take the defendant, but let me make sure that there's no one in the hallway. All right? And I'm going to ask you all to remain seated while the defendant is taken out of the courtroom. Okay.
It's okay. Okay.
Do you want this back or this first?
That can be it.
Okay.
You didn't move any.
We did.
This is the order.
You've been watching day 5 of the James Crumbley trial. Prosecution just wrapped up and rested their case. We're going to go into closing arguments soon here. Jack Nissen joins us, a digital producer and journalist who's been keeping us updated on the web. Jack, what do you think about everything that's been going on? It was pretty quick this morning.
It was pretty quick this morning, Bree, but it's also been pretty quick the entire trial. I think we went at kind of a breakneck pace yesterday. I think we heard from 6 different witnesses. And then on Monday, I think it was maybe closer to 3, but the value of the testimony the past 2 days have probably been the most important and probably the most consequential of the entire trial. We kind of got a look into the actual home of the Crumbleys. We had a look at the meeting with the counselors. We got a good look at where the guns were kept in the Crumbley household. And we saw footage of when they were arrested. So these are all kind of linchpins in this case for when the jury is going to make the decision about how culpable the parents are. It was pretty fascinating stuff. And then, of course, today we saw the defense's only witness. Last trial, we only saw one witness from the defense as well. That was Jennifer herself. This time, we didn't hear from James, but we did hear from a family member, Karen Crumbley, who added only brief testimony. It was quite a drive up from Florida, I'm sure, to only answer a few questions. But for the defense, it's probably very important questions, which is, beyond just the immediate family, did you see anything amiss? Did you see anything that concerned you? Anything that you might have been, spurred to go and tell somebody about, either concerns from the Crumbleys about their son or the way they were being parented? And she said no. So, for all of that being said, it's been a pretty quick trial. And as you said, closing arguments are up next.
At 12:30, right?
Correct.
So a lot of people online are curious about why we don't use the shooter's full name. And it's out of respect for the families and things like that. Do you want to explain that a little bit more?
Yeah, so, this case has been going on for a long time. And I think sort of balancing the significance of the coverage with sort of the precedent that it's setting, you want to keep up with it as much as you can. When it comes to sort of journalism, you have to make sure that everything is, I don't know, followed as much as it can. And so, I think we used the shooter's name up until a certain point. When it got around to trial coverage, and I think as well as the shooter's sentencing, the families asked that we didn't refer to his name anymore. I think a key part of that is oftentimes when mass shootings are carried out, they're done so with the intention of garnering fame. Their intention was to, make a name for themselves and so that they become famous. I believe the shooter even mentioned in his journal that he would carry out the largest mass shooting in Michigan history, kind of hoping to sort of go down in history. But, to combat that, we don't say his name out of respect for the families and just sort of, I think, kind of going forward. I've kind of been seeing a trend from a lot of other media organizations that try to avoid really idolizing or even providing any sort of coverage that could idolize the shooter while still providing enough coverage for the victims.
Let's talk a little bit about what happened yesterday. We did see a new witness take the stand that didn't testify in Jennifer Crumbley's trial, and we also saw a snippet of a journal entry that we haven't seen before, where the shooter does mention that his dad didn't want him to get the 9mm gun, and they were going through financial struggles and things like that. How do you think that testimony contributed to the outcome of, what's going to happen with this verdict and closing arguments?
Absolutely. Yeah, I think that it could be kind of the crux of this case. I will take everybody back to the voir dire, which was jury selection back last week when the trial actually began. The defense attorney asked each and every person that took the stand, or rather was seated on the bench to potentially be a juror, and she asked them what they thought of access. What did access mean to them? Does access mean having permission to get something? Does access being physically allowed to get something, or even physically capable of getting something without being told that you're allowed to have something? There's a lot of gray area there in how people might interpret that phrase. But it's kind of at the heart of this case, because when we got to the diary entries that were written by the shooter, he mentions that he is trying to and has succeeded in getting access to the gun. Whether James Crumbley is aware of that is kind of a big key part of this. Whether he should have even made it possible for his son to have access to the gun is another part of this. I think the jury is going to consider a couple different ways as far as, how easy it was for the shooter to have an opportunity to get the gun, and whether his parents did a good enough job making sure that wasn't possible. So between those two things, I think that it could really add a lot of value to the jury's deliberations when they actually go and make the decision themselves.
And yesterday we heard from, I think it was about 5 or 6 witnesses yesterday, just speaking to the fact that this trial did move a little bit faster than we were expecting. I think Jennifer Crumbley's trial was a little under 2 weeks, wasn't it?
Yeah, it was about 2 weeks, yes.
Yeah. So now we're seeing closing arguments just 5 days into this trial. So, I mean, do you think that gives any insight into what his fate could be?
Nope.
No?
I think that, the thing about this case is it's very novel. The only other example we have was one that happened a month ago. And I believe someone actually said that, it's kind of the equivalent to a comedian going up and telling a bunch of jokes to an audience, and the audience, enjoying it, and then going up and trying to do the same thing again with the same jokes. This time, the audience is completely different. There's also a couple of different pieces of evidence that are allowed in this, a couple of different witnesses, as we already mentioned, but the case is somewhat the same. However, with a completely different pool actually deciding the verdict here, it's not out of the realm that we could see a completely different result at the end of this case, which I think would be kind of a wild duality in all this, since we're only kind of beginning to see examples of this kind of case for the very first time. How people consider whether and how it should be prosecuted is probably still up for interpretation, since it's very, very new. And in Oakland County, we're seeing the first 2 examples of it. It's rather amazing.
Well, Jack has been following this trial, Jennifer's trial, along with Ethan's sentencing for the past 4 months now. All of these updates are online at our website at fox2detroit.com, where you can see what's been happening for the past 4 or 5 days and get up to speed everything that's been going on in this James Crumbley trial. Thanks, Jack.
Thanks, Bree.
All right, we're gonna take a quick break. When we come back, we're gonna replay the testimony of Karen Crumbley. That's James Crumbley's sister. We'll be right back. We won't be right back. We'll go ahead and play that right now.
Karen Crumbley, K-A-R-E-N-C-R-U-M-B-L-E-Y.
All right, I'm going to ask you to keep your voice up.
Okay.
All right, take a deep breath.
Okay.
Go ahead and sing it.
Thank you, Your Honor. Good morning, Ms. Crumbley. Can I call you Karen?
Yes, ma'am.
Thank you. Karen, I am going to, again, ask that you keep your voice up. You are a little soft-spoken, so I want to make sure that the jury in the courtroom can hear you, okay?
Okay.
I just have a few questions. How are you feeling today?
Good.
Are you nervous?
Well, I mean, yes, a little. I mean, I'm all right.
I'm going to take you back. Well, let me start with this. Do you know James Crumbley?
Of course, yes.
How do you know him?
He is my brother.
Do you know his son?
Yes, I do.
I am going to ask that you not say his son's name. We do have some direction from the court not to use his son's name in court.
Okay.
And what is his son's relationship to you?
He is my nephew.
We're going to be fairly specific. Where do you live?
I live in Welaka, Florida.
Tell the court a little bit about yourself.
I was raised in Jacksonville, Florida. I went and graduated high school, and then I got my medical assistant degree and did a few times in New Hampshire at Dartmouth-Hitchcock Hospital, and then came back to Florida. And I was in a car accident where I lost my right leg, and now I stay in a town that is peaceful, and I have 4 children and 2 grandchildren.
How old are your kids?
17, 18, 23, and 25.
I'm going to take you back to 2021. Where are you living in 2021?
In Welaka, Florida.
Specifically, I'm going to ask you about April of 2021. Do you recall what was going on in April of 2021?
My mom was in the hospital. My mom passed away April 6th of 2021.
Do you recall if you saw James or his son in April of 2021?
Yes, I did. My brother, James, was there in the hospital with us when my mom passed. And then my nephew came down, I believe, the day after and stayed for the while we had those services. And then we had like a memorial thing, like get together with everybody, cookout and stuff. And then we had the services, the funeral services and things like that.
You said your mom passed away on April 6th of 2021?
Yes, ma'am.
Do you remember exactly that your nephew came down on the 7th, or are you not sure of the date? And if you don't know, it's okay.
I know that they left when they found out that my mom had passed. I believe my nephew and his mother.
For a second. Who's they?
My nephew and his mother drove down to Florida from Michigan when they'd find out, and believe they got there maybe around on the 7th that they arrived.
Okay. So you remember that you saw your nephew maybe the 7th. It might have been the next day, or maybe you're not sure.
Right. Yes.
But it was shortly after the 6th.
Yes. It was very shortly.
While your brother and his son were in Florida, did you spend time with them?
Yes, I did.
Okay. Obviously, it was a difficult time with your mom passing away. Do you recall seeing anything concerning about your nephew?
No.
Do you recall him saying anything concerning to you?
No.
And if I ask you about if you recall if anyone...
Will you keep your voice up? Just
Yes.
I want the jury to be able to hear.
Okay, I'm sorry.
Thank you, Judge. When I ask you if you recall hearing anything or anyone saying anything, I don't necessarily want to say what they said.
Okay.
That's not allowed. But just if you recall hearing anything.
No.
Do you recall having conversations with your brother where he expressed anything concerning to you about his son?
No.
Do you recall your brother expressing any conversations he'd had with his son that were concerning to you?
No.
Do you recall how long they were there?
I think I'm not honestly too sure. 1.5 weeks, maybe a week.
Okay.
For sure, for a week.
So it was more than a couple of days.
Of course, yes.
And you saw them more than one time.
Yes.
And when I say them, I mean both your brother James and his son.
Yes, ma'am.
Do you recall seeing James and or your nephew any other time in 2021?
Yes, I went to Michigan with my father and my stepmother to visit. It was actually he knew my father was going, but I was a surprise to my brother. And we went to Michigan. We stayed at their house for about a week. About 3 or 4 days, maybe.
When you say you stayed at their house, whose house did you stay at?
My brother James's house.
And was his son there?
Yes.
And you stayed there for a few days?
Yes, ma'am.
Did you spend time with James and your nephew in those few days?
Yes, ma'am.
And I'm going to ask you the same thing. Do you recall seeing anything concerning?
No.
Do you recall your nephew saying anything concerning to you?
No.
Do you recall your brother talking to you about concerning conversations he had with his son?
So I just have to object to that question. Honestly, I should object to the last question regarding April as well. She can testify as to what she observed and but not what James said or not said.
Yeah, correct, yes.
From your observations, did you see anything concerning in June of 2021?
Absolutely not.
And did you speak with your brother after June of 2021?
Yes.
Did you speak with your nephew after June of 2021?
Not directly, no. Heard him in the background, tell him I said hi, he said hi, things like that, but not directly, no.
So based on those interactions, although they weren't direct, they were kind of in the background.
Yes.
Did you observe anything concerning with your nephew between June of 21 and, we'll say, November 30th of 2021?
No.
If there had been anything concerning that you had observed, what would you have done?
I would have addressed it, and if I would have known anything, I would have talked to him, I would have took him home with me if there was any kind of inclination that anything was wrong.
Would you have made your brother aware of it?
Of course.
Did you ever make your brother aware of anything that you were concerned about?
No, because there was nothing I was concerned about.
I have no further questions, Your Honor.
Ross?
Good morning.
Good morning.
My name's Mark. I'm going to ask you some questions. If anything I ask is confusing or sometimes I kind of go on a little bit, just let me know and I can rephrase the question.
Okay.
Now, James Crumbley is your brother, obviously.
Correct.
And we refer to him as a shooter. He's your nephew.
Yes.
Okay. The last time you actually saw the shooter was June of 2021? Your nephew?
Do you mean in person?
In person, yeah. The last time you saw him?
I think, Your Honor,
Oh,
but she's hesitating. I think I know what she's hesitating about. Do you want to discuss it at the bench?
can we approach? Yes. I think I know what it is, too.
Okay. All right, go ahead, Mr. Case.
Thank you. Before the shooting on November the 30th, the last time you saw your nephew was in June of 2021?
Correct.
Okay. And the last time you saw him before that was in April of 2021?
Correct.
Okay. And you, from the time of actually, you may not know this, but everybody's phones in this case were seized and analyzed. Did you know that?
Yes, sir.
Okay, including your brothers as well as your nephews?
Yes, sir.
Okay. So you're not here to tell us that you had a particularly close relationship with your brother, is that right?
We had a close relationship, but we lived in 2 different states, so it was mainly, it wasn't like close.
Well, you wouldn't talk very often.
At least maybe once a month.
Well, according to the phone records on your brother's phone, it was far less frequent than that. Does that sound right to you? And I'm not trying to trip you up.
No. We talked on social media as well.
Right. So there's call logs, actual device to device.
Right.
Then there's Facebook calls as well.
Correct.
And I show 2 Facebook calls.
Okay.
And then there's instant messaging, and there's 22 instant messages between you and your brother.
Okay.
And that's the entire year of 2021.
Okay.
And then there's some group Facebook messages
Right.
with other members of the family.
Okay.
Now, your nephew never wrote you a note that said, "Help me."
No,
did he?
sir.
And he never drew a picture next to that note with a gun, did he?
No.
Okay. And that would be concerning to you.
Yes.
Okay.
It would
And is
cause-
that what you meant to say, or is that what you meant when you said, what would you have done if you saw something of a concerning nature?
I would have brought it up, yes.
Yes. That would be something significant to you as a mother.
To address, yes, of course.
I just want to, I think it might have glossed over, I want to clarify. On the phone log, there's only 3 actual phone calls between you and your brother in 2021.
Okay.
Does that sound right to you?
Yeah, I
Okay.
guess.
Now, you were interviewed in November of 2023 by an investigator when your name was put on the defense witness list. Do you remember that interview?
Yes, sir.
Okay. And you were asked if you knew you were on the witness list, and you said that you didn't know at that point.
Right.
Okay. And then you said you would have nothing to testify on their behalf because you had no knowledge of the incident until after it happened.
Correct. I have no knowledge of the incident.
Okay. And then you said you didn't know that a gun was bought for your nephew prior to the incident.
I did not know about that weapon, no.
And during that interview, you were asked about guns in the family home back when everybody lived in Florida. And you said, well, you know, some firearms is something that wouldn't be out of the ordinary for someone to own back in Florida when you grew up.
Right,
Do
no.
you recall that?
Yes, I do
Okay.
recall that.
But then you said, having guns in the house wouldn't be out of the ordinary, but getting one for your kid would be. At 21 minutes into the interview,
Getting one as in,
giving a gun as a
no,
gift for
not
your
giving,
kid.
but to use at a shooting range or whatnot.
Well, I'm just
I would
reading
not see a problem.
your words, and again, I'm not
Okay.
trying to trip you up.
Yeah, no.
You
Okay.
said getting a gun for your kid, that would be out of the ordinary.
Yes.
Thank you.
Redirect?
Yes, Your Honor, thank you. The prosecutor asked you about guns in the family home. And you were aware, or let me ask you, were you aware in April or June of 2021 if there were firearms in James Crumbley's family home?
Yes.
And what do you know about those firearms, if anything?
I know that there was a Derringer because I saw and held it myself when I was there in June.
And how did you go about seeing and holding it?
He took it out of his room. I had brought it.
Let me stop you. Who's
Okay,
he?
sorry. My brother,
Okay.
James, took it out of his room to show because it was, I guess it's maybe like an antique kind of ish gun. I'm not sure. I don't know really too much about them, but and I wanted to see it and I hold it, and it was very heavy. And then afterwards, he put it back in its case and brought it back into his bedroom.
Okay. You said you're not very familiar with guns, right?
Correct.
The prosecutor asked you about a statement that you made about getting a gun for your kid would be, I don't remember the word he used, odd or something along those lines. Is that right?
Yes, ma'am.
Okay. What did you mean by that? It sounded like you were trying to explain that to the prosecutor, and I don't know if we heard it.
I mean, if you're getting a gun specifically for your child to use at his leisure, that would be wrong. But with adult supervision, and I don't see any problem with it.
I have no further questions, Ian.
Just real quick, when you were there in June, here in Michigan in June, I think, right?
Yes.
Okay. And James went and showed you the .22 caliber Derringer, the small gun.
Yes.
Okay. You said he went and where he kept it in his room.
Yes, sir.
And the whole family was there.
Yes, sir.
Okay. I have nothing else. Thank you, Judge.
All right, you can step down and you're excused.
All right, the trial has been going on for a little over a week now. Charlie Langton has been in the courtroom for the past week. He's joining us now live from Pontiac. We can see what's going on through the lens, Charlie, but we can't necessarily, but you're there, right? You can see everything that's going on. How has this morning been? It was brief, but how was this morning?
Well, I think you have to take a look at why the prosecutor would recall the ATF agent, and then ask yourself, why would the defense call James Crumbley's sister? So let's go back to the prosecutor first. There was only one witness to be recalled. We thought there were going to be no witnesses, and technically there were no witnesses. The prosecutor can recall a witness. But for the very limited purpose today, the ATF, Brett Brandon, and he wanted to take the jury back to Detroit, back to the day that the allegations are that the Crumbleys fled. So this, by my count, will be the 6th witness to testify about Detroit. So what does that tell me about the prosecution's case? Is that they really believe that the Crumbleys, the crime may have been committed after they were charged, that they fled. And believe me, they're going to hammer that home. They did, with the last 6 witnesses talking about that. So one more today. And the ATF agent essentially was asked, what did you see on the video of the art, where they were, the owner of the art studio, that he went to the grocery store, he bought groceries, he brought a case of water. Why? The implication there is that the Crumbleys were going to stay there because it was safe. Maybe because they were hiding. At least that's the implication from the prosecutor. And if that is the case, the jury is going to be told that if you believe that the Crumbleys were hiding, fleeing, you can consider that as an element of guilt. It's an extremely important part of the prosecution's case. And so that's why that ATF agent was recalled. Remember, he only reviewed the tape. He wasn't even actually there. But nevertheless, okay. Now, why would James Crumbley call his sister to testify? Sister lives in Florida, near Jacksonville. We know from other parts of this case, James Crumbley has another child who's, I believe, an adult right now that does live in Florida, in the Jacksonville County area, or at least that's where they were before. The purpose of the defense, that strategy, is to get someone related to James to basically say that that one of the issues was the shooter, did he have mental illness? Was he upset? Was he distraught? And one of the big issues there was James's mother's funeral. And James's mother's funeral, we now learn today, was in Florida. And James took his son down to Florida for the funeral. And yet the sister said she did not see anything wrong. It was a family, no problems whatsoever. Again, the theme now from the defense is to say that there was nothing wrong with the shooter. But what they're really trying to do is the issue of foreseeability. That's the legal issue. In order for the prosecution to win, James has to foresee that whatever problems his son may have had, James had to have sought, it had to be foreshadowed. And one of the big issues is the funeral. For example, if the shooter was all crying and upset and distraught and whatever, that would give James a sign that you better get this kid some counseling. Didn't happen that way. That's why they were called. And one other time, the sister testified in June, a couple months before the shooting. She was up here in Michigan, and again, observed the whole family and observed nothing unusual. So now we're getting a little bit of the defense case, is that she's going to hammer home to the jury that there was no foreseeability, legal word, but hugely important for the defense. James could never have foreseen that his kid would shoot up the school. And I would suspect that in closing arguments, the defense is going to hammer it home. Not only did James not see anything, but the school counselor didn't see anything, dean of students didn't see anything, etc., etc. So we actually got today, even though the testimony was pretty short, we got a little bit of an insight into the themes that we're going to hear in just a couple of hours or so in closing arguments. And so I think it actually was, the morning was very telling about the theories of this case. I think overall a very well-tried case. I mean, I think the jury's got quite a bit to convict or quite a bit to acquit, and that's why we have the juries. Bree?
You know, Charlie, I'm shocked to hear that James Crumbley actually had another child. But when it comes to this witness list, was there anyone else on the witness list that they were going to bring up that they ultimately decided not to?
Not for the defense. It's unusual. Remember, the defense doesn't have to call any witnesses. Zero, none. And I mean, obviously, everyone's speculating, will James testify on his own behalf, as his wife Jennifer did in her trial. But we saw what happened there. Well, it was not good for Jennifer. And again, as a defense attorney, you've got to condition the jury to accept the fact that a defendant does not have to testify and does not have to call any witnesses. It's a little unusual not to call any witnesses, but that the defendant doesn't have to testify is one of the best rules around. The burden is on the prosecutor to prove her case, period. That's the law, that's the way it is. But it's hard conceptually for non-lawyers to understand that concept sometimes. So that's why in the picking of the jury, again, very important, the defense attorney, Mario Lehman, hammered home the point, James does not have to testify. And to make it even more important about the defendant not testifying, after the jury left, after both parties rested, no more witnesses, jury was excused, and then I don't know if you saw it, I don't even know if the tape was on, but the judge pretty much asked James Crumbley, stand up, swear under oath. And then he was questioned by his attorney. You know you have a right to testify. You can testify. We've discussed the advantages to testifying and the disadvantages, and is it your choice not to testify? And James Crumbley, under oath, said, yes, I will not testify. That record's got to be made in a criminal trial because the defendant has a right to testify, even though the judge will tell the jury that the defendant does not testify and you cannot hold that against him. The judge will tell that to the jury. But there's a little procedure that has to be gone through. It's a good procedure, and it happened in this case. Bree?
So, Charlie, I know you've mentioned over the past couple of days that you don't think James Crumbley is going to testify, and you're right. But what was happening at the end there when he was having that little back and forth with his lawyer, and we did hear from him a little bit? What was going on there?
Yeah, the lawyer was questioning James Crumbley about testifying. You've got to put that on the record. You got to make sure that the defendant understands that he does have a right to testify. He can testify if he wants to. But if you don't testify, you got to make that known. In other words, the defendant himself, James Crumbley, he's got to be aware of his rights to testify or not testify. And they go through that little questioning by his attorney and James. So standard in every criminal trial, especially when defendants don't testify, which in my experience is about 95%. The only time a defendant would testify really is in a criminal sexual conduct, a rape case where it's he said, she said, and there's no other witnesses in the world, no other video, no other people, and the accusing witness says he did it. And then he would probably get on the stand and say, I didn't do it. So and there's other exceptions to that, but that's the general textbook rule where defendants would testify. Obviously, this is a totally different case. General rule, defendants don't testify. James Crumbley did not testify. Doesn't surprise me, and I think it's the absolute right move.
So why did Jennifer Crumbley testify in her trial? Then why do you think that decision was made for her?
That's a great question. I don't know. I think some people think they can get up and they can withstand cross-examination, or they become so credible when they get on the stand that I've got nothing to hide, nothing to hide. It's not the case. You're talking about very skilled questioners, and a lot of things can be slanted. And a lot of very strategic questions. Why did she testify? I think Jennifer Crumbley thought that she did nothing wrong, and I think her strategy was to hammer home the point that it was James who bought the gun. It was James who instructed the shooter as to how to shoot the gun, and it was James and the son who loved guns, and that Jennifer had nothing. I know nothing. It's I know nothing defense, which is a tough defense. Obviously, the jury didn't buy it. And actually, if you remember, at least talking to the foreperson of Jennifer's trial, she was quoted in the media as saying that one of the big factors for that jury, not James, that Jennifer jury, was that Jennifer was the last person to actually have the gun. and actually take the shooter to the shooting range. So that was a big issue in the last trial. So I don't know why James testified. I thought it was a mistake. I think I said it, but listen, different lawyers have different strategies. And listen, had Jennifer testified and was found not guilty, I think Shannon Smith, the lawyer, would have been a lawyer of the year, because that's a strategy I didn't see coming. And a lot of lawyers that I talked to didn't see it coming either. But again, listen, this is strategy. We don't know what's going to work and what's not going to work. And so you have to kind of it's kind of a sixth sense. It's almost like picking a jury. I don't know if this person's good, but I kind of like him. Let's get him on. It's like anything in life. Sometimes you have to take a chance. Sometimes you make the right decision. Sometimes you don't.
I think the confidence she had to take the stand was pretty impressive, especially considering that we just saw the footage in the police car where it seemed like James was more cooperative, and it just kind of seemed like her attention span, like she was focused on other things. She was trying to get out the car. So I think her confidence there is interesting to me. But then what's interesting to me also is the fact that we just saw a new journal entry where the shooter said that his dad actually didn't want him to get the gun. So I'm wondering, at what point did that change?
I think what you're making is a very good point, Bree, is that defendants today, in this modern world of trying cases today, defendants do testify. Why? It's because of this thing. It's all on cell phones. There's video everywhere. There's text messages everywhere, and it's all recorded. They've got experts, and we saw them in this case, sheriffs, cops, that do nothing in their world. Their only job is to extract data from devices, whether it's video, whether it's phones, whether it's Facebook, whether it's all the stuff. And so defendants do testify today. And you take a look at just in the back of the police car on the day of the shooting, you saw a big contrast between Jennifer and James. I'll just ask you, who do you believe more? I don't care what the facts are. I don't care what the questions. Just look at the person, Jennifer, who was screaming, "Why am I handcuffed? I don't want to be handcuffed. What's going on?" And she was agitated. You know, remember there was a friend of hers that she saw, Patrick was yelling out there. And James, sitting there, "It's going to be okay." And he gave her a kiss, and he was compassionate. Just forget the facts of this whole case. Just on that, who do you believe and who don't you believe? Or who are you likely to believe? Who are you not likely to believe?
If we're basing this just solely, if we're basing this solely
on
body
that,
language
alone,
else. You know, I gotta go with James. I gotta go with James. He seems more compassionate.
It was James.
And we also saw, you know, when he called it in, you know, after the shooting happened, and he called it in, and he seemed so concerned. It's like, my son's at the school. You know, I have this gun, all that stuff, and then, you know, she's in the back of the police car while they're searching, and she's asking for a cigarette, and it's not looking good there. So
it's not. See, Bree, you are the average juror. You are the jury. This isn't rocket science. It's psychological. It's people, and I think that James, I would bet that he's far more compassionate than his wife. So there you go. Why would you call Jennifer to the stand is beyond me. And so would you call James because he's such a nice guy? No, he already testified. You leave it alone. And that's why I think the prosecutor spent 6 witnesses after all that stuff. 6 witnesses to talk about going and fleeing in that Detroit art studio, because that is like they're running. And again, if the jury believes James was running, even with Jennifer, that's what they're going to be. I think that's what they're really going to be questioning about. So
you know, and if we're talking about the art studio, I mean, they were pretty set up in there. Like you said, they had water and everything. They had a mattress, and they were sound asleep. We saw that on the body cam yesterday. So it's that argument's difficult to make, right? That they weren't trying to do what, you know, people are assuming that they're doing.
I think what was realistically going to happen was, I don't think that the Crumbleys thought that they were going to be arraigned on manslaughter, but I think that the Crumbleys thought that they were going to be given a personal bond. The bond is, I think it's $500,000 in this case. Well, I mean, I don't know, Bree, do you have $500,000 laying around to post bond? Times 2. So you need $1 million. They don't have it. So, but I think that the Crumbleys thought that they needed a place to stay for a while, and they couldn't go back to their house because of the media and because of whatever. Again, I'm guessing, I don't know this for sure, but they wanted a safe place. Now again, an art studio in Detroit, you know, is probably not a, it's not a luxurious place
thing.
either.
Yeah.
But again, I don't know that, and I don't know how long they would have been there. And a case of water, I don't know, I can go through water a lot. I mean, she smoked 14 cigarettes in one day. If anything, they probably would have had to get cigarettes. Listen, I don't know what was in the Crumbleys' mind, but I think it was a rude awakening when they arraigned the Crumbleys and they pretty much gave that very high bond. And so that was it. And they've been in jail, right over there, Oakland County Jail, for the last 2 years. So their life changed quite a bit on that day. And I tell you, I don't think James ever thought that that would happen, at least, and Jennifer too, at least then.
Mm-hmm. Because they even had to sell their homes, you know, to pay for legal fees and things like that as well. So, I mean, this is definitely probably not what they expected, right? When it comes down to it.
And they wanted as we heard from the Jennifer trial, I mean, they had a couple of horses that she was trying to sell. There was a deal with a horse person to sell the horse for $5,000. They needed money. And I think that's why they took the money out of their bank account. Listen, you have no cell phone, you can't go back to your home, you've got no job, and your kid is accused of being the Oxford High School shooter? Good luck in living. Listen. Mm-hmm. It's a real practical problem, and I think that the defense tried to bring that out, to undo the thought from the prosecutor that these people were running away. They weren't running away. They were trying to adjust to their life. Their life was turned upside down in an hour. You just think about it. Your kid becomes the Oxford High School shooter. Everybody knows it. It's all over social media. I mean, my gosh, we probably had 8 or 9 reporters alone on that story. Just us. And this place is crawling with reporters right now. So this was a major national. If I remember correctly, I think the President of the United States, I think President Biden made a speech about this. Listen, it's a big story. The Crumbleys were done. So they were panicking. They didn't know what to do. But I don't know in my own mind whether that's fleeing. Prosecutor will say it's fleeing, and there's all 6 witnesses that the jury heard about it, but I think the defense, it's very difficult for the defense to undo that. But again, those are the issues. Life is crazy, all that kind of stuff. So that's why all of that testimony came in on both sides. But let's see if the jury gets there. I think the jury is going to have to at least figure out, did James Crumbley know? Did he do things that were grossly negligent or not do things that were grossly negligent? The drawing, not taking the kid out of school, etc. And was it foreseeable that the shooter could be the shooter? That's the issue. That's the legal issue. So we'll have to see. We'll get those instructions.
And we know that the shooter asked for help multiple times based on his journals. Did that ever come up in the argument that, you know, there wasn't actual proof that he asked them for help? Did that ever come up?
No.
No?
Nope.
No, the journal was enough.
The journal, which is very the journal's very controversial, and the defense objected to the journal getting into evidence. Why? Because I don't know if that's true. I mean, I can write anything, and generally speaking, you've got to lay a foundation. Who wrote this journal, and is what is written true? And we didn't have that here. Again, the judge made a ruling on the shooter's journal, and she allowed it into evidence. But the defense attorney can't cross-examine the person that wrote that. So you got to take out little parts that are good for the defense and take out little parts that are good for the prosecution. It is an issue that bothered me a little bit, the shooter's journal, and I think that someone wanted to call the shooter to testify, but because he's got a case and he's exercising his Fifth Amendment not to testify, it does become a legal issue that I think an appellate court's going to have to deal with. And without complicating things, the shooter's journal is going to be an issue on appeal. And it will be in Jennifer's case, and depending on what happens here, if he gets convicted, it will certainly be an issue on appeal. In other words, whether you can get essentially hearsay evidence into trial without a foundation. Again, I don't want to get too legal on it, but it is an issue. It was subject of a big argument before the trial started, but the judge felt that it was reliable enough and the jury can consider whatever it wants to consider it. Remember, there were things in the journal about how dad hid the gun, I got to go look for the gun, that type of thing. And there's no evidence, I don't believe, well, let me take that. There's no evidence that James knew the contents of that journal. There is evidence that James knew the shooter had a journal because he volunteered that evidence at the meeting in the counselor an hour or so before the shooting.
So I know that we heard from a couple of Oxford Oxford High School administration, like the counselor, a teacher that was shot and injured while this was all going on. Even the assistant principal, we heard from her as well. Do we see this going? What direction do we see this going for Oxford High School or the school district in general? Do we think that there'll be some level of accountability here for them?
So now let's talk about, this is everything we've talked about before. This trial is the criminal side of it. Then there's a civil side of it. Yes, Oxford High School was sued. They were sued and the case was thrown out of court. It was thrown out of court by a judge in this very courthouse because essentially you can't sue a school district because they're part of the government, and you can't sue the government because they have what's called immunity. Governmental immunity, we've heard that word, and what does it really mean? It means that for money damages, for civil damages, you can't sue the government. There are exceptions to this, but in this case, even if the counselor and the dean of students made the decision to keep the shooter in school, that would be a regular decision made in the ordinary course of business, maybe the wrong decision, which we now know it's the wrong one, but they have immunity from making normal decisions. Now, I'm simplifying governmental immunity because it is a big deal. Ven Johnson, who we've had on the show many, many times, my college roommate. I've known Ven for many, many years. He represents a number of the victims in Oxford, and Ven Johnson has been on a champion cause to undo governmental immunity because it is controversial. There's a reason we have governmental immunity, and it's because, in a easy nutshell, we don't want governmental units like schools, police departments, fire departments to be sued, because if they get a judgment against them, the taxpayers have to pay. And so we limit, the law limits how and when you can sue police officers, firefighters, and school districts. But in this case, the law says, again, those decision-making elements, if they're just negligence, no good. And that their negligence has to be what they call the proximate cause. It means their decision has to be the cause of those people dying. And really, the cause of the dying is the shooter, not necessarily the decision. And again, this is going to be, it's on appeal. Judge threw the case out, and without getting into a very complicated discussion on governmental immunity, but those are the elements of governmental immunity. It is worthy to discuss it. I do think we'll get some legislation down the road on governmental immunity. I don't know if Ven Johnson's going to be happy with it, because there is, listen, we don't want if Ven Johnson gets a multi-million-dollar judgment in Oxford, first of all, they're probably not insured for a whole lot, and second of all, the taxpayers would have to pay for it. And again, I'm getting into a little bit into the weeds here on this governmental immunity, but it's a very complex issue, not necessarily easily understood, but it's super interesting for lawyer and legislative types. We're going to see more, but bottom line, Oxford can't be sued. Judge threw that case out.
So we know that we're approaching closing arguments around 12:30, about a little under 2 hours here. We know that Jennifer Crumbley's closing arguments in her trial took about 2 hours, and a lot was uncovered during that time. What do you expect for James Crumbley's trial?
So let's go. The prosecutor goes first. I don't know who's going to give the closing argument. My guess it'll be Karen McDonald. She gave the closing in Jennifer's case. Karen McDonald, if she does the same kind of thing, she'll go witness by witness and discuss every aspect of the testimony from the witnesses. The purpose of closing arguments is to summarize your overall theory. So I don't necessarily go witness by witness, but Karen McDonald did. She's got the benefit of the video. She can put the name of the witness on. She can put some bullet points. She can run some videos and probably emphasize the warning signs that James Crumbley missed, the fact that it should have been obvious that a shooting was going to happen, and they fled afterwards, which just cements their guilt. So I think she'll probably go an hour, maybe a little better than an hour. Then the defense will go, and Mario Lehman will go. She's generally shorter. She's much more concise. Her opening was, I forget, 40 minutes maybe, not that long. And I think she'll summarize her theory of the case, that James was a father that did not, there were no warning signs, that he didn't see the journal, he didn't see anything. In fact, he saw the opposite. The kid was fine. And that no one would be able to foresee a shooting, and they didn't flee. So that'll be essentially. Then the prosecutor does have a rebuttal. They can go back and they get the last word because they've got the burden of proof. But all in all, if we start, 12:30 we're going to start for these? I would say 12:30 to roughly 1:32, 3, I would say, and then the judge will tell the jury what the law is. That'll take about 40 minutes, actually. It's a long time. Judge has to read a whole bunch of stuff. I would say the jury is going to get the case today around 4 o'clock. My gut, just time-wise-ish, give or take. And then the jury they can start deliberations, or they can come back tomorrow. My guess is they're going to, at some point, come back tomorrow. But I think that's probably a fair timeline, give or take.
All right, Charlie, I'm sure we're going to hear from you again at 4 o'clock on Live Now Detroit. We're going to thank so much for your time and your expertise. It's always good talking to you. We're going to take a quick break. When we get back, we'll replay some of the earlier testimony from Adam Stoic and some of the other detectives that were on the case. We'll be right back. Welcome back to Live Now in Detroit. You've been watching day 5 of the James Crumbley trial. We just went into a quick...
Now, I want to direct your attention to November the 30th. Okay, were you working?
I was.
We heard testimony yesterday regarding a search warrant at 112 East in Oxford, the Crumbley family home. Did you participate in that search warrant?
I did.
Okay. Now, if you could tell us, please, what happens when a house is secured for a search warrant?
Yeah, so securing a house prior to getting the search warrant, you're going to go initially and just kind of do an initial sweep of the house to make sure no one's inside the house, no one's injured inside of the house, and then after that you're just going to secure the house until you get the authorization from the judge, just for like preservation of evidence and make sure that if there is evidence inside the house that it's not tampered with.
Okay, and did you do that in this case?
I did.
And who else was with you?
Detective McPherson, Detective Steele, Detective Peschke, Deputy Zajac, Deputy Mozak, and for apprehension was there too.
From the ATF?
Correct.
Okay. Now, when you were sent to that location, did you know what would be found there?
No.
Okay. And when were you assigned with this task?
After we initially searched the school, my supervisor at the time was Sergeant Hicks. He gathered a few of us up and said to go to 112 East Street and secure the residence.
Okay. So you responded to the school first, and then you were tasked with securing the residence at 112 East in Oxford?
Correct.
Okay. I'm going to show you what's been admitted as People's 270. Sir, is this a photograph? This photograph fairly accurately depicts the address at 112 East?
It does.
Okay. Describe the layout for us of the home.
Yeah, so it's when you walk in here, that's the front of the residence that faces East Street. Walk in to your immediate right, there's a living room area with a couch. There was a TV. You walk into the left, it was like the dining room. There was a table, chairs. Through that, there was a kitchen. Off the kitchen, there was 2 bedrooms, one on the right, one on the left, a bathroom.
I'm going to show you what's been admitted as well as 205. Is this a sketch of the home?
Correct.
Okay. And so we have a front entrance at the top of the diagram here?
Correct.
Okay. Can you just walk us through here?
Yeah, so where the sheriff's emblem sign is there is the front of the residence. You'd walk in. This would be on the left of this picture. Here is the living room. There's some couches. There's a TV stand, a table. To the right there of that was the dining room. There's a kitchen table, some chairs. I think there was some workout equipment in there. Past that, there's a little opening right there which led to the kitchen, refrigerator island, some cabinets. So right there to the left would be the entrance. There's a little hallway to 2 bedrooms. There's 1 bedroom. That's north bedroom. There's a bathroom in between that. And then across the hallway there was labeled middle bedroom. Was the bedrooms. And then you come out of there. There was a little hallway. There was an opening to like the landing that led to the basement, the foyer. And then it was what was the master bedroom was immediately past that.
Okay. Now, prior to participating in the search of this home, did you learn which bedrooms were associated with the shooter?
I did.
Which one?
So in this picture here, you'd see north bedroom was one of the shooter's bedrooms, and then directly across the hallway, which is labeled middle bedroom there, was also the shooter's bedroom.
Okay, so his rooms were, what we have labeled here is north bedroom and then middle bedroom. Both are adjacent to the bathroom, and middle bedroom is adjacent to the master bedroom. Is that correct?
Correct.
Okay. Now tell us, when you first entered the home to secure it for a search warrant, did you see anything of note?
Yeah, so obviously you're kind of just doing the search, but you're obviously still, if you see things, you take a mental note of what you see. And when I walked into what I was described as the master bedroom, there was an open 6-hour gun box on the bed, and next to that was an empty box of 9mm ammunition on the bed as well.
Did you touch that?
I did not, no.
Okay. So when you see something like that, what do?
You just kind of take a mental note of it, and obviously once you get the authorization from the judge and the search warrant, you're going to go search the house, and my partner and I were tasked with searching that bedroom, so we were aware before we came in.
So after the home was secured and you confirmed that, well, first of all, when it was secured, did you encounter either James or Jennifer Crumbley?
I did. I had a brief encounter with James Crumbley.
Okay, is he in court today?
He is.
Can you please point to him and describe something he's wearing?
He's wearing the suit with the blue shirt and the blue tie.
Your Honor, would the record reflect identification defendant?
The record will so reflect.
Tell us where you encountered James Crumbley at when you arrived on scene.
When I initially got there, he was secured in, I don't remember who, Deputy Mozak or Deputy Zajak's patrol vehicle.
Okay. Now, if an admitted video of a patrol video indicated 2:46 p.m. arrival on November the 30th, 2021, does that seem right to you?
Yes.
Okay. Did you speak with Mr. Crumbley?
I did.
Okay. Did you speak with him on scene there or when he was transported to the substation?
So I had a brief conversation with him prior, or at the substation, really nothing of note. And he was taken back to the residence, and that's where I had more of a, not in depth, but more of a conversation with him outside of the residence.
Okay. So I'm going to show you and play what's been admitted as People's 300. This is the in-car video that you referenced. Just raise the volume. Thank you.
Have a seat right now. Why is she in handcuffs? I don't know. Can you take the handcuffs off from me, please? Carefully hold yourself. Okay, plug in first. It's not going to be long for those handcuffs, I promise.
Why am I in the cuffs though?
Until we can figure out everything.
This hurts. Like it really hurts.
Hold on one second.
Why am I in your cuffs?
I don't know. I don't know. I asked them the same fucking thing.
They didn't do anything. I'm getting claustrophobic. I'm getting claustrophobic.
Honey, don't freak out in front of the house. This is going to be a lot better if you don't make the situation.
Why are they here? Why are they here? Okay, push my glass in my nose, please. Put jacket on my lip, please. I have my fucking phone. Why are I'm so confused?
Why are you in fucking handcuffs?
Your phone here?
I set it down and then I have a cop pointing a gun at me.
Why are they in our house? I'm so confused.
We're dealing with this shit. We're already dealing with shit. Why have we got to deal with this?
Where's your other gun?
In the gun case.
Where's that at?
And the dresser.
There's Patrick! There's Patrick! 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 Patrick!
He can't hear you, Jimmy.
Patrick!
He can't hear you. He's not going to be able to hear you.
Patrick!
Jen, he can't hear you.
If you're in the market for a brand new roof, now is the absolute best time to buy because the prices have never been lower. For the best deal on a roof that doesn't leak, just head to HybridGun.com. With Housework, in the country's possible technical reviews. And just like that, there it is. The only time in the hospitality.
Honey, I love you. In case something happens. If anything happens, you do not answer any questions without a lawyer.
Ma'am, I didn't catch your name.
It's Jennifer.
Jennifer, come on out. Wait, hang on. I'll get the handcuffs off.
Okay, so that timestamp was 2:50 p.m. on November 30th. Does that appear right to you?
It does.
Okay. Now, you said James was transported to the substation and taken back?
Yeah, there's a lot going on. So initially, we were kind of instructed to take James to the substation and interview him. After a conversation with, I believe, Sergeant Bryan, it was determined that he had already spoken with detectives prior to us getting there, so he was taken back to the house while we were waiting for the search warrant to be completed.
Okay, so we heard testimony in this trial that Sergeant Bryan began that interview at 1:58 p.m., and this occurred after that, is that right?
Yeah, it was after the initial interview.
Did you have some conversation with James about obtaining a search warrant for the home?
Yeah, I had a brief conversation with him.
Okay. Did you let him know you were looking for firearms?
I did, yes.
And would that conversation have been recorded on the in-car video system as well?
Yes.
Okay. I'm going to show you what's been admitted and play for you. Exhibit 204. This is a portion of the in-car video from 3:42 p.m. on November 30th.
Hey, man. Hey, so let me just grab your name real quick. I know you already got it, but I just want to know who I'm talking to. Can you just spell it?
James,
Yep.
you know my middle name too?
No, what's your last name?
Crumbley, Crumbley.
What's your phone number?
6483.
Okay. So what's going on is we're waiting for to complete the search warrant, okay? So what we're going to do is you guys, obviously, while we're waiting to go into the house, we can't have you guys go back in right now, just while we wait till we get the search warrant. So you're more than welcome to either sit in here, you're more than welcome to get in your car and hang out until this is done. You're more than welcome to go get a cup of coffee if you want or something, but it's probably going to be a little while. So it's kind of up to you. But while we're waiting for that, we just ask, obviously, please don't go inside the house while we're waiting for everything to be done, okay? In the meantime, can you tell me where those guns are so we don't have to rip your house apart? Is that cool?
Yeah, absolutely. They're in a gun case.
We're at the house.
And if you go to the very back of the very back of the house,
where like the husky was sitting.
Yes.
Okay.
Yes, and he's nice.
Yeah, he's nice.
So then you guys can just be cognizant of the doors. We have cats.
Okay.
Okay. But if you go into that back bedroom, there's a dresser on the left with the TV sitting on it.
Yep.
The very right cabinet door.
Okay.
Inside of there's a black gun case that's locked.
Okay.
And then there's some 20. There's only a 20. There's a 22 Derringer.
Okay.
And a 22 Kel-Tec.
It's locked.
Pistol. The case is locked.
How would we get into that? Do you mind if we get into that?
I mean, if you absolutely have to.
Is it got like what kind of, is that a combination on
It's
it?
just a combination.
Okay. Do you mind if we, because we're going to have to get the guns obviously for now.
Yeah.
Do you mind if, okay. Otherwise I don't want to have to, you know what I mean? Just
No, I'm completely open, and I want you guys to do what you have to do. I mean,
0.
0.
Yep.
0. 0.
3 zeros.
4. And that's the only. Oh, okay. And then in the bedroom to the left of the bathroom,
okay,
there is a BB gun.
Okay.
It's unloaded.
Okay.
But it looks like a freaking assault rifle.
Okay.
It's one of those
AR-15.
Well, it's not AR-15. It's something different, but it's one of those air cartridge.
Yeah. Oh, I got
BB
it.
guns.
Okay. Fair enough.
Okay. But that's just sitting out. So don't freak out when you guys see that. It's not a.
I appreciate the heads up.
Yeah.
Are you going to want to hang tight, or what are you guys going to want to do?
Well, I mean, where's my wife? I want to,
What does she want to do? Okay. Do you want to go with your wife then?
Yeah.
Okay.
Sorry,
We'll let you.
Am I?
You talked to Sergeant Brian earlier?
Yes.
Okay. He's going to call you when you guys are able to come back, okay?
Okay.
Fair enough?
I'll need my phone back.
Who's got his phone? Somebody have the phone?
So backing up just a little bit, can you tell us why Jennifer Crumbley was in cuffs?
Yeah, there was multiple. There was a few detectives. There was deputies on scene. I didn't take part in placing her in handcuffs. That would have been up to the deputy that put her in handcuffs.
And the deputies arrived were coming right from the school, is that right?
Correct.
Okay. Just now in this interview with James Crumbley in the back of the car, he told you the combination code was 0000, 4 zeros, is that right?
Correct.
Did you subsequently recover that safe?
I did.
Was it 4 zeros or 3 zeros?
It was 3 zeros.
Okay. Did you come to learn what the default code is for that safe?
Yeah, 000.
Now, what did you find inside that safe?
Yeah, so inside the safe there was a 22 Kel-Tec handgun and a 22 Derringer, which is like a single shot handgun, was inside of the safe when it was opened up.
Okay. Once the search warrant was officially authorized by the judge, did you participate in the search of the home?
I did.
And there are actually 2 occasions on which detectives entered the home with authorization from the search warrant. Is that correct?
Correct.
So once was November 30th, the evening of the shooting, and their time was December the 13th?
Correct.
Okay, both 2021.
Correct.
All right, I'm going to take you through some photographs of the home. First of all, prior to a search warrant being executed of somebody's residence, are photographs taken?
They are.
Are they taken before or after the home is searched?
Before.
Okay. So any photograph received from November the 30th of 2021 was taken before the room was searched by any detective?
That's correct.
This is Exhibit 249. Tell us what we're looking at here.
Yeah, so the initial picture, that's the front door of the residence. Right when you walk into your immediate right, there was couches and a TV in the living room area.
So I'll try to take us through the home as you would walk through it. So we have the door in the frame here?
Correct. That's the front door that faces East Street.
That's the front door in the living room, okay. This is 250. What is this?
It's just a wider angle. That's the couch that we saw in the initial picture, and the other couch that would be facing the front door.
Okay, so if you step into the front door and you turn to your right, this is what you'd be looking at?
Correct.
All right, this is Exhibit 251. What is this?
Yeah, same thing. Right when you walk in the front door, this would be to your immediate right, and kind of straight ahead. There's just the couches and then a chair, table.
Okay, here's 252. Again, we see the front door.
Yep, so that would be, now you'd actually be facing the front door. That was just the TV stand, which had the TV on it towards the front door.
Okay, and you told us that there was the living room, and then in the same area, you described a dining room?
Correct.
Okay. This is Exhibit 272. What do we see here?
Yep, so that was the dining room. It was some Christmas decorations, dining room table.
And this photograph was taken on December the 13th, 2021?
Yes, this was not the night of.
So this is if you walk in the front door and you turn to your left. Is that right?
Correct. Yep, you walk in and your immediate left would be this.
And here's 273. What do we see here?
Yep, so that'd be when you walk in, to the right was the living room, to the left was the dining room, and directly ahead of the dining room was the doorway that leads to the kitchen, which you can kind of see in the background there is the kitchen.
Okay. Here's 274.
Yep, so this would just be a picture of the kitchen, the island, the refrigerator. And then as you can see further down in the picture is the door to the master bedroom.
Okay, so this would be if you step towards that hallway, towards the kitchen?
Correct. Yep, you're exiting the living room. There's that little doorway, and that's going to take you right into the kitchen area.
Okay, we'll talk more about the kitchen in a few minutes. First, I want to take you through one of the shooter's bedrooms identified as the middle bedroom. Okay, this is Exhibit 206. What do we see here?
Yep, so that would be, there's a hallway, there's a bedroom to the left, bedroom to the right. This is the bedroom to the left, which is the middle bedroom. That was right when you walked in the bedroom. There was a bed with various belongings on it, and then on the wall you can see some shooting targets, targets.
Okay, and as a police officer, you've been to a shooting range before, is that right?
Correct.
Okay, these type of targets consistent with what you obtained in a shooting range?
Correct.
Okay. And this photograph was taken November the 30th, 2021?
Yes.
This is Exhibit 207. Are we in the same room?
Same room, just off the bed there. There was that desk with a TV, things all over the floor. That was the natural state of the bedroom we got in the house.
When you say natural state, that's before the detective searched it?
Yeah, correct.
And this plywood right here, can you tell us about this, please?
Yeah, so that part of the bedroom actually leads, that would have been a window that would have gone to the master bedroom. I believe the master bedroom is probably an add-on, so that would be a window that would lead you to the master bedroom.
Okay, so we're making sure we're oriented. This middle bedroom is adjacent to both the master bedroom on one side and then the bathroom on the other?
Correct.
Okay. This is Exhibit 208. Is the same room from a different vantage point?
Same room, yep. Just another little dresser there, the closet on the left.
Okay. Exhibit 209.
Same thing, just the various things on the floor, clothing, the chairs, same bedroom.
And Exhibit 210.
Yep, same bedroom, just kind of an outer shot that shows the whole bedroom there.
Sir, as a detective, tell us why it's important for someone to capture the natural state of something from different angles.
Yeah, so I mean, when you conduct a search warrant, obviously you want to be cognizant of the fact that that's someone's house. You don't want to tear the house up, but I mean, you're going to go through the house and things are going to get moved around. Do your best to clean up afterwards, but when you want to, a picture of this can show you what the house looked like right when you walked in. Nothing was changed, and what the livable conditions were when we got there.
Okay. And is that also why you would take multiple pictures of one bedroom just from different angles?
Correct. Yeah, just so you could get a full shot of what was actually going on inside of the bedroom.
This is Exhibit 211. Is this also the middle bedroom?
That is, yep. It's the closet in the middle bedroom.
Exhibit 212. Same closet?
Same closet. You can see there in the bottom on the chair was the butt of the, which Mr. Crumbley described as like the rifle-style BB gun.
Okay. We'll get to that in a second. This is Exhibit 213. What do we see here?
Yeah, those are the targets I described earlier. They're visibly been used. They had bullet holes in them, multiple bullet holes in both of them. That was on the wall right next to the bed, the shooter's bedroom.
This is Exhibit 214.
Yeah, same thing, just a different angle. That's the bed to your far left, and then the used shooting target on the top right corner.
If there were any other posters or pictures on the wall, that would have been depicted in the photographs of detectives. Is that right?
Correct.
This is Exhibit 215.
There's a picture of the bed. There was clothing, some school books, the knife on the bed there. There was tons of different stuff on the bed.
And so where the targets that were on the wall, they'd be just where this photograph cuts off at the top. Is that right?
Yeah, just above the bottom.
Okay.
The top part of the target would be, or of this picture, where the targets would be.
Okay. Here's 216. What are we looking at here?
Yep. So that's like a nightstand just off the bed. Various things on the nightstand.
And 242. This is a closer version. A closer photograph of the items on the nightstand.
Yep, correct. It was various spent shell casings. Looks like various caliber spent shell casings inside the plastic container, which was on the nightstand, which was directly next to the shooter's bed.
And this is Exhibit 243. You mentioned the butt of the rifle of that gun in an earlier photograph. Is this what you're referring to?
Correct. When I was speaking with James earlier, the video you played earlier, he kind of described that was the one he told me not to be freaked out about. It was the BB gun rifle that was on in the shooter's bedroom on his computer chair. And that's how it was when it was found.
This is Exhibit 244. What's this?
So that would be part of the dresser there that the TV's on. He had there was a notebook there, pencils, stuff like that. His wallet, that was on the TV stand.
In the middle bedroom still?
Correct, still the middle bedroom.
Okay. And 245, same drawer, different angle?
Yeah, correct. Looks like there's a lighter. I believe those are fireworks of some kind. And just another notebook, and that was also in the middle bedroom on the dresser there.
Okay. And Exhibit 246, we're still in the middle bedroom?
Yep, still in the middle bedroom, so that's going to be right at the front of the bed. It's a bottle, it looks like it's an empty bottle of Canada House, which is bourbon whiskey, at the end of the bed.
Now I'm going to move on to the north bedroom. This was identified as the shooter's other bedroom?
Correct.
Okay, so this would be the bedroom on the other side of the bathroom?
Yep, so when you came out of the kitchen, you made that right. It was a small hallway straight ahead with a bathroom. To the right was going to be the bedroom we're going to see now, which I think is the north bedroom, and to the left was that middle bedroom, is what you guys just saw in the pictures there.
Okay, so here's Exhibit 217. What are we looking at here?
Yep, so just kind of a shot of the overall bedroom on the right, which was also the shooter's bedroom, second bedroom.
218, same north bedroom, but from a different angle?
Correct. That'd be right when you walk into your immediate left. There's a TV stand, a TV, some clothing on the floor, and on your right there you can see the bed, which had various things spread all over it.
Okay, again, this is the natural state of how you found it?
Correct.
219, what are we looking at here?
Yep, so that would be you'd walk in, you make a left. At this point, they're kind of rounding the bed.
I'm sorry, 282, I misspoke.
It would just be the picture of the bed, and then in the far left corner there is a litter box. Cat litter box on the ground there.
Is it far left corner?
Yeah, so you get right there. Yeah.
Oh, I see. Okay.
Just various clothing and other items on the bed.
219. Are we still in the north bedroom?
Correct. It's the closet. Clothes in the closet.
All right. 220. What is this?
It's just a bed. Again, various things on the bed.
This is 247.
Yeah. So that was a notebook that was recovered in the bedroom. Obviously, there's some pictures of a rifle on it. Looks like another handgun in the bottom left there.
Okay, that's 247. That was found on the bed in the north bedroom?
Yeah, correct.
Here's 221. Are we still in the north bedroom?
Yeah, so that's just, now you're like looking out towards the bedroom. That's that doorway to the far left is the doorway that leads you out of the bedroom, and that open door was the open door to the bedroom that we saw the initial pictures in, just straight directly across the hall. They were both the shooter's bedrooms.
Okay, did you observe anything on the shelf?
Yeah, there were some knives, various knives on the shelves.
Okay, and that's depicted in Exhibit 248?
Correct.
And then finally, Exhibit 222. This is standing in the north bedroom looking down at the TV, was he?
Yeah, it was the TV stand. I think it had a little fireplace there and various items on the TV stand.
Okay, so we mentioned the bathroom that was adjacent to these two bedrooms. This is Exhibit 223. Does this accurately depict what you observed that day?
Yep, it does.
Now, did you also participate in the search of the master bedroom?
I did.
Okay, you mentioned what you observed during that process when you secured the home, but you participated in the search as well?
Correct.
This is Exhibit 224. What do we see here?
Yes, you could walk into the master bedroom, which you'll see other pictures here, but to your immediate right in the master bedroom was the bed. Right when you walked in, this was the first thing you could see was the open gun box, and that box next to it is an empty box of 9mm ammunition. And this is exactly how we saw it when we did the initial search of the house, and then when we came back in, once the search warrant was granted, this is how it was when we came in.
Okay. And this box right here is the empty box of ammunition, the red box?
Correct, 9mm ammunition.
This is Exhibit 225. This is the same master bedroom?
Yeah, just kind of a different view, but that's that'd be when you make a right to the bedroom. The bed was against the wall, and that was one of the sides of the bed.
Exhibit 226?
Yep, same thing, just the other side of the bed. So that far window right there on the left would be the window that would face the backyard of the residence.
Exhibit 227?
Yep, far left side of the bed there. That's the outer window that faces the backyard, and it's just clothing on the ground.
Okay, 228. This is still in the master bedroom?
Yep, so that's the door there to the master bedroom. When you walked in immediately on
this
the right.
This is the door here?
Correct. Yep.
Okay.
And on the wall there was armoire. On the far, or on the immediate right was that armoire.
And this is Exhibit 229?
Yep, just a different shot. That's the door. Immediate right's that armoire. To your left in that picture is the bed.
Okay, just so we're clear, all of these pictures of the master bedroom were taken November the 30th before the room was searched?
Correct.
Was the TV stand searched as well?
It was.
Okay. And that's where James told you to look for the .22 caliber firearms?
Correct.
Exhibit 230, this is the TV stand I'm referring to?
Yep, so that was what James had described, and I spoke with him. That's the TV stand, right when you walk into the bedroom, to your immediate left was that TV stand, multiple drawers, there had a TV on it. Within the door you're seeing, there was like a sliding glass door that would lead you to the outside backyard of the residence.
This is Exhibit 231, this is just straight on view?
Correct.
Exhibit 233, this is angled to the left?
Correct.
All right, 234, what are we looking at here?
Yep, so that TV stand we just saw, the furthest right door that was opened up, and that was where the gun box was, or the gun safe was located right there on the top shelf, as it is in the picture there.
Okay. And that was recovered by you?
It was.
Okay. And did you use the code 000 to open it?
I did.
It would open with that?
It did.
Okay. Was ammunition found on that shelf as well?
Yep. So when the gun box was removed from there, there was 2 magazines, the holster. It's kind of hard to see, but you can see there's a box of ammunition there in the back.
Okay. You say holster. What we're looking at, the object on the right, that's the holster?
Yeah, it's like a cloth holster, black cloth holster.
This is Exhibit 235. 236, were those items from that right drawer taken out and put on top of the TV stand?
Yep, so at this point they were removed from the picture you just saw. They were put on top of the TV stand. On the left there you can see the 2 magazines, gun magazines up, and then there's the bag with the ammunition in it. And then I think to the right there's the box for the ammunition.
Okay. And that's 22 caliber ammunition?
Correct.
Okay, did you participate in the search of the kitchen as well?
I did.
First of all, here's 237. This is what, let me ask you, what is this picture?
Yep, so the black firearm there is a 22 Kel-Tec handgun that was recovered when I opened the safe. The silver gun there is a 22 Derringer. It's a single shotgun that was also found in the safe once I opened it up. And then there was another magazine there to the far left, which is kind of hard to see. And then there's some ear protection. The orange ear protection was also located in the safe when it was opened.
So this is 238. What is this?
That's the 22 Derringer that was recovered in the safe.
And 240.
Yep, that's the 22 Kel-Tec handgun that was recovered in the safe.
Okay, so this is 276. Can you tell us what we're looking at here?
Yep, so that would be the kitchen. The pictures you saw earlier, that would have been on the right-hand side. And we saw the pictures of the kitchen. It's the refrigerator.
Okay, so I'm going to try to take us around the kitchen. Well, first of all, is there an island in the kitchen?
Yeah, so when you're looking outside of the kitchen, there was an island in the middle. There was across from that was like a sink, some shelving units, and then all across from the island is this, which is the fridge, more shelving units, all located in the kitchen.
Okay. This is 278, so this would be on the other side of the kitchen?
Yep, correct. So that would just be, when I described the other side of the island, you have the sink there on the left, the stove, and just various cabinets and other things in the kitchen there.
Did you have occasion to search in this island here?
I did.
Okay. This is 277, that's the island I'm referring to?
Correct.
All right. Exhibit 253. Tell us what we're looking at here and where it was found.
Yep, so on the far right corner there, you can see a black, which is later discovered to be a black gun box there in the far right corner.
Let me back up for 1 second. So we're talking about, I'm sorry, this cupboard here, the right cupboard of that island?
I believe it was, yes, the right cupboard, correct.
And that's 277. Here's 253?
Correct. Yep, so there in the far right corner, you can kind of see that black gun box was located there in the island on the right side of the island.
Okay, and was that removed?
It was.
Okay. This exhibit 255, what is this?
Yep, so that's just the gun box was taken out of there, and that's just a picture of the gun box. It was the gun box for that Kel-Tec, that black firearm that was found in the bedroom. This is the gun box for that 22 handgun.
Okay. And this is 256. What are we looking at here?
Yep, so the gun box was opened. It was obviously empty. Besides that, cable lock was located inside of the gun box. If you look closely, you can see the keys to the gun or to the cable lock there in the bottom part of the baggie there. That's how that was located when it was opened up.
Did you or any other detective find any other locking mechanism for a firearm anywhere in the home?
No.
You want to say this, the gun box next to the blender, what kind of gun box was that?
That was for the 22 Kel-Tec. It was the black handgun that was found in the safe in the bedroom.
All right.
And that's in Exhibit 253, which is also depicted in Exhibit 255. And that's where the cable lock was contained, depicted in Exhibit 256. Is that right?
Correct.
Okay. All right. All right. What are we looking at here in 257?
That's just a gaming system. I believe it was a PlayStation gaming system that was located in the residence.
Okay. 258.
Yeah, those are games for that gaming system, Battlefield, Assassin's Creed, Battlefront, just various games that were located inside of the residence for that gaming system.
All right, here's 259.
Yep, looks like those are more games, Grand Theft Auto. I'm not familiar with the other ones, Battlefield, and then a few to right there.
Okay, 260.
Yep, Call of Duty, Attack on Titan, some other games that would be used in that gaming system.
All right, was anything searched outside of the home?
Yeah, so outside of the house, there was a vehicle, a gray Kia, that was located in the driveway. It's Mr. Crumbley's vehicle. This is a picture of when the trunk was opened up, what was in the back of the vehicle.
Was there a garage or shed associated with the home?
Yeah, no garage. So the first picture we saw was the outside of the house. There was a driveway to the left of that led to the backyard. And then in the backyard, there was a shed in the backyard, but there was no enclosed garage or anything like that.
Okay, was the shed searched as well?
The shed was searched, correct.
All right, here's Exhibit 298. Before we get to the shed, what are we looking at here?
Yeah, it's just like an overhang, like almost like a foyer outdoor area that was covered. There's a grill out there, like a seating area, which is on the back of the residence prior to getting to the shed.
Okay. Here's Exhibit 299. Is this the shed you referred to?
Correct.
Exhibit 264. What do we see here?
Yeah, so when you walked into the shed, immediately through the door to the right, there was a couple BB guns, right, leaned against the wall there. As you can see, the brown one to the far left of the picture, and then the black one, which is rested against kind of the door frame there.
Okay. Exhibit 265.
Yeah, just a different angle. You can see the black BB gun in the right corner, then the brown ones right there visible, leaning against the wall.
Exhibit 266.
This is like on the workbench in the shed there. There was some BB guns recovered. That's like a Uzi style BB gun that was sitting on the bench when we went inside of the shed.
Exhibit 267.
Another BB gun. It's like a 357 style BB gun that was seated on. Same thing, right by that Uzi there. Right when we walked in, there was a big bench, and that was on the bench when you walked into the shed.
Okay. Here's Exhibit 268.
Yep, so you can kind of see the work area there in the back where the BB guns were recovered. This is just kind of an outer shot of some of the chairs and the floor of the shed.
269. What are we looking at here?
Yep, so that was outside of the shed. It was various CO2 containers which are used to shoot BB guns, pellet guns on the ground there.
Okay. Now, back in the home, Exhibit 289, where was this taken?
Yeah, so as I described, when you walk in the hallway before the master bedroom, there was like a landing that led you to the basement and to the outside of the house. So this was just an outer picture of that landing area. To the left of that photo would take you in the basement, and to the right would take you to the backyard.
Okay. And Exhibit 295?
Yeah, same thing, just kind of a landing, just an outer picture of that. Once you go there, to the right was that door that leads you to the backyard, and if you went down and made a left, that would take you down into the basement area of the house.
Any areas of the home that were not photographed during the execution search warrant?
No, everything was photographed.
Okay. Now, we heard the video where you told James that he and his wife could leave. That was timestamped at 3:42 p.m. At some point, did they return?
Yep, so after we were done with the search warrant, they returned to the residence, and they spoke with Lieutenant Marsban. Was there for that.
Were there phone seized at that point?
They were.
Okay. And at some point, were they turned over to Oakland County Computer Crimes?
Yeah, they were driven back to the high school by myself and Detective McPherson, and they were given to Detective Wogrowski.
Nothing further. Thank you, Judge. Now, I want to direct your attention to the days after the Oxford High School shooting of November the 30th, 2021. First of all, do you remember that day?
I do.
Okay. Were you working that day and that week?
Not that specific day. I was out of town, but the rest of the week, yes.
Okay. At some point, were you requested to locate James and Jennifer Crumbley?
We were.
And tell us how that happened, please.
I believe it was December 2nd. Lieutenant Willis asked me to attempt to locate both of them.
Okay. And if I told you they were formally charged on Friday, December 3rd, does that sound right?
Yes.
Okay, so Detective Willis sitting at the table here asked you to locate them?
Yes.
What information did you have at your disposal when you were given this assignment?
They're basic information. They're pictures, full names, height, weight, addresses, vehicles they drove, things of that nature.
Okay. Were you made aware that their phones were seized on the evening of November the 30th?
Yes.
Okay, so tell us, please, what did you and your team do to attempt to locate the defendant?
We began looking at and conducting surveillance at their residence. Any family members that we knew of, friends, things of that nature. Checked area hotels, places that we might think they might go.
Okay. Did you locate them? You were given this assignment on December the 2nd, you said?
Yes.
Did you locate them that day?
We did not.
Were you able to identify where they had stayed from November the 30th until that point in time?
We had identified a hotel they had stayed at. I don't specifically remember the name of the hotel, but
Okay.
any hotel.
That's fine. When you received that information, what did you do?
We checked with the hotel staff to find out whether there were still guests there, whether they had checked out, and in fact they had checked out.
Okay. So after you learned that they had checked out from that hotel, what happened next?
We continued to check area hotels, surveillance of any known locations, and eventually we located a vehicle that belonged to them at a hotel in Auburn Hills.
Okay. And when you identified this vehicle belonging to either James or Jennifer Crumbley, what happened next?
I pulled all of the team to that location and we began constant surveillance on that vehicle to check and see if they would come back for it.
Was that on Thursday, December the 2nd, or Friday, December the 3rd?
That was on Friday, December the 3rd.
Okay. And did either the defendant or his wife come back to the vehicle?
They did not.
Okay. And tell us, please, what's happening at that point in time?
At that point, we're still trying to locate them. We're still, again, checking anything, social media, anything we can find to try to locate them.
Okay. And were you able to at that point?
No, we did not.
All right. Tell us what happened next.
At some point late in the evening, and I don't remember the exact time, we were made aware that their other vehicle had been located in a parking lot by the Detroit Police Department.
Okay, so this is late in the evening on Friday, December the 3rd?
Correct.
Okay. Did you come to learn that they were formally charged at noon on December the 3rd?
Yes.
Okay, so earlier that same day?
Correct.
All right. When you learned that they were charged, what did you do personally?
Myself and one of the other detectives went to what we learned was their attorney's office and checked the office parking lot or surrounding parking lots to see if their vehicle might be there. By chance, they would be in the office with the attorney. Upon not finding the vehicle, we went in and made contact with one of their attorneys.
Okay. And without telling us what was said in that conversation, did you find either James or Jennifer Crumbley there?
Did not.
Okay. And at that point in time, they had the same attorney, is that correct?
It's my understanding, yes.
Okay. And so would that have been before noon on December the 3rd or after noon, December the 3rd?
It was afternoon.
Okay, so after they were charged?
Yes.
All right. And backing us up a little bit in the timeline, it was after that the vehicle belonging to one of the defendants was recovered?
Yes, several hours later.
Several hours later. Okay, thank you. Later that evening, Friday, December 3rd, what did you learn?
That the vehicle was located in the parking lot in the business in Detroit.
Okay. So another vehicle belonging to either James or Jennifer Crumbley was located in Detroit?
Right.
All right. Tell us what happened next.
At that point, I left one person sitting on the vehicle in Auburn Hills, just by chance they came back to it, and the rest of the team and myself went to Detroit to attempt to locate them somewhere in the area of the vehicle.
Okay. The law enforcement personnel involved in this endeavor, was it contained to just the 7 of you?
No, sir.
Okay. Tell us what you encountered when you went to the location where the vehicle was found.
Originally, when we got there were several Detroit police officers that had the street blocked and had the car secured in the parking lot. As we searched the area, because we had no idea whether they had walked away from the car, they were in the building, we didn't know at that point. So we were searching the area. More and more law enforcement officers arrived. Officers from the U.S. Marshals arrived to assist us, the Border Patrol, the Michigan State Police, more Detroit police, all arrived on scene.
Okay. After the exterior of the location was searched, and I take it no one was found then?
Correct.
Okay. What happened next?
We formulated a plan to begin searching the building. It was a 3-story industrial building. We had several officers on site, so at that point we decided to begin going room to room and search the entire building.
Okay. I'm going to show you what's been admitted as People's Exhibit 307. This is a photograph, sir. Do you recognize what's in this photograph?
I do.
And tell us how.
That is the industrial building where the vehicle was located in the parking lot.
Okay. So the parking lot would be behind this chain link fence to the right of the photograph?
Correct.
Okay. And did you and your team participate in the physical search of the interior of this building?
We did.
Okay. And now, contained to the interior of the building, again, was it just the 7 of you, or other law enforcement personnel involved as well?
Oh, several law enforcement officers.
All right, tell us about that, please.
The plan was formulated that the Detroit Police Department would search the first floor of the building. The rest of the teams that were there, we took on the task of searching the second and third floor of the building.
Okay. Now, was this done in secret, or was this out in the public, as far as the knowledge?
Oh no, it was very obvious, very apparent. There was dozens and dozens of officers. We went room to room. At some point, we had obtained keys to some of the rooms. When we had those keys, we were able to unlock the door, announce our presence, go in and search every place in the room that could potentially hide a human being. Other rooms we did not have keys for, and we were forced to force our way into those rooms.
When you say force our way into the rooms, can you describe what that looks like?
Yeah, there are several tools that are used to what's called breach or force a door open. There's a long Halligan-type pole like a fireman would use. You jam it into the door frame and pry the door back and get the lock to sometimes pop. If that doesn't work, we have a 35-pound battering ram, and we will batter the door lock mechanism until the door opens.
Okay. Is that a quiet endeavor, or is that loud?
Oh, it's very noisy.
So, specific to the 3 floors in what's the building depicted here in 307, which areas did you and your team search?
The second and third floor.
Okay. And was anybody located in those searches?
Not on the second or third floor.
Okay. At some point, were you made aware that James and his wife were found on the first floor?
Yes.
Were you involved in the actual breaching of that room and the arrest?
No, that was handled by the Detroit SWAT team, I believe, handled that door.
Okay, they had already been assigned to the first floor?
Yes, sir.
Okay. And tell us what happened after that occurred.
As soon as the SWAT team entered that room and searched it and discovered the Crumbleys in that room, they were taken into custody by Detroit, and then they were turned over to my team, who took custody of them and transported them back up here to Oakland County.
Okay. Do you recall the approximate time that occurred?
Probably 1:30, 1:15, somewhere. It was after 1 o'clock in the morning.
In the morning. So we're talking Saturday, December the 4th.
Yes, sir.
And is James Crumbley in court today?
He is.
Can you please point to and describe something he's wearing today?
Gray suit and headphones.
Your Honor, would record reflect the identification of the defendant?
The record will so reflect.
Thank you. Nothing further.
Cross.
Yes, Your Honor, thank you. Good morning.
Good morning.
Your involvement began on December 2nd of 2021, is that correct?
Yes, ma'am.
You were out of town on November 30th. Is it safe to say you were aware of the shooting that occurred at Oxford High School on November 30th prior to your involvement?
Yes.
Now, your involvement was as the sergeant of the Fugitive Apprehension Team.
Correct.
It's also called FAP, is that correct?
Correct.
You testified that unit is responsible for locating people with felony warrants or wanted for serious crimes.
Correct.
Your unit did not get involved in all felony warrant arrests, is that fair?
I'm not sure I understand what you
Sure. All felony warrant arrests in Oakland County, your unit did not go and arrest everybody who has a felony warrant. Is that fair?
That's fair.
Okay. And your unit did not get involved with all crimes that people were arrested for. Is that fair?
That's fair.
And let me clarify. So we know, and we heard some testimony previously, that there was a warrant issued by the court, correct?
Correct.
In this case, correct? And based on your experience, you were a law enforcement officer for 34 years, you were a detective for a number of years. You know that somebody who's accused of a crime and charged can walk themselves into a court, correct?
Correct.
With or without an attorney, right?
Correct.
And that includes for felonies.
Correct.
Their attorney, you're aware that there have been times where their attorney has arranged, sometimes with the detectives, sometimes with the prosecutor's office, in various ways. Their attorney can arrange for them to be turned in to the court or the police department on a specific day and time. Is that fair?
Sure.
The other ways are involving your former unit.
Correct.
And that's done by law enforcement. The attorneys don't call you up and say, hey, can you come get my client? That's the police who say, go get this person.
Correct.
And then obviously other agencies can get involved with our other arrests as well. Is that fair?
Yes.
In this situation, your involvement was requested prior to Mr. Crumbley being charged.
Yes.
You testified that your involvement was December 2nd of 2021.
Yes.
You were contacted, and I don't know if this was clear, you were contacted by Lieutenant Willis.
Yes.
He contacted you on December 2nd of 2021 and asked you to locate James and Jennifer Crumbley.
Yes.
Now, did you learn as part of your involvement or as part of getting that initial information that there were some concerns? Well, let me go back. You're aware that after the Oxford High School shooting that people were scared. Is that fair? I'm talking people in general.
Possibly, I would assume.
Angry?
Sure.
Upset?
Sure.
It was very public what had happened on November 30th of 2021.
Yes.
The shooter's name became public shortly after the shooting.
Yes.
If you recall, and you may not know, but if you don't know, please say you don't know, that Mr. and Mrs. Crumbley's residence was made public.
That I don't.
Did you learn during your involvement in this case that there were some concerns over the safety of James and Jennifer Crumbley because they were the parents of the Oxford High School shooter?
I was never made aware of that.
So all you were made aware of was that James and Jennifer Crumbley needed to be located.
Yes.
And the first place you went was their residence.
Yes.
They weren't there.
Correct.
You eventually determined and learned that they had been at a hotel in Auburn Hills from November 30th to December 3rd, the morning of December 3rd.
I'm not sure if they were there that entire time, but that's where we ended up finding the vehicle, was at that hotel.
And did you also learn through your involvement that they registered at that hotel in Jennifer Crumbley's name?
I don't specifically remember whose name it was.
So you began looking for James and Jennifer Crumbley before they were formally charged?
Correct.
Now, I assume in your career you've been involved in what would be considered high-profile or media cases, is that correct?
Yes.
And oftentimes in those cases, is it standard practice for your department to take someone into custody before the actual charges are announced?
Depends on the crime and the circumstances surrounding it.
Your department often, and correct me if I'm wrong, but your department will often assume that a high-profile case or a serious offense that somebody might run.
It is a possibility. People do.
You had no information that James Crumbley had indicated that he was going to run away or flee or anything like that. Is that fair? On December 2nd of 2021.
That's fair.
You were aware that James and Jennifer Crumbley did not have their phones after November 30th of 2021 because they had been either given to or taken by law enforcement, but law enforcement had them in their possession.
Yes.
Did you also learn during your early involvement in this case, or at any point, that James and Jennifer Crumbley had obtained track phones or pay-as-you-go phones or things like that?
Yes.
And did you learn during your involvement in this case that those phones were obtained because James and Jennifer wanted to be able to contact family in the early days after the shooting?
I was not aware of the reason behind obtaining those phones.
Did you also learn during your involvement in this case that James and Jennifer Crumbley obtained additional phones in the same phone number of the phones that were given to law enforcement?
I did learn that, but I don't remember at what point in our investigation I learned
Said that charges were formally announced at approximately noon on December 3rd of 2021.
that. That's my understanding, yes.
You do not know whether or not James and Jennifer knew that those charges had been formally announced. Is that fair?
That's fair.
You said that you went to James and Jennifer's attorney's office and you talked to an attorney.
I did.
That was not me, correct?
It was not.
Some hours later, you were notified that that one of their vehicles was located in a business parking lot in Detroit.
Correct.
It was not a parking garage, is that fair?
Yes.
It was not underground parking.
No.
It was not indoor parking.
No.
It was in a gated parking lot. We can see the fence in the photo, correct?
Correct.
There weren't boxes or branches or anything covering their vehicle. Their vehicle was in the parking lot.
Correct.
And at some point during your involvement between December 2nd and December 3rd, were you also made aware that there were going to be some attempts to do an alternative to what we talked about earlier when it comes to turning somebody in, that Mr. Crumbley may be walking himself in to be arraigned on the warrant after he'd been made aware of it, if you recall those conversations?
I had conversations with an attorney, but I'm not sure what I can go in.
Yes, and I'm not asking you about the details of the conversation. Just if you had some knowledge that there was an indication that Mr. Crumbley was not running, but that he was in fact going to turn himself in. Again, without giving.
Yeah,
Judge, I object to this whole line of questioning. I think it's getting close to speculating what the purpose of what a hearsay conversation would be, and it could open the door to other things.
Well, yeah. Are you going to open the door to that?
I can move on, Judge. At no point during your involvement in this case were you told James Crumbley is absolutely avoiding these charges and will not be turning himself in. At no point were you told that.
There's the same question, same objection to the same question, just asked differently.
Well, and who is he being told that by?
It could be anybody, Your Honor. His involvement was requested by Lieutenant Willis. He had multiple police officers involved. There were multiple people involved in locating Mr. Crumbley. I'm just asking if he was ever given knowledge that was going to happen.
Just as a response, he's testified to what his job was. He was given an assignment, and he carried it out.
Well, I don't know. I guess you got to be careful what you wish for, right?
Thank you, Judge.
Yeah, you know.
You indicated that the building where Mr. Crumbley's vehicle was a quote-unquote 3-story industrial building, as I believe what you called it.
Yes.
That was Exhibit 307, which is on the screen. In that building, obviously from the outside, it looks kind of like a warehouse. Would you agree with that?
Sure.
But you learned during your involvement that there were multiple tenants in that building.
Yes, multiple suites.
Right.
Or rooms.
Businesses.
Yes.
People who were regularly in and out of that building.
That I can't answer to. It was very late and there was nobody in and out when we were there.
Okay. Did you learn during your involvement that there were people in and out during the day that day?
Not at the time I was there.
Okay. And you may not be the right witness to ask these questions of. I'm just trying to determine what exactly you knew about this building.
Yeah, at that point, at that hour of the night, there was nobody coming in and out, and we wouldn't have allowed anybody to come in or out anyway.
And you learned in going into the building that there was an option for interior parking. Did you learn that?
I don't recall there being any interior parking, like a parking garage, if that's what you mean.
Right. Like a way to pull a vehicle in through a garage and park it inside instead of out in the lot.
There was a loading dock, so I guess technically you could have pulled a car inside of there, but I did not see, it was not a designated indoor parking structure.
Right. So not like a parking garage or those underground parking like we were talking about earlier.
Correct.
Okay. Your testimony was that it was obvious and apparent what was going on outside of and in that building during your search of the building, correct?
Yes.
Now, you can't say, because you really have no idea what James Crumbley heard or saw that night, correct? On December 3rd of 2021, or the early morning hours of December 4th of 2021.
I can only tell you what I saw and heard, and the commotion, the law enforcement officers, the flashing lights from the police cars, but specifically as to what he saw and heard, I can't tell you.
Right. You have no knowledge of whether or not he saw or heard any of that. Is that fair?
Yeah.
You were not part of the arrest of James Crumbley after entry was made by DPD's SRT unit, correct?
Correct.
I have no further questions, Your Honor.
Adrian?
Thank you. Sir, who were you given this assignment by?
Lieutenant Wilkes.
Okay. And you were asked to locate James Crumbley on December the 2nd, not arrest him on December the 2nd. Is that correct?
Correct.
And that's not uncommon for an officer in charge to contact the fugitive apprehension team to locate a suspect, is it?
No, it's not uncommon at all.
Okay. And the goal as a member of the fugitive apprehension team is a peaceful surrender?
Yes.
Okay. Is that why you reached out to Mr. Crumbley's attorneys?
Absolutely.
Okay. And there were no arrangements made to you to turn the defendant in on Friday, December the 3rd, were there?
No.
Nothing.
All right, you can step down in your excuse.
Thank you.
Now, were you able to determine what area, what room or area of the school specifically the shooter left right before he began shooting?
Yes, it was the bathroom adjacent to room 258.
Okay, I'm going to show you what's been admitted as people 16. What are we looking at here?
This is the backpack and contents that the shooter was seen, observed wearing, walking into the bathroom prior to the shooting beginning.
Okay. Now, was this photograph taken after the location was made safe by the bomb squad?
That's correct.
Okay. And they didn't find any explosive devices?
They did not.
Okay. Now, what do you see in this picture? What was seized as evidence?
The most obvious thing is you see the book open, that is the shooter's journal.
Okay. Did you have the opportunity to review that journal?
I did. I have.
All right. Were you able to identify it as being written by the shooter?
Yes, sir.
How were you able to make that identification?
There's, first of all, his name's in it. That was the most glaring way to identify that it was his. His writing is unique, and it matched some homework and other writings that we saw. There's references to several incidents that occurred in the school within the month of November, things of that nature.
Okay, so you, from the content of the journal itself, you're able to put a time frame on when the journal was likely written?
Yes, sir.
And tell me about that.
The first date written would have been November 9th. But it did reference incidents that happened before that.
Okay, in the month of November?
In the month of November,
okay.
Yes.
As well as incidents that happened after that in the month of November?
Yes, sir.
Okay. How many pages of writing are contained in that journal?
22.
Okay. So is it filled with writing from front to back, or is it at different parts, or how is it organized?
No, it actually appears to be written from back to front, and it stops about a quarter way through.
Okay. Now, of the 22 pages, is there, I guess, a title page or something to signify the end of the journal, end of the writing?
There's, yes. I mean,
okay.
To answer your question, simply yes.
So out of the pages with writing in that journal, how many contain reference to the school shooting?
All 22.
Now, for the record, I'm going to show you some of these slides, or some of these passages rather from the journal, and I'm going to refer to them by page number, and just so you're clear, sir, they're indicated page 1 from where the writing starts to page 22, which would be the back binding of that journal. Is that accurate?
Understood, yes.
Okay. Now, is the journal in written format or were drawings contained as well?
Both.
Okay. Were there any passages in this journal that you noted indicative of the shooter's request for mental health help?
Yes.
This is People's 359. Can you read what's written in this passage, please?
Yes. I have zero help, and help is bolded, for my mental problems, and it's causing me to shoot up the fucking school.
This is page 5. For the record, that was page 6 on the journal. Same exhibit, page 5. Could you read that, please?
Yes. I want help, but my parents don't listen to me, so I can't get any help.
Okay. That's page 5. This is page 19. What does this say?
My parents won't listen to me about help or a therapist.
All right. Now, were there any journal entries about the shooter's desire to obtain a 9mm handgun?
Yes, sir.
Same exhibit, page 3. Can you tell us what this is, please?
Yes. The shooter writes, so we should be bound to get my SD 9VE soon.
Okay. Now, that specific term, SD9VE, did you see that anywhere else in this case?
Yes, I did.
This is People's 85 and 86. What do we see here?
This is a picture of a Smith & Wesson model number SD9VE that was for sale, that was extracted from the defendant's phone.
Okay. And Mr. Rogowski testified this was from Monday, November the 8th, sent from the defendant's son to the defendant in a message that was deleted. You were here for that testimony?
Yes, I was.
Now back to the journal. This is page 22. Can you please read us what this says?
Yes. The shooter writes, I want to shoot up the fucking school so badly. Soon I am going to buy a 9mm pistol.
Same exhibit, page 17. Go ahead.
All I need is my 9mm pistol, which I am currently begging my dad for.
And page 22.
This
is the binding, right?
The binding,
Okay,
correct.
go ahead.
I will have to find where my dad hid my 9mm before I can shoot the school.
Okay. And page 15.
Unfortunately, my dad does not want me to get the 9mm gun, and we are having financial problems, RN for right now. And I don't have a job. So now I'm pissed because I want to do the shooting with a 9mm pistol as they are effective for killing. But RN right now, all I got is a puny 22 LR Keltec that I don't know where my dad hid it.
Okay, and we heard evidence in this case that James Crumbley obtained a 22 caliber Keltec pistol in June of 2021. Is that right?
That is right. Yep.
Were there journal entries regarding the shooter's plan?
Yes.
Okay. Here's page 3, same exhibit. Can you read this, please?
I'm about to shoot up the school and spend the rest of my life in prison.
Sir, did you find any journal entries regarding the shooter's access to the 9mm?
Yes, I did.
Same exhibit. This is also page 3. Go ahead.
Excuse me. First off, I got my gun. It's a SP 2022 6-hour 9mm. Second, the shooting is tomorrow. I have access to the gun and the ammo. I am fully committed to now. So yeah, I'm going to prison for life, and many people have about 1 day left to live.
Now, sir, we saw one of the journal entries that had the word help, all bold, that was across a couple of lines. Were there any other writings or passages in that bolded format?
Yes, there were, sir.
Were there pictures in the journal as well?
Yes, there were.
Okay, like what?
There's a picture of what appears to be an arm fully extended out with a gun pointed to the back of what appears to be a female's head.
Okay. And was that a little picture or a large picture in it?
It took up about that much of the page.
Okay, so to reference...
Oh, I'm sorry, about 3-4 inches of the page.
Now, was this journal a full-size book like this legal notepad, or was it small?
It was small.
I'm just going to mark this for a demonstrative exhibit. This will be 381. This is a demonstrative exhibit. Any first witness?
Any objections?
No, Your Honor, just for demonstrative purposes.
Sure. Put a pair of gloves and just take that off so you can see it. Can you just hold it up for the jury so they can see, please? And thank you, sir. And that's what's depicted here in People 16 that we're referring to?
That's correct.
Okay.
If this was laid open.
Yeah, first one.
Sure.
Would you mind putting that back in?
On December 4th, were you dispatched that day, if you know, to an address of 1111 Bellevue in Detroit?
Yes, I was.
Okay, do you know about what time you received that dispatch?
I believe around 2 o'clock.
In the morning?
Yes.
Okay. Were you aware if there was a search warrant that was being executed?
The request we got over radio was there was a search warrant executed at that location.
All right. And what were your initial thoughts when you were dispatched to the location about what your purpose there was?
All we knew at the time was it was a search warrant at the location. We really didn't know anything else about it previously until we pulled up.
All right. And when you pulled up, what was your observation?
Objection, Your Honor, relevance.
When he pulled up to the scene, overall,
Thank you.
A lot of news cameras around, so we were like, okay, this is interesting.
In addition to the news cameras, though, what was the scene like in terms of, was law enforcement already on scene? Did you know what had happened in that scene?
At that time, we didn't still exactly have any of the real details. All we knew at the time was it was a search warrant, and we were there to collect evidence regarding the search warrant. When we pulled up, there was, of course, like we mentioned before, news cameras all around and heavy police presence.
All right, and then what happened?
Then when we reached the scene, we talked to the officer in charge, and then that's when we were notified what this case was actually involved with.
And what were you told?
That the case was involving the crime.
Can you just raise your voice just a little bit, please?
Oh, I'm sorry.
That's okay.
I was trying to.
I knew you could speak louder.
No problem. Case was involving the shooting incident, and this was the location that search warrant was being authorized, and 2 people were arrested.
Is that all you were told?
Yes.
Okay. And were you directed to a certain part of the building?
Suite 130 of the location you mentioned.
Were you by yourself or with someone else?
I had a partner.
And who's that?
My partner is Stephanie Sparks.
Do you normally process the scene by yourself or with another partner?
Midnight, you process scenes with partners.
Okay. And once you arrived at the suite, were you and your partner the only one there? Were you the only ones there, or who else was there?
The scene was secured by the police, by the church police.
What does that mean, secured?
Means that it's secured so that way there's no outside interference coming inside the building, no one tampering with evidence, and everything is there as it was when the search warrant was executed.
And is that a typical thing and that you encounter in your job? That do you arrive to scenes once it's cleared and secured, or are you sometimes there at the same time? A lot's going on.
Oh no, we're there after the scene is secured.
Okay. So, what is your job when you arrive on the scene that day?
When I arrive at the scene, we talk to the officer in charge of the scene. We then walk through the scene. He points out items of interest.
Remember, keep your voice up.
I'm sorry.
That's okay.
He points out items of interest that he might want collected. My partner and I would then walk through the scene. We'll also pay attention to see what's around. We then would suggest additional items if any to collect, and allow us to look around a little bit more. And then after that, we take pictures, collect evidence, and package the evidence, turn it in.
All right, Mr. Kerr, is there a difference between collecting evidence and searching?
Yes.
And are you assigned to do both?
It depends on the situation. Yeah, in this situation, we collected the evidence. The search warrant was already executed, and we looked around additionally.
All right, and what makes you start searching other places?
The fact that we looked around and we said, yeah, the OIC, I can't remember the name at the time, gave us permission to look around a little bit more.
Okay. I'm going to show you what's been marked as People's Exhibits 306, 307, 309 through 320, 322 to 358. I believe these have all been admitted. Mr. Pierre, what is that?
That's the scene location.
All right. And
again, it's the north side of the scene location.
Okay.
Again, we're at the north side of the scene location.
All right. Can you see the windows on the suite that you searched?
I believe the windows on the scene that we searched, because the actual suite 130 is located on the northeast side of the building. So I would say the 2 windows closest to the left side of the screen.
Okay. And then, do you know what this is?
Yes, that was the vehicle we were directed to at the crime scene.
Oh, you also searched the vehicle?
No, we didn't search the vehicle.
Okay.
We took pictures of the vehicle.
Okay, got it. What did you learn about the car? Anything? Did you take pictures of anything around the car, in the car?
We took pictures around the car, and then also around the car there were cigarette butts we collected.
You collected the cigarette butts?
Yes, ma'am.
And what is this a picture of?
Those are pictures of the cigarette butts.
All right. Do you remember how many were there?
Not off the top of my head.
Okay. Did you bring a report with you today?
I did bring a report.
Would that refresh your recollection?
It would.
All right. Could you have a look at it and just let me know when you are ready to answer that question?
collected a total of 14 cigarette butts.
Okay. Anything else around the car? Is that a picture? What are we looking at?
The picture that's behind the vehicle and more cigarette butts.
And you collected those?
Yes.
Okay. All right, and 312 and then 313. What is that?
That's Suite 130.
Okay. Is that where you searched?
Yes.
All right. And is that typical? You just take pictures of. What do you take pictures of as a matter of protocol?
No problem. We take pictures of the area. In this particular situation, that's the actual room number. So of course we took pictures of the front door and room number. As we enter through, we'll take pictures of there to see if there's any damage to the door, if any, if the door was breached, if it wasn't breached, if there was any damage at all.
Was there any damage to this door?
No, none observed.
Okay. And the next slide is 314. Do you recognize that?
Yes, that's the actual scene inside of the same location, 130.
Okay. And then 315, is that also from a different angle?
Yes, as we enter the room, that would be to the north.
And those windows that we see, do you know where they faced?
They are also facing north.
Would those be the windows you just pointed out in the previous slide?
Yes, ma'am.
Okay. This is another angle?
Yes, ma'am.
Okay. And what is this?
This is directly in front of the door, so that would be to the east side of the building.
Did you observe a mattress in this building, in this room?
There was a mattress in the room.
Do you see it in this picture?
You kind of see it towards the bottom of the screen. Yeah, right there.
Okay. And the next slide?
To the bottom right-hand corner of the screen, you see the mattress with the drawers on top of it.
Oh, that's the mattress?
Yes, ma'am.
Okay. All right. And then I'm just going to show you some slides, pictures of the scene, and you can just describe what angle it is and what you, if you see anything of significance to point out to the jury.
Yeah.
Okay.
Again, you see the mattress. You see the drawers. You also see going just to the right of the mattress.
Remember to keep your voice up a little bit.
Sorry.
Mm-hmm.
To the right of the mattress towards the edge of the screen, you see a table with 2 solo cups.
Right there?
Yes.
Okay. What is this?
Again, we're right at the mattress. At the, I guess that would be the left side of the mattress, you have some clothes and a baseball cap.
Okay, and the next slide. What's significant about this, if anything?
You got the mattress in the bottom right hand of the picture. Towards the left hand of the picture, right in front of the little shelving units on the floor, you have a Snipes clothing bag.
All right. And at some point, did you remove the items in the bag?
Yes, ma'am.
Is this the picture of those items?
Yes, ma'am.
Can you tell the jury what you found?
You see in the picture a few pairs of socks, receipt, sweatshirt.
And are the socks, do they appear to be worn or new?
Those are brand new.
All right. Do I see a receipt in that picture?
Yes, you do.
Okay. We're going to get to that in just a second. The next slide. What are we looking at?
You're looking just, that's the mattress to our right, and to the left there's some shelving units, but right in the middle there's a sweater.
Okay. Just for context, when you say right or left, when you're looking at this picture, where's the door?
Got you. The door would be to the west of the mattress.
So to the top right of the...
It'll be just to the, on the right side of the screen, towards the right border of the screen.
Okay. And is that the article of clothing we just saw in the previous
Yes, ma'am.
slide? Okay, what is it?
It's a sweater, as I mentioned before.
All right, do you know if it's male or female?
Looks like a female sweater.
Okay, and the next slide. Where did this come from?
Right now, if I remember correctly, this is going to be towards the east side of the room, and that's just a regular shirt, and you see further on a few pairs of other articles of clothing.
Okay. The next slide is, where is this in relation to the room?
In relation to the room, as you see through the previous slides, there was a table. The table would be along the south
Is the
side.
table right next to the mattress with the solo cups?
Yes, ma'am.
Okay.
This area is behind the table, and that's a pink book bag. This was in a plastic tote container.
Was the tote, did it have a lid on it, or was it without a lid?
It was without a lid when we arrived.
With or without?
Without.
Okay. Do you know, did anybody take the lid off, or was it found like that when the individuals were arrested?
Objection, Your Honor. Speculation. I don't know how he would know that.
I started out with, do you know?
No,
Do you know?
I don't recall.
Okay, thank you. And was there anything else in this container other than the backpack?
I'd have to go further through the pictures.
Okay. What is this?
That's the table that is right in front of the tote with the book bag.
Okay, and can you tell the jury what was on this table?
You have foodstuffs like bananas, orange juice, a Ferner's bottle, a Coca-Cola bottle, Solo cups.
All right. And the next slide?
Next side, we're right back at the tote with the book bag.
All right. And what's this?
This is the part where we're getting ready to go through the tote, through the book bag that we just pulled out of the tote.
And what do you see? I'm sorry. What did you find in the backpack?
Okay, to the left of the book bag, towards the top of the screen, you have a smaller little bag, and you also, as we're going to go progress through the pictures, you're going to see various articles of clothing.
Okay. Next slide.
Again, we're going through, progressing through the pictures. You have various articles of clothing, and we still have that little smaller bag right there on top of the book bag.
Was there anything in that bag?
I have to look at my report to refresh my memory.
Okay, go ahead.
Don't believe that's the great purse. Could we progress through the pictures?
Sure, sure. What's to the left on there?
To the left, you have a pair of black jeans.
Do you know if they're male or female?
I believe they're female.
All right. And the next slide is 332. What is that a picture of?
Another picture. It's another picture of the black jeans.
Okay. And the slide after that?
You see the brand of the jeans. You see their high-rise skinny stretch jeans, and you can see the size on the tag if you zoom in.
All right.
That's size 12.
Okay. And the next slide? Where were these articles found?
Those articles were inside the pink book bag.
Okay. And can you tell the jury what is in that picture?
And inside the picture, you have you see a syringe. I'd have to go through my notes to recall what was actually inside the syringe. You also have some pills just at the bottom of the screen, and then on the inside the bag, you also see a bank envelope.
A what?
A bank envelope.
A bank envelope. Okay. Do you know what the pills were for, or what they were?
Not off the top of my head, no.
Is it in your report?
Let me look at my report.
Okay. Yes. And while you're doing that, would it refresh your recollection about the syringe?
Yes, because
Okay.
I recall that it's definitely in my report.
Okay.
Okay, the syringe was the Exceed. It's the prescription for medication for a horse.
Okay.
That's the syringe that you see in the picture inside the bag. And I don't have a description of the pills.
Okay. In the next slide, do you see a better description of the back of the pills there?
Yes.
Does that refresh your recollection?
Yes, I believe they're like caffeine pills or something like that.
Vivarin?
Yes.
All right. In the next slide, that's what you just talked about.
Yes, ma'am.
Okay. All right. And what is this?
Those are articles of clothing I described earlier.
And can you list those?
They are female intimate garments, underwear and bras.
And do you know how many pair of underwear?
Now I'm talking about
Okay. In the next slide, what is that?
that is the hotel room key. It was inside a black jacket, and that was along the northeast corner of the room.
Okay. And the next slide is 339. What is this?
It's a picture of a whiskey container. It's in a garbage can.
All right. And the next slide is a receipt. What is this receipt for?
It's from the Rivertown Market. We found the receipt on the table. As you see on the, as we go through the pictures, you have the various items that are on the receipt. I believe the next picture also has the date on the receipt as well.
What is this?
That is going to be a plastic tote with an avocado inside the tote.
Okay. And I remember the last time you testified, you weren't sure what that was.
Exactly.
You've since learned it was an avocado.
Yes, ma'am.
Okay. What else is in that picture with the avocado?
It's a aluminum container, similar to what you would use for, like, maybe
Lasagna?
Lasagna.
Okay. And what's inside of it?
Melting ice in an ice bag.
So was it completely melted or was it still cold?
At the time, it was completely melted. Yeah, at the time, it was completely melted.
Was it still cold?
No.
Okay. The next slide. What is this?
It's a receipt.
Is it the receipt that we just talked about at Rivertown?
I would have to look at the picture before, because you see at the top of the receipt it has 14, and on a previous picture. Yes, that's the bottom of the receipt.
Okay. And what's the date on that?
The date on the receipt is 12/3/2021.
And at the time you are searching this, is it December 3rd or December 4th?
It will be December 4th.
Okay. And is the actual time of the purchase?
4:09 p.m.
Okay. The next slide is, what is it?
Yeah, this picture of the mattress we talked about earlier.
Okay. The next slide is 344. Tell the jury what this is and why you took a picture of it.
This is a picture of the totes that will be around the east side of the room. The reason why we took pictures of the totes is because we saw the one tote that was already open before. These totes look kind of funny, or kind of just look like they kind of was messed with or jostled with at the time. So we decided to take pictures of the open one.
Okay, and just so that the jury understands, I want to go back to slide 14. Do you have that number? It's to show where. Maybe this one. Starting. Okay, so do I have this right? There were 2 separate plastic totes that you discovered items in?
Yes.
Okay, and were they found in the same place?
No.
All right, you testified earlier that the tote with the pink backpack, where did you find that?
The tote with the pink backpack, if you go through the picture, you see the table just to the left side of the screen in that corner. That's where the one tote with pink book bag is located.
So how far away from the mattress?
It's the mattress, table, and the tote.
Okay, so a foot, 2 feet?
About a foot, yeah.
Okay.
About a foot, yes.
Okay, and then you said you searched and discovered more items in a different tote.
Yes.
And where was that?
Towards the top of the screen, you have the yellow scaffolding, whatever, holding the totes. Then behind that area, behind the table, right there, would be the next area of totes.
Okay, so is it on that scaffolding you found it?
Right behind it.
Right
behind the table.
Right behind there?
Yes, ma'am.
Okay. So was that visible when you walked into the room?
No, as you walk into the room, you look around, you know, during the search of the area.
Okay. So that tote that was found on the other side of the room, what was discovered, if anything, in that tote?
In that tote, that's where we found the purse with the money, as we go through.
Okay. One moment. Okay. Was the tote found in that condition? And I guess what I'm asking is, was there a lid on it?
You see the lid on it. As we take pictures, you see it as we present, as we progress.
Okay. Next slide. What is that?
Again, you see the tote being moved over a little bit, and you see the purse.
Okay. What is this?
Yes, now we're looking inside the purse.
All right. And then the pictures, is this how you do it? You take a picture of the first item and then all of the things that you take out of it?
Yes, ma'am, we take a progression.
Okay. Sorry, you told me that. All right, next slide. What is this?
You see the bank envelopes, you see a search warrant under the bank envelopes, and you see the 2 bank envelopes as well top of it.
A search warrant, what is that?
As you see at the top of the screen is the warrant tabulation return.
Okay. And that was found in the bag or in the tote?
The bank envelopes were found in the purse. The search warrants were just on the table.
Okay. And then the next slide, what is that?
You're again looking inside the purse, and you see cash right in a smaller pocket of the purse.
Was there anything in the bank envelopes?
Yes, there's money in the bank envelopes as well.
All right. And you see cash in this picture. Is this separate in addition to what you found in the bank envelopes?
Yes, ma'am.
Okay. And if you remember, and if not, you can look at your notes. How much total? What was the total amount of cash found in that handbag?
I'd have to look at notes. I know it was around $6,000.
Do you want to just correct?
Yes,
Make sure you're correct.
$6,617.
Okay. And those are, we'll get to it. I'm not going to do that again. Okay, next slide. That's just a close-up?
Yes, ma'am.
All right. The slide after this. This is exhibit 350, and there's kind of a lot going on in this picture. Can you explain to the jury what you see?
No problem. In the picture, you see 4 cell phones. One of the cell phones appears to be busted and broken. Those are the condition of the cell phones. Those are the condition when collecting the cell phones. You also see the keys just to the left of the cell phones. They were collected. They were turned over to the unit at the scene so they can collect and move the card. You also see a bank card and some prescription medication just to the top of the bank, just to the top and left of the bank card.
Okay, the next slide.
That's a close-up picture of the keys.
And the bank card, is that a traditional bank card if you know?
No, I don't know.
Okay. The next slide.
You have a close-up picture of the medication I mentioned before.
And do you know what these medications were?
No. I see Adderall and 2 other containers.
Okay, and do you know who they're prescribed to?
You see Jennifer Crumbley on all 3. Well, you can see it better on the bottle to the right. In the other 2 bottles, you can kind of see Jennifer and Crumbley.
All right, and the next picture?
Again, it's a picture of the 4 cell phones.
Were any of these cell phones powered on?
No.
How do you know that?
Because if they were powered, we take pictures of the items in the condition that we collected.
They were all off.
Exactly.
And then the next picture? What is this?
It's pictures of the money we collected from the purse.
So you actually lay out each bill?
Yes.
Okay. And the next photo?
More pictures of the money.
And the 2 after that?
Yep.
All right, and then the last photo here is a receipt. Can you tell the jury what the time and date is on this receipt?
12/3/2021.
And what are the items listed?
Giant lasagna pan, Werner's 2-liter bottle, paper towel, Kleenex.
Okay, thank you. At what time do you estimate that the search was completed?
I have to look at my notes, definitely get that time.
Okay. For the sake of time, does it around 5 a.m. sound
Yeah,
right
around
to you?
5 a.m.
Okay, and then when you were done, what did you do?
We were directed to take pictures of the prisoners.
And is that a normal thing in your job?
If we were directed to, yes.
Okay, so where were these individuals located?
Oakland County Jail.
So did you drive straight to the jail?
When we were directed to, yes.
Okay. As soon as you finished the search?
Yes.
And the preparation? Okay. And when you arrived at the Oakland County Jail, what did you do?
We took pictures of both the Crumbleys individually. First, we took pictures of Miss Crumbley first, and then Mr. Crumbley.
Okay. And what's the purpose of that?
The purpose of it was the fact that show any injuries if there are any, and the condition when they were arrested.
Okay, thank you very much. Nothing further.
Sorry, I didn't hear the end of your response.
Are there any injuries or their condition when they were arrested?
Thank you.
Cross?
Yes, Your Honor. Briefly. Good afternoon.
Good afternoon.
As a forensic technician, your role is to document what you see.
Your Honor, calling People v. James Crumbley, case number 22-279-989-FE.
Thank you, Mark Keese, on behalf of the people.
Karen McDonald on behalf of the people.
Good afternoon, Your Honor. Marielle Lehman on behalf of James Crumbley, who is standing to my left.
Good afternoon, Mr. Crumbley. Can you hear us?
Yes, I can. Thank you, Your Honor.
All right. Are you ready for the jury?
Yes.
We are, Your Honor.
All right, I will bring them in.
All rise for the jury.
Good afternoon. You may be seated. Ladies and gentlemen, the witness testimony and the evidence portion of this trial have been completed. We will now hear the closing arguments. Much like the opening statements, these are not evidence. They're only how each side sees the case. Because the prosecutor has the burden of proof, they also have a right to rebuttal. You also will have a copy of the jury instructions at the end of the trial and when you're deliberating. Right? Prosecutor?
Good afternoon. On November 30th of 2021, around 1 o'clock in the afternoon, Lieutenant Tim Willis doesn't remember exactly what happened immediately upon being informed that there's a possible shooter at the Oxford High School. Doesn't really remember who he called or how he got down in the elevator, but he remembers one thing. Whoever he called, the first thing the caller said was, "It's real." Doesn't really remember the details on how he got there that day. But he did tell you that of all the first responder scenes he's ever experienced in his 20 plus years of being in law enforcement, this was the largest and most serious by far, and the second, what didn't even come close. Ed Wagrowski, who is now works for the Secret Service but was worked for the Sheriff's Office in the Computer Crimes Department, told you that he went so fast that he could barely keep his tires on the road. He told you that he will never forget the look on those kids' faces because they looked like zombies. He also told you that in that moment of crisis, he will never forget the looks on the parents' faces who were waiting desperately for their kid to get off those buses. Molly Darnell, a seasoned teacher who had years and years of training on what to do in an active shooter situation, she told you that even though she locked eyes with James Crumbley's son when he fired his SIG 9mm at her and hit her, she still couldn't believe she was shot. She told you that she didn't even put it together when she felt the warmth and burning on her arm. She didn't even trust herself to recognize a voice she'd known for over 20 years outside the door. And you heard from Chrissy Gibson Marshall, an assistant principal who had had hours and hours of training on what to do in an active shooting situation. And what did she do? She ran towards the shooter. She ran towards the shooter. All the training, all the preparation, and she did the opposite of what she was trained to do and what she tells everybody else to do. Because she couldn't believe it. And even when she saw James Crumbley's son with that gun, she still couldn't believe it. But she wasn't going to leave because Tate needed her help. All four of these individuals trained for years and years and years. Law enforcement, what to do in an active shooting situation. Yet, all four of them, as experienced and trained as they were, had no idea how to accept the reality that this was happening. Which is why Lieutenant Willis remembers it's real. Ladies and gentlemen, those four people, they were adults. Those four trained, experienced people were adults. These four were children. And so were the hundreds of kids in that school. What happened that day is about the deaths of these four children and what James Crumbley did and what he didn't do. The shooter has been sentenced and prosecuted and convicted. He pulled the trigger. James Crumbley is not on trial for what his son did. James Crumbley is on trial for what he did and what he didn't do. James Crumbley had a willful disregard of a known danger and it caused the death of 4 students in Oxford High School on November 30th, 2021. Hannah, Madison, Tate, and Justin. I'm going to spend a few minutes on the law, but the judge is the authority on what the law is, and she's going to instruct you what the law is. He's charged with 2 counts of involuntary manslaughter under 2 alternative theories. You don't have to find both. You don't have to agree on both. You can agree on both, but either one is the only thing you're necessary to return a verdict of guilty. The first is that there was gross negligence in the performance of a lawful act, and that the defendant caused death, and in doing the act that caused death, he acted in gross negligence. And then the second is his failure to perform a legal duty, and that he knew about the facts that gave rise to the duty, and he willfully neglected or refused to perform that duty, and he failed to perform it, and it grossly negligent to human life. And that the death of the victims were directly caused by defendant's failure to perform this duty. 4 counts of involuntary manslaughter for children who were killed. There can be more than one cause of death. James Crumbley doesn't get a pass because somebody else also caused the death of these 4 kids. And the judge will instruct you on that. It's not enough that he just made it possible for the deaths of Madison, Tate, Hannah, and Justin. You must find beyond a reasonable doubt that the deaths were the natural or necessary result of his acts or failure to act. You heard the evidence about how each of those kids were killed. And as previously noted, there can be more than one cause of death. In order to find that the death of Madison, Tate, Hannah, and Justin was caused by the defendant, you must also find beyond a reasonable doubt that his son's act of shooting someone was reasonably foreseeable. Not that he knew his son was going to kill 4 people. That is not what I have to prove. just that it was reasonably foreseeable. What's gross negligence? It's more than carelessness. It's willfully disregarding the results to others that might follow from an act or failure to act. And in order to find that, you have to find that the defendant was grossly negligent, and you must find each of the following three things beyond a reasonable doubt. First, that he knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring someone else. Second, that he could have avoided injuring another by using ordinary care. And third, that the defendant failed to use ordinary care to prevent injuring another one to a reasonable person. A reasonable person. And it must be apparent that the result was likely to be serious injury. In Michigan, a parent has a legal duty to exercise reasonable care to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates unreasonable risk of harm to others if the parent knows that they have the ability to control their minor child and knows of the necessity and opportunity for exercising such control. Even before we had safe storage, there was always a legal duty that existed. That newly passed law has no bearing on your legal duty that, as a parent, that you've always had. I said this before, there are two theories, two different ways to prove the same crime. If proven, one of these, both of them, are sufficient to establish the crime of involuntary manslaughter. And again, it's not necessary that you all agree on which theory has been proven, as long as you agree that the prosecutors proved at least one of those theories beyond a reasonable doubt. I want to stop before I talk about the evidence briefly. I want to note that everyone appreciates how much care and patience you've taken in listening. It's clear and it's obvious, and I thank you for doing that. There are people, though, who think that the prosecutor's job is just to convict people. And that's just not true. It's our job to present you with the facts and tell the truth and to be advocates, and telling the truth sometimes involves showing you things no one wants to see. Sometimes our job requires to produce evidence and testimony and pictures and images that we don't want to show you and no one wants to see them. But that's our job. That's my job. And it's not our job to sanitize, even though that would be easier. It's my job, and it's Mr. Keith's job, to present all the evidence to you and explain why we think the defendant is guilty beyond a reasonable doubt. Mark Keith told you when this trial started that any number of tragically small efforts could have saved the lives of 4 kids. That it was foreseeable and it was preventable. And the evidence presented in the last 5 days has proven that, ladies and gentlemen. James Crumbley was presented with the easiest, most glaring opportunities to prevent the deaths of these 4 students. And he did nothing. He did nothing. He did nothing over and over and over again. And the evidence shows that. This case is not about holding James Crumbley responsible for what his son did. Again, if he knew exactly what his son was going to do, he'd be charged with murder. It's about his legal duty and his failure to perform it, or to perform it in a negligent way. You heard the testimony of Molly Darnell. She told you that the first thing she saw when she looked through the window and saw the gun being raised towards her was that there was no orange tip, which she had learned previously, she doesn't remember where, meant it's a real gun. that he aimed the gun at chest level and he locked eyes with her, and the bullet landed 6 inches from her heart. Ed Wagrowski, who was a member of the Computer Crimes Unit in the Oakland County Sheriff's Office. He told you about what forensic evaluation of cell phone analysis is. He was qualified as an expert. He described his involvement and observations at the school that day. And he told you that he doesn't really respond to incidents like this. He was in computer crimes. No one comes into the office and says you have to respond to a critical incident, except that day. And you could tell that that had a great emotional impact on him. He watched hours and hours and hours of videos and images of that school that day to put together the evidence that we were able to present to you today and through the past 5 days. He reviewed all of it and he described and then showed you the path and the camera angles of the shooter's path through the school that day. He also presented the messages between Jennifer and James Crumbley and the messages between their son and his friend. He told you that there were over 20,000 text messages between the shooter and that one friend he had. He also told you in 1 year there were only 65 text messages sent between James Crumbley and his father. James Crumbley, who had either worked at home, was in between jobs, or had DoorDash. James Crumbley, who was the person he dropped his son at school every single morning. He told you that the image of the gun that the shooter shared with his dad was deleted. We played the voicemail from the school on November 29th from Pam Fine, talking about his son searching bullets. He presented evidence that he was aware of that because Jennifer told him about it. She texted, "Did he tell you about what happened at school?" James responded, "Yes." He shared with you the defendant's communications on November 30th of 2021. And important to note, he was able to show you exactly the path that he took. Because of the cell phone data, some of you were probably surprised and a little concerned about how much somebody can actually know what you're doing, but it's a lot. And we know exactly where he was, what he did, who he talked to, and so we could trace his steps, which turns out to be some of the most critical evidence in this trial. He showed you through the DoorDash search warrant returns the locations of what James Crumbley was doing from the moment he left the school that morning until the moment he called 911. And only after he learned that there was an active shooter at the school did James Crumbley go home and look for the gun. Even though from 11 o'clock to 1 o'clock he had 4 DoorDash pickups and passed his house many times. He was within minutes, many times. And you heard the 911 call by James Crumbley about 14 minutes after he arrived home and discovered that the gun was missing. Bob could tell us, he testified, and we showed you images of the hallway in that school when he processed the scene. And you saw pictures of that. And he told you that a total of 50 fired and unfired cartridges were recovered. And that the shooter fired 32 rounds and 18 were unfired. And we know where he got those 50. You saw that. It's when he pointed them out across the counter when he's with his mom standing a little bit behind her and said, 2. And you also know that James Crumbley knew that. Because when he was at the substation and they asked about where this gun was, who owns the gun, where's the ammo, he described it as he bought 2 boxes, referring to his son. Bob Catellis told you that those are rods placed in where bullet holes have penetrated that glass. And as you can see, and you saw other images, this was somebody who knew how to use a firearm. And Special Agent Brandon told you that's immediately what he observed. Those are shots, if landing on a human being, would kill them. Cammie Batt explained in detail what her requirement is and what she did that day, and that she knew James Crumbley because in June he came in and he bought 2 more guns, one for himself, which the evidence showed, because he told Jennifer how much did your gun cost? It was $300. And then there was another gun, which was his son's, a Derringer, and you saw the Derringer. She told you that she also sold him the 9mm on the 26th, that his son was present with him. He stated he's had his eye on that gun. She told you that they sell a locking mechanism with each gun they sell, that he was provided the trigger lock statement, and that there was a cable lock with the Sig Sauer when he bought it, and it was provided to him, and the ATF pamphlet solely in existence to just warn people, once again, the dangers of firearms with minors. And she told you that regardless of what kind of mechanism they provide, they always try to provide a tool with anyone who purchases a firearm to make it safe. Sergeant Joe Bryan testified and introduced the video, the recorded statements of James in the substation. James' statements indicate he knew that his son had only one friend and that he left abruptly. He referred to the math worksheet that morning as some doodling on a paper. But that was after the shooting. Before the shooting, we know that he texted Jennifer Crumbley WTF when he saw it. Now he's downplaying it. It's just doodling. When asked how many rounds, he corrected Jennifer and indicated there were a box of 50 rounds that he bought his son. When asked where the gun was, James responded, it was hidden in an armoire, in the case, and the bullets were hidden in a completely different spot underneath some jeans. We're going to get to that. What James didn't say that day, no mention of any lock. No mention that the school wanted them to get their son help that day, and then when they couldn't, within 48 hours. And here's something you never hear him say. You hear him say the gun was hidden. You hear him say that there was some doodling on a paper, that he was a perfect kid. But here's what he never says. He never says, I don't know how he got it. Never said that. He never says, it was hidden. I have no idea. I can't imagine how he got a hold of this gun. Never mentions that. 4 kids just died. Your son's in custody because he committed a school shooting, and not once do you say, how did he get the gun? And you know why he didn't say it? He didn't say it because he already knew. He knew his son had access to the gun. Christy Gibson Marshall, as we just talked about, heard gunshots, saw kids running in a way that wasn't normal, went towards the shooting, identified and spoke to James Crumbley's son, and you saw that video, how she just stood there. Sean Hopkins. Sean Hopkins was a counselor. He testified that the shooter was looking up bullets the day before. He was aware of that. That morning he was told he was watching violent videos. And he told you that even in a 20-minute period of time, he was concerned enough to call parents and ask them to come to school right then. He told you that he said he needed help right away. He wanted them to get him some help right away. He told you that he was very concerned about the images, but his main concern was for the safety of the shooter. He told you he didn't want him to be left alone. And he said in that meeting, he never received relevant information from mom and dad. It was short. It was a very, very small period of time for a meeting that takes place when you have to come from your work. James was at the barn at the time. Go to your son's school. They were in and out of there in a very short period of time. He testified, they said that just couldn't happen today. They had to work. Now, you've heard the testimony. You know what James Crumbley was doing as employment during that time. And defense counsel and I agree. That is a worthy endeavor, being employed regardless of how you choose to do it. But what's important to note is that DoorDash is not something that you can create your own hours. You can work when you want. It's not compulsory. You can work on the weekends. You can work anytime. Nick Ejak is the Dean of Students, testified that he was also at the meeting and that James Crumbley seemed irritated. And that at the time they knew only a fraction of what was going on. No one told anybody at the school they just purchased him a gun. Neither one of them, James Crumbley didn't say, you know what, we had this fight before, they mentioned about the fight the night before about grades, but didn't really discuss it as a big deal. Didn't really discuss the gravity of what it was like for his son, who had one social connection to the outside world, and that person abruptly left with, and that his son found out because he just stopped texting him back. And that he was obviously so concerned and upset that he communicated that to his father because his father reached out to the friend's father. He didn't say that. He didn't say that the weapon wasn't secure. He didn't say that there had been signs that something wasn't right. Now, you may not like what the two people who were employed by the school and had contact with the Crumbleys that day did. You may not like it. I don't like all of it either. But my job isn't to present to you the evidence that just looks good for my case. My job is to present evidence to you, all of it, because this is about the truth. But he doesn't get a pass because you don't think the teachers did enough. He doesn't get a pass for that. And the blame shifting is only meant to send a message, I'm not accountable here at all. Even though I bought the weapon. Even though I didn't secure it. Even though I never got help from my son. Even though I could have taken him that day. Special Agent Brandon testified where he was when he heard about the shooting, what he did when he got to the school, how he traced the gun, how he found out who owned it. He watched the surveillance. He noticed a couple things that were really concerning to him. One, it was somebody that was proficient with a firearm. He did what's called a combat load, which is unusual. The way his stance was, the shot he took that killed Tate. This wasn't somebody that wasn't experienced with a firearm. And logically, he wanted to know where this person was taught how to handle that weapon, where that minor was taught, that 15-year-old. And he discovered that. He testified that the cable lock that was seen in pictures was sold with the SIG, and it was the cable lock that was seen in the photos. And then he testified that they found that cable lock shoved in another gun box in the kitchen in a cabinet behind a door. You also heard him tell you that the minute he looked at that drawing, he instantly noticed the gun. It wasn't just any old gun. It wasn't. And maybe you wouldn't have picked that up. But Special Agent Brandon did. And you know who else would have known? The person that purchased the gun, James Crumbley. Detective Stoyak talked to you about the search. You saw pictures of the search and the house. You saw where the gun box and the ammo box were when they searched the house. It was on their bed. You also saw a map and learned a pretty small house. Pretty small. You learned he had 2 bedrooms. And you learned that in that master bedroom, which was small, there was the bed, some nightstands, and 2 other pieces of furniture. A TV stand, where he found the 2 other weapons that were in a gun safe, a locking mechanism, with the code set to 000, which is the default. Detective Stoyak and told you what others did. He never, ever, ever said that SIG was locked. He said it was hidden. David Hendrick is in charge of the Fugitive apprehension team. You learned what that is from 2 law enforcement officials. You learned that on the day the defendants were charged, they left a hotel in Auburn Hills, local, and drove all the way to Detroit in a building that is meant for businesses, not retail. People don't sleep there. And you heard what it was like when he arrived on the scene, when they were searching for James Crumbley and his wife. You heard through the body cam of the Detroit officer, and you heard from Officer Hendrick, and you heard from Luke Kirtley that it was extremely loud. There were dozens and dozens and dozens of law enforcement, and most of them SWAT. Luke Kirtley told you about how James Crumbley was discovered that night. And the only reason he knew it is because it was all over social media with the description, the license plate, and picture of James Crumbley and Jennifer Crumbley. Why? Because they were charged. And even before they were charged, there was a lot of speculation about them being charged. Luke told you about what that building looks like, what it's for, who's normally there at night, not many people, that he shares a wall with that studio that they were found in, that mattress they pulled in was out in the hallway. He again told you how loud, and that it would have been impossible if he was in his unit not to hear that. Officer David Metzke told you that there were tons of officers, multiple agencies, and that they took a 35-pound steel ram to bypass multiple doors, and they used it, and it was loud. I think he testified we have the bigger guys do that. We saw through his body-worn camera the arrest of James Crumbley, who was laying on the mattress and seemed to be wanting to create the impression that he was sleeping. There's a big problem with that. One, we know that shortly after Luke Kirtley went out to see the license plate, that he followed him shortly after, and he was awake. And shortly after that, dozens and dozens and dozens of law enforcement show up on the scene. It's a first floor unit. The windows face that parking lot. Lights and sirens, media were there, yet he's lying on a bed as if he's sleeping. William Creer told you what they discovered. They had bought and purchased, they had purchased items with them, socks, new socks. They had clothing, they had food, there was a whiskey bottle in the trash can, there was ice. But here's the thing that was the most compelling about his testimony. The bag with the 4 phones that were turned off and $6,000 of cash was stored on the other side of the room from the backpack in a lid in a plastic bin with a lid on it. That is strong circumstantial evidence, which is used in this country every day to convict people, that was placed there in hopes that no one was going to find it. $6,000 cash, 4 cell phones turned off, which is odd if you're really trying to get up in the morning and go somewhere, and the alarm was set on one of those phones, but they were off. But what did Ed Wagrowski tell you? He told you that you can't track a phone if it's off. You can't track it. We all learned, if you've learned nothing else, turn your phone off if you don't want to be tracked, because there's all sorts of ways. Lieutenant Willis testified. He showed you the bank records showing what they did when they found out that their son was charged and when there was talk of them being charged. He talked to you about the scene at Oxford High School. And it was a really detailed description of what it was like in that school that day. Because hundreds and hundreds of law enforcement officials went to that school, some miles away. No one asked them to. They just drove there from all different parts. And so it was Tim Willis's job to take all of those people who wanted to help and give them something to do and get the scene processed and start building a case. And answering questions, which is really what an investigation is about, way before you get to a prosecutor. Because sometimes you never get to the prosecutor. Your job is to go where the evidence leads you. And there were things about this case from the very beginning that just seemed like questions that needed to be answered. And one of them was, that gun was purchased 4 days earlier by James Crumbley, who was the same person who was at the school that day. This is information they're learning immediately. They do a search warrant for the house and for phones, and they find out a lot of information. You saw the video of the shooting. There's a reason we tell the media they have to turn their cameras off. We don't want those images out there. We don't want them to be on the internet. We don't want to encourage another school shooter. And we don't take any pleasure in showing it to you. But it's our job to know the truth and look at it and not look away. He told you how each of those kids died. Hannah was hit immediately after he left the bathroom. You saw the image and it was described to you. Madison Baldwin didn't run. She crouched down. There was a door 4 feet from her. And she put her hands over her head. And he walked right up to her and he shot her at close range in the head. Tate was shot. I talked about that shot he took as he was coming in the door. He had his headphones on. He didn't even know what was going on. And Justin Schilling was shot in the bathroom after several minutes of being in there. It wasn't immediately. Shooter went into the bathroom, stayed there. Justin knew the shooter was there. And there was another student in there as well. You saw him running, Keegan. And he ran after James Crumbley's son shot Justin Schilling, execution style. Defendant's son had access to and the use of this gun. It was preventable and it was foreseeable. You heard during jury selection, and you heard during opening, and if my prediction is you're going to hear it again, that this could be you. This could be any of us. This is what defense, this is their defense, that this could be you if you let your kid drive a car or leave with a sharp object. This couldn't be everybody. This couldn't be the person that takes their kid hunting. This couldn't be the person that buys a gun for their child to use, for their minor child, for their use. That doesn't create a criminal charge, ladies and gentlemen. It couldn't happen simply because you purchased a firearm or simply because you let your kid drive a car. Beware of the claim that this could be you. Beware. It is not the case that finding James Crumbley guilty of gross negligence would result in a criminal charge for every parent who doesn't know what their child is doing at all times. And it is not the case that he was faced with the same normal challenges as parents that we all go through and suddenly found himself in a courtroom being charged with involuntary manslaughter. It is just not the case, and the evidence shows it. In June, the Derringer and the Caltech were purchased by James Crumbley. We know that Caltech was left out, unsecured, with ammo. Why do we know that? You saw that picture and video and the one he sent to his friend, and you saw the text that accompanied. But before we get to that, this is an image from the video that you saw. It was 12:30 at night. That is his cat, Dexter. That is the shooter's cat. That magazine is loaded, and it was shoved on a table to load it, not a proper or safe way to handle a firearm. And there is a round in the chamber, and the safety is off because red means dead. And Special Agent Brandon told you that. Even if James Crumbley was standing next to his son, that would still be an extremely dangerous way to handle a firearm. But we do know what happened. Because he told his friend when he texted it to him. My dad left it out, so I thought, why not? This is precisely the reason there's a legal duty in the state of Michigan to prevent your kid from harming himself or somebody else. All I need is my 9mm pistol, which I currently am begging my dad for. This is from his journal. First off, I got my gun. It's a Sig Sauer 9mm. Second, the shooting is tomorrow. I have access to the gun and the ammo. I have access to the gun and the ammo. Then we have defendant's own statements. James Crumbley said it's a substation. James responded when it asked where the gun was. It was hidden in our armoire in the case, and the bullets were hidden in a completely different spot underneath some jeans. Here's what he doesn't say. Never claims it was locked, never says it was inaccessible to his son, and again, never says or expresses any surprise on how his son got a hold of it. We know he took him to the range. We showed you videos and images of that. In fact, 8 times we know that happened. We know that throughout June, July, August, September, October, by November, when he begged his dad for the 9mm, and he actually did buy it for him, Now he's at the point where he can instruct other people. It's James Crumbley's son that knows more about guns and when he takes his mom to the range. And how did he learn? James Crumbley taught him. He didn't take himself to the range with his dad. This is the shooter 2 days, 1 day after the gun was purchased for him. He's packing it up. What don't you see? The cable lock. It's not even in a case anymore. And there it is. That's the cable lock that was provided that day with the pamphlet and with the gun. Just the day before. It's already out of the case. Here's where the other 2 guns were found in that bedroom, in defendant's bedroom, in a safe. In the TV stand. The code was 000. The important thing is that the SIG could not fit into that gun safe. Could not fit it. It's impossible. But the other important thing is you're hearing a claim that James Crumbley didn't think that he had to lock his weapon up. Okay. It's not about whether you locked the weapon. It's about whether you made it secure. And we already know he felt the need and understood his duty to lock the other 2. Special Agent Brandon read to you the lines, if he had opened it up, if he had read it, if he had believed it, those deaths could have been prevented. If he had just read it and just did the simplest of things. This is the crime scene. There were 32 shots fired that day by James Crumbley's son. How do we know this was foreseeable? The shooter says in his journal, "I have zero help for my mental problems, and it's causing me to shoot up the fucking school." You heard a lot during jury selection and opening about kids exaggerate to their friends. This is his journal. He's not sending it to a friend. He's expressing his state, which was desperate because he needed help. I want help, but my parents don't listen to me, so I can't get any help. My parents won't listen to me about help or a therapist. I can't even say with a straight face or even find a way to explain the rationale behind a 15-year-old that desperate writing that in a journal because he was exaggerating or lying. We have the text between James Crumbley's son and his friend about exactly what he wrote about in the journal. He hears people talking to someone in the distance. I actually told my dad, asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to suck it up. Again, teenagers exaggerating to make themselves look better, to impress. None of these text messages to his friend make him look better. None of them make him look impressive. They just make him look desperate and sad and wanting help. I'm having bad insomnia and paranoia. I need help. I was thinking I could call 911 so I could go to the hospital. This was in April. But then my parents would be really pissed. I'm going to ask my parents to go to the doctors tomorrow or Tuesday again. But this time I'm going to tell them about the voices. And then on April 5th, like I am mentally and physically dying. What did James Crumbley know? He knew the family dog had died. A grandmother had just died. His son's only friend, the one person he had any social contact with, abruptly leaving. Can't even text him. Knew his son was completely isolated. Knew he had looked up bullets the day before. Knew he was upset the night before. Knew he had been watching videos that morning, violent videos. And then he sees that drawing. He sees that drawing that morning when he goes to the school, and what does it say? It says, "Help me." How many times does this kid have to say it? He says it in his journal. He says it to his friend. And what is he saying? I asked my parents. I asked my dad. And then if that isn't enough, he writes the words, "Help me," on a piece of paper. And his parents, James Crumbley, is called to the school to see it. And what does he say? He says, "We got to go to work." He describes his son as a perfect kid, never gets in trouble. Well, you know, if you have a perfect kid that never gets in trouble, being called to the school abruptly that day and asked to come and saying your kid needs help is about 100 out of 10 in terms of how troubling it is for a parent, if it's that unusual. He knows his son is proficient with guns because 4 days earlier he purchased that weapon for him. This is James Crumbley's son on the morning of the shooting, November 30th, being dropped off like every day by James Crumbley. And here's the worksheet. The thoughts won't stop. Help me. You have a picture of someone bleeding with bullet holes. You have a picture of the exact gun. It says blood everywhere. My life is useless. The world is dead. This is the worksheet James Crumbley looked at when it was texted to him. This is the worksheet he sat and looked at when he sat in that counselor's office. Those are the words he was reading when his wife said, "We can't do that today. We have to work." And he said nothing. And he leaves with a piece of paper with the names to call. This is what he was looking at. And there's the piece of paper. It took just one tragically small measure of ordinary care to avoid 4 deaths. James Crumbley failed to use ordinary care, which could have prevented the death of these 4 kids. Didn't stop at home to check to see where that gun was. Even though you can't take him, which we know he could have driven around with him. He could have not done any DoorDash round until Jennifer comes back from work. He could have gone to see where that gun was. We know that in his DoorDashing, he was minutes away from 11 o'clock to 1 o'clock. He didn't search or ask to see the backpack. Never thought then to say, "Hey, can I talk to you out in the hall?" Or, "Hey, where's that gun?" Didn't ask his son where that gun was. Didn't check the journal, despite acknowledging he had one. Didn't lock and secure ammunition. Didn't lock or secure the gun. Didn't take his son home. Didn't take him to get this care that a counselor's telling you he needs. Didn't say, "We bought him a gun 4 days ago as an early Christmas present." And didn't tell the school much relevant information at all. And Sean Hopkins told you that. He also didn't disclose any of the instances that you were shown throughout this trial. That there was a message in March about him doing something stupid. Jennifer Crumbley was concerned about it. James was always home. Is he home yet? Is he home yet? Is he home yet? Leave me alone, I have to work. He's fine, is what he says. The incident about giving him melatonin and him being worked up, didn't tell him that he'd asked him for help and asked to go to the doctor, told him to suck it up. Didn't say about the friend and how it was his only person he ever had any social contact with, that there were multiple guns in the home, that he was begging for a 9mm. James Crumbley never even shot that gun. He didn't fire it once. He had it, he purchased it on Friday. On Saturday, he was gone all day doing DoorDash. On Sunday, he was gone all day doing DoorDash. in that he wants you to believe he had this secure hiding spot. What, it was a hiding spot for one day? We know it wasn't there on Saturday. We have the shooter taking pictures of it. And we know the cable lock isn't around. And we know Jennifer leaves. He's alone with this gun. Didn't say that it was identical to the one in the drawing. Didn't say he bought 50 rounds to take home. Expensive rounds to use at a range. This is the DoorDash information from 11 o'clock to 1 o'clock and all of the times he passed that house. He was within minutes. We know that he was absolutely concerned about this worksheet until after the shooting in the substation where he says it was doodling. We also know that not once on any of his devices did we find any searches or information he was trying to get about firearm safety or how to make sure a minor doesn't get a hold of it, laws, any of it, until after the shooting. We know that at 10:37 he arrives at school. His son leaves at 10:52. They're gone by 10:53. At 11, he logs on to DoorDash. He completes 4 orders. He tells us in the 911 call and at the substation he saw cop cars. We know that 12:51 the shooting starts, and we start to see students and parents, we heard, arrive at the Meijer. They're being told by dispatch that's where their unification time is. James drops off his last order at 1:01. The email comes out from the school at 1:09. At 1:11, James is in the Meijer parking lot. It's unclear exactly why. He calls his wife for 57 seconds. That's the call lasts 57 seconds. He's on the phone with her for 10 minutes and 19 seconds. He gets home at 1:20. During that call, she texts her boss, the gun is gone, so are the bullets. So we know that by 1:23, both of them had knowledge about that. He calls her again, 1:30 to 1:33, another 3 minutes, and finally calls 911 at 1:34. There were 1,800 students in Oxford High School. There was one parent who suspected their son was the school shooter. And it was James Crumbley. You know what that's called? It's called foreseeability. That's what that's called.
What's the location of your emergency?
Okay, I'm not really sure. I'm at my house. There's an active shooter situation going on at the high school. My son goes to high school. I have a missing gun at my house. I need an officer to come to my house right away, please.
Okay, I'm not going to be able to send anybody to your house right now. So they're on the active shooter situation right now.
I understand that. There's a million cops there. I have a missing gun, and my son is at the school, and we had to go meet with the counselor this morning because of something that he wrote on a test paper, and then I was down, and I saw a whole bunch of cops going somewhere, and I made sure that I wanted to get to the hospital to see someone going to the high school, and then somebody told me that there was an active shooter, and then I raced home just to find out. And I think my son took the gun. I don't know if it's him. I don't know what's going on. I'm really freaking out. My son's name is Ethan Crumbley. C-R-U-M-B-L-E-Y.
E-W-Y. All right, sir, I'm going to put you on hold for just 1 second, okay? I have to talk to Cookman and see if I can do anything for you, okay? I'll put you on hold.
Thank you.
Okay, then.
You just heard this. I have a missing gun. My son is at the school, and we had to go meet with the counselor this morning because of something that he wrote on a test paper. And then I saw cops going somewhere. I wanted to go to the school, see what was going on. I heard about the active shooter, and I raced home just to find out. We don't have to discover or argue about whether or not he was put on notice that something was really, really wrong. He says it. He says it. He calls and he says, because of this meeting at the school, and because I have a gun, I went home to look for it when he heard about the shooting. So the question of whether or not that did concern him, it's not a question. We know it concerned him because he said it. And then at the substation, and this is what he says, and somebody said there was an active shooter, I immediately freaked out because the situation. And after I saw all the cops, after I found it was an active shooter that went on this morning, and after what went on this morning, what's he talking about? He's talking about the meeting and the words on the paper that says, help me, blood everywhere, with a picture of the gun he bought him. So I raced home and I found the gun missing. We went into detail about what James Crumbley and his wife did after they thought they might be charged with a crime. And the evidence clearly shows what they didn't do. They did not turn themselves in. They did not make sure that they were in the area. They withdrew $6,000 and they went to Detroit and turned the car around so the license plate is not facing, and didn't go out and buy that stuff themselves. They sent somebody else. And lastly, defendant conflicts his own statements. At the substation, the drawing was doodling. When he receives it from his wife, he's concerned, my God, WTF. He says at the substation, I immediately raced home and found the gun, and that's when I called you. I called you guys right away. It was 14 minutes after he got home. You think your kid has this gun, you know he does. You know he's really upset, you know the words he wrote, you suspect he's the shooter, and you wait 14 minutes to call 911? He doesn't know when the shooting started or when it ended. I think he owed something to the parents and the kids in that school to at least try, once he did figure out that the gun was gone, which any reasonable person would have known. But why lie and say you call right away? You called after a 10-minute conversation with your wife. At the substation, he's a perfect kid, doesn't get into trouble, yet he was looking up bullets, and yet they were called to the school, and the drawing, he doesn't say that, or what the drawing was really about. It's a downplaying situation, and then he says the gun was hidden. And again, never once, I don't know how he got it. Never once says that. James Crumbley had concerns that day. He knew something was wrong. He said it in his own words. And we know that because of what was on the drawing, and we know that because we know what his response was when he received the drawing. He kept those concerns private that morning. But he didn't just fail to inform the school. He failed to act. James Crumbley failed his son in a tragic way. You're not going to hear me say that's not true. But he didn't just fail his son. He failed Hannah. He failed Madison. He failed Tate. And he failed Justin. He failed to perform his legal duty to prevent these kids from being killed. And he failed their parents, too. And I ask that you find him guilty. Thank you.
Thank you, Prosecutor. Ms. Lehman?
Yes, Your Honor. There were a variety of emotions following the shooting on November 30th of 2021 at Oxford High School. Terror, anger, and devastation. There's an epidemic of mass shootings in our country. School shootings, in particular, have devastated our communities. There have been social and political groups formed to address these issues, but so far they've been unable to do so. However, on December 3rd of 2021, the parents of a school shooter were charged with involuntary manslaughter for the first time. When we started this trial, I said that the events of November 30th of 2021 undeniably changed people's lives in ways that most of us will never understand. We know that 4 children were killed, multiple families were devastated, and communities were terrorized. And ladies and gentlemen, James Crumbley and I do not dispute any of that. We heard from people who were at Oxford High School on November 30th of 2021. We not only heard what they had to say, we saw the impact that day had on them. Multiple people told you what that day was like. They told you what they felt, they told you what they saw, and they told you what they experienced. You were also shown videos of what happened inside of the school on November 30th of 2021. We can agree that you all heard a lot about what happened inside of Oxford High School on November 30th of 2021 through videos and testimony. This case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. This case is about what James Crumbley knew on and before November 30th of 2021. James Crumbley was charged on December 3rd, 2021 for the deaths of Hannah St. Juliana, Madison Baldwin, Tate Meir, and Justin Schilling. As you've seen throughout this trial, the charges and allegations against James were based on assumptions and hindsight about James and his knowledge about his son, who we've referred to as either his son or the shooter. The prosecution is asking you to second guess the decisions made by James Crumbley on November 30th of 2021 and before those days. And as Sean Hopkins told you, it's easy to look at things in hindsight. But we aren't here to look at things in hindsight. We are here to look at what James Crumbley knew prior to and on November 30th of 2021 before the shooting began. You heard no testimony and you saw no evidence that James had any knowledge that his son was a danger to anyone. You heard no testimony and saw no evidence that James Crumbley knew what his son was planning. You heard no testimony and saw no evidence that James Crumbley was aware that his son knew where the firearms in the home were hidden. You heard no testimony and saw no evidence that James Crumbley was aware that his son had obtained access to those firearms and had handled them unsupervised. Still, the prosecution wants you to find that James could foresee that his son was a danger to others, and that James acted in a grossly negligent manner or breached a duty that he owed to other people, despite having no information at the time. You obviously know that the defense has no duty to present a defense. We talked about that during jury selection. The judge will give you instructions on that and the law on that. But we did bring out more information so that you all had a more full picture, a more complete picture of what happened in the days leading up to November 30th of 2021 and even on November 30th of 2021. But in the end, if you have any questions, if there's anything that you're unsure of, if there's anything that you're wondering about, the prosecution was the only one that had a burden of proof. when it comes to burdens of proof in this country, beyond a reasonable doubt is a very, very high burden. In civil cases where people sue each other for money, the burden of proof is 50-50. Preponderance of the evidence, whether or not somebody gets money and somebody has to pay money. In cases where the state wants to take your child due to abuse and neglect, it's clear and convincing evidence. A little bit higher. Beyond a reasonable doubt is the highest burden in our country, the highest burden of proof as it relates to criminal prosecutions. Judge Matthews is going to instruct you that reasonable doubt is just that, a doubt based on reason and common sense. It can be based on the evidence, or it can be based on the lack of evidence. When it comes to reasonable doubts, you can have 1 or you can have 10. You don't have to have the same reasonable doubt as your neighbor. What matters is that if a juror has a reasonable doubt, then they must vote not guilty. You can believe that if the prosecution had evidence that James Crumbley knew that his son was a danger to others, you would have seen it. Especially if James knew what was inside of that journal. We've heard about the journal. If James knew what was in that journal, the prosecution would have told you that. If James knew that his son had gained access to his firearms, the prosecution would have told you that. You definitely would have seen it. And the fact that you have not seen any of that evidence can be your reasonable doubt. You can also believe that if the prosecution knew that James Crumbley knew that his son knew where the firearms were stored, the prosecution would have told you that. You would have heard about it, but you didn't, because James didn't know. He didn't know that his son knew where those firearms were. Absence of evidence that James knew that his son had learned where those firearms were can be your reasonable doubt. Also, if James had violated any laws as it relates to storage, specifically gun storage, you would have heard about that, but you didn't. In fact, you heard from ATF agent Brandon, who told you there are multiple ways to store a firearm. Multiple ways. You can use a safe. You can use a cable lock. You can use a trigger lock. You can store it unloaded with the ammo separately. You can store a firearm in any number of ways. That came from ATF agent Brandon. Those were his words. If the prosecution had evidence that James knew that his son was accessing firearms without his permission, not that his son was accessing them without his permission, that James knew that his son was accessing them without his permission, the prosecution would have shown you that. But you didn't see it because it isn't true. James didn't know. This can be your reasonable doubt. Mr. Wagrowski testified that James would have heard his son handling the firearm, the Kel-Tec that you saw the video of, where he sets the Kel-Tec on the table and loads the magazine. He slides the slide forward. He releases the slide forward. Mr. Wagrowski testified from this chair that James would have heard that because of the volume of the sound and because of the size of the home. You all have observed James throughout this trial. You've seen him. Judge Matthews instructed you at the beginning, James is wearing headphones. James is hard of hearing. He needs a hearing-assisted device to hear, even in this courtroom. And if you watched, there were points where he had to push the headphones into his ears so he could hear better because he still couldn't hear well enough.
Your Honor, I hate objecting in a closing, but that is not evidence, and her client didn't testify, and so it's just not evidence what he was doing, and it's just not. And his headphones are not evidence.
There's evidence that he needs a hearing device, as I explained to you in the beginning of the trial why he was wearing those headphones. Go ahead.
Thank you, Your Honor. Mr. Wagrowski also testified that he could not indicate and could not say with certainty where James was at the time that his son made that video. He knew that James was likely at the home. He didn't know if he was outside in the very large backyard that Detective Stoyak told you about. He didn't know if he was in the home. He didn't know if he was standing next to him. He didn't know if he was standing outside. He didn't know if he was in another room. He didn't know if he was sleeping. Mr. Wagrowski couldn't tell you what was going on other than James Crumbley's son handling that firearm. Was it unsupervised? We don't know. Was it supervised? We don't know. We don't know. So any statement by Mr. Wagrowski that James had to have heard that is an assumption. It's not based on fact, and it's not based on evidence. If the prosecution had evidence that James was concerned about his son's mental stability, or if his son had asked him for mental health treatment and it was denied by James, you would have seen that. Not a statement by his son to a friend or a writing in a journal, a statement by James that he acknowledges that his son was having issues, that his son was having a hard time, that his son needed help. None of you saw that. None of you saw that because it's not true. James had no idea that his son was having a hard time. Instead, you saw texts between James's son and his friend in April of 2021, where his son says he's going to tell his parents about the issues he's having. You also heard testimony from James's sister who said she saw him within a day or two, maybe 3 days, of those texts being sent to his friend in Florida after their mother passed away. James and his sister's mother passed away. She spent a week or a week and a half and saw them, saw James and his son, and saw no concerns. Not worried, didn't hear anything, didn't see anything, wasn't made aware of anything, no concerns. You heard that on November 30th of 2021, James drove his son to school. You saw the video of James dropping his son off. You heard that later when James went to the school with his wife to meet with his son and the school counselor, Sean Hopkins, and the dean of students, Nick Ejak, that James had told them, or that James had had a conversation, that he had talked to his son that morning, told his son he loved him. We just want you to do your schoolwork. We want you to do your best. There was never a conversation about, Dad, I'm having a really hard time. Dad, I really need some help. In fact, there were no concerns expressed whatsoever. James had no knowledge that there was an issue. You also heard Sean Hopkins and Nick Ejak both testify that in the office, sitting in the office, that James sat next to his son, right in front of Sean Hopkins' desk, sat next to him, went over the piece of the math assignment with him, the drawings, what was on there, that he was caring, that he told his son, you can talk to me. You can talk to other people. There was some reference to a journal. There was no indication that James knew what the journal looked like, whether or not his son was even writing in a journal, where it was, how often he used it. No indication at all, just that one may exist. And again, in that meeting, there were no comments, whether either before James got there or after he arrived, from James's son to the school counselor or the dean of students saying, I really want some help. I'm really having a hard time. I really need to see someone. I've been trying to talk to my parents and they haven't been listening to me and I need you to tell them. That didn't happen. Instead, Mr. Hopkins testified that he had concerns about the level of although appropriate, the level of sadness that James's son was experiencing. Sadness associated with the losses that he'd had that year. He lost his grandmother. He lost their Great Pyrenees dog. His friend moved away. He had a hard time with COVID. He struggled with virtual school. Mr. Hopkins was concerned about the sadness and wanted James's son to see someone to ensure that it didn't get any worse. Not that he had to see someone right now. It's an emergency. He has to see someone right now. That's not what was said. In fact, if you recall Mr. Hopkins' testimony, and I believe Mr. Ejak said the same thing, that James and his wife were told that the school was going to follow up with them within 48 hours. Now, in Mr. Hopkins' head, he testified he was thinking it was going to be the next morning, but he told them 48 hours. You heard Mr. Hopkins testify that James's son said he wanted to stay in school. In fact, he even asked for his homework while sitting in the office waiting for his parents. He asked for them to go get his homework. So they went and got his backpack. They brought it back. He started working on schoolwork. His attendance wasn't bad. There's some question about whether or not he missed one or more days of school that year, but his attendance wasn't bad. His grades weren't terrible. They were average, according to Sean Hopkins. There were no concerns, even by Sean Hopkins and Nick Ejak, beyond the sadness that they saw James's son was experiencing. The absence of evidence that James knew about the struggles that his son was having can be your reasonable doubt. You heard from James himself more than once. You heard him tell the police that there weren't any issues with his son. Within an hour of the shooting at Oxford High School, James was at the police station with his wife, interviewing with law enforcement, talking to them, saying, my son was a great kid. I think he used the word perfect. That his grades were mediocre, again, although Sean Hopkins said they were average. But that he'd never had any disciplinary issues. Sean Hopkins and Nick Ejak confirmed that. They had no disciplinary history with James's son. And even if you have a question about how great of a kid James thought his son was, Christy Gibson Marshall said the same thing to you. We'll talk a little bit more about that. But Christy Gibson Marshall also said that James's son was a good kid. Christy said that her testimony was that she was standing in the hallway. She had spotted the shooter coming down the hall with a firearm, with a gun in his hand. She saw that there was an injured student in the hallway. She walked up to the student, was standing next to it. You saw the video. She's standing next to the student who's injured on the floor. The shooter gets closer, and she realizes that it's James's son. And her first thought was that it couldn't be right. With a gun in his hand and an injured student in front of her, smelling cap gun, she didn't think that was right. Even in those moments. Going back to Sean Hopkins and Nick Ejak, two people who met with and talked to James's son on November 30th of 2021, at one point for over an hour without James and his wife there. They talked about a variety of topics. This was 2 hours before the shooting began. They said that based on the explanations that they were given about the drawings on the math assignment, that they weren't concerned. Kids draw violent things. Kids draw guns and bullets. That the confirmation combined with the confirmation from James and his wife about what was going on in their son's life, in combination with the explanations that they were given by James and his wife's son, that they weren't concerned. There was an explanation about interest in video game design. They looked a little bit about video game design. Sean Hopkins and Nick Ejak weren't concerned on November 30th of 2021, 2 hours before the shooting started. Both Sean Hopkins and Nick Ejak told you that guns are not uncommon in homes in Oxford. It's a hunting community. That it's not uncommon for students to handle guns in their homes or to go to the shooting range. That they knew that James's son had gone to the shooting range the weekend before with his mom and that he had access to a firearm. They didn't ask any more about this, about access to a firearm or having a firearm in the home, because they weren't concerned that James's son was a danger to anyone. They weren't concerned. Sean Hopkins and Nick Ejak testified that they had concerns related to the effects of the losses that James's son had experienced in that year. There was testimony that James's son's level of sadness was appropriate given various factors, but that it wasn't concerning. They just wanted to address it to ensure it didn't get any worse, because they'd seen sadness get worse and have issues with other students, according to Sean Hopkins' testimony. We talked about Sean Hopkins and what he said about wanting James's son to see someone within 48 hours. You also heard testimony from Sean Hopkins and Nick Ejak that they didn't believe that, or they believed that James and his wife were going to get their son help. That they had no reason to believe that they weren't going to. And if they did, they would have done things differently. If they had concerns that it had to happen right now, they would have done things differently. But they didn't. Sean Hopkins and Nick Ejak testified that they didn't ask if there were guns in the home. They didn't ask because they weren't concerned that James's son was a danger to anyone. Despite the information and the concerns that they had, they made decisions with the information that they had at the time and based on their education and training, which we can all probably agree a school counselor and a dean of students has more education and training than the average parent. And even with all of that and the experience with teenagers and what they had in front of him, they still didn't believe that there was a reason to be concerned that James's son was a danger to anyone. In fact, they didn't even feel that he was in immediate danger to himself, because if they had, they testified they would have done things differently. James worked. You heard the testimony. He left the school at approximately 10:57, and if you want, you can go back through the exhibits, and logged on to the app for DoorDash and started working within 3 minutes. The prosecution is focusing on James not going home in the time from leaving the school and when the shooting started. Why would he? He didn't know. He didn't know what was going on with his son. He didn't know what his son was planning. He didn't know that his son knew where the guns were. And he didn't know that his son had somehow obtained access to those guns. Or a gun. He didn't know. So why would he go home? There was no reason to. You heard about James's actions following learning of the school shooting, or following the school shooting. You heard that he went to the Meijer, which was the reunification point on Ray Road. You heard that he saw the police lights, he saw multiple police cars, he followed them. He actually tried to go to the high school first and he couldn't, so he went to the Meijer. And it was there that he learned that there was a shooting at the school, that there was an active shooter at the school. There's evidence and exhibits showing James's movements while at the Meijer. He was there for approximately 6 to 7 minutes. In that time, he texted his son. You can see that on exhibit 375. He called his son to see if his son was okay. He texted his son again. He called his wife. He talked to his wife for about a minute, and he left the school. Then he called his son 2 more times. 2 more times in less than a minute to find out if his son was okay. He talked to his wife again for about 10 minutes. You saw a text during that phone call from James's wife to one of her coworkers where she says that their son was the school shooter. Contrary to Detective Lieutenant Willis's testimony that James said his son was the school shooter, he didn't. James didn't say that. You heard the 911 call a few minutes ago. That's not what James said. James called 911 at 1:34 p.m. and said that his son was a student at Oxford High School, and that after he'd learned about the school shooting, that James had gone home, he found the gun and bullets missing. He didn't know if his son took it, that he didn't know if it was him. And if you recall, Nick Ejak and Sean Hopkins both testified that even during the shooting at the school, even after the meeting that morning with James's son and James and his wife, even in those moments, they did not suspect that James's son was the school shooter. Sean Hopkins testified that he didn't even think that it was James's son who was the school shooter until after he checked attendance, after the shooting had ended, and after James's son had been arrested. You heard James say on the 911 call that he was really freaking out. You've heard that a couple of times from James. And you can listen to that call yourself. It's Exhibit 154. You can almost hear, as James is talking to the dispatcher, how he's looking back at what had happened that morning and trying to piece things together and figure out what's going on. You heard from James 2 more times within hours of the shooting at Oxford High School, once at the substation and once while in the backseat of a patrol car. At the substation, James learned that his son was the school shooter, that he was not injured or anything, that he was in fact the school shooter. You heard James say he was freaking out. He asked for a water. His mouth was dry. He was freaking out. James was emotional. I believe that Detective Sergeant Bryan testified that James was sobbing, that he was crying. You can watch it. You can see how James was reacting in that interview. Detective Bryan said that James was forthcoming, that he was willing to speak with them, even after James's wife suggested, maybe we should get a lawyer. Maybe we should stop talking. James said, no. Let's keep talking. I want to keep talking. It's okay. We can keep talking. And he does. He told the police how many guns were in the home, where they were located, that the handgun that was used by James's son in the shooting was a 9mm Sig Sauer. He mispronounced it. We've all heard that. That it was hidden in an armoire. No one in that interview, neither of those 2 law enforcement officers in that interview said, well, you shouldn't have had it there. Was it locked? How did your son get it? You didn't hear those questions. You heard James tell the police that the handgun was stored unloaded and that the ammunition was stored somewhere else, that it was stored separately, under some jeans. Again, those 2 officers didn't say, well, you shouldn't have done that. That wasn't right. Well, you did that the wrong way. Well, that was really irresponsible of you, Mr. Crumbley. They didn't say any of that. The police didn't ask if the gun was locked or in a safe. James clearly told them that that 9mm was hidden. And the police moved on. James talked about what a great kid his son was, about his mediocre grades, but overall he didn't get in any trouble. You watched as James saw his son for the first time after that school shooting. It was a very brief encounter. And you saw as James was leaving that he repeatedly told his son he loved him. Ladies and gentlemen, you can watch that for yourself. It is Exhibit 301. He repeatedly told his son he loved him. And then after, as he walks back into the first interview room, you can hear him audibly crying, sobbing at what was going on. And what does he say? He asks the police if he can find out where his son is going to be. And they say, yes, the court will tell you. In that interview, you also heard James Crumbley say, I wish we had taken him home. In hindsight, looking back, I wish we had taken him home. James had no knowledge that his son had access to any of the firearm, any of the handguns in the home. You saw his son's own words sometime after November 27th of 2021 and before November 30th of 2021. And we know that because in Exhibit 359 on page 22, his son specifically writes 9mm. And we know that there was no 9mm in that home prior to November 26th of 2021. We know that James's son went to the shooting range on November 27th of 2021 with his mom. So we know that that had to have been written sometime between November 27th and November 30th of 2021. We talked quite a bit about this during jury selection. Most, if not all of you, agreed that there's a difference between having access and giving access. We talked about car examples. We talked about the responsibility in different scenarios, a parent's responsibility in different scenarios. This case is like the first car scenario, where the child takes the car without the parents knowing, takes it out and something happens. This is the first scenario. This isn't the second scenario, where the parents might have suspected that their child might do something. This wasn't the third scenario, where James knew his son was going to do something and just handed him whatever it was he was going to do it with and said, here, take it. This is the first scenario, where James Crumbley had no idea what his son was capable of. He had no idea what his son was planning, and he had absolutely no idea that his son had access to those firearms. Also, as an aside, if it really were his son's gun, why was it hidden in James's bedroom? If it really were, why was it hidden? Not only in the bedroom, but in a location that James's son was not aware of. Sometime before November 26th of 2021, James's son wrote this in that journal notebook that was found. Exhibit 359, page 15. We know that it was before November 26th of 2021 because of some of the other statements that are around that journal entry, which you can look at if you'd like, but they reference a 9mm and a .22 caliber. And we know that there was not a 9mm in the house before November 26th of 2021. And even here, I don't know where my dad hid it, is a reference to .22 Caltech. Even before November 26th of 2021, well before November 30th of 2021, James Crumbley's son didn't know where those firearms were. He told you he didn't, in his own words, in his own handwriting, which was verified by law enforcement. There's no evidence that James Crumbley had reason to believe his son would hurt anybody. I went over this a few minutes ago. Christy Gibson Marshall's testimony was that she had known James Crumbley and his son since approximately 4th grade. She told a story about James emailing her and asking about getting his son's report card or grades or something along those lines, and she responded and said, "Give him a hug for me." She testified about everything she saw, heard, and felt on November 30th of 2021. And as I said, she talked about seeing the shooter walking toward her with a gun in their hand. That as the shooter got closer, she recognized that it was James's son. And in those moments, she thought to herself, this can't be right. He's always been such a sweet kid. She was in such disbelief that it was his son that she even tried to talk to him. As he's walking through the school with a firearm in his hand, she is trying to talk to him because she just can't believe that James's son was the shooter. And it was when he wouldn't respond that she realized it must be him. ATF agent Brandon testified there were no laws governing the storage of firearms. We went over this a little while ago. We talked about the various ways that you can store firearms. I outlined a few of them. He testified that people store firearms unloaded and unlocked, which in and of itself is not irresponsible or dangerous in 2021. Not putting a gun in a safe or using a trigger lock alone does not mean that that person is irresponsible. Now, ATF agent Brandon gave you his opinion about what he saw on that math homework. That opinion was given within the last couple of days. And with all due respect to Agent Brandon, his opinion on what he saw is irrelevant. It doesn't matter in this case. What matters in this case is what people thought that math homework showed on November 30th of 2021. And those people weren't concerned. They didn't see what Agent Brandon saw. They saw images that weren't concerning, that are common, that other kids write and draw about. The concern was that he was sad and needed to talk to someone. On November 26th of 2021, we saw evidence and her testimony that James Crumbley went and bought the Sig Sauer at the gun store. James had been to that gun store on multiple occasions. We heard that testimony from Miss Back, who told you that she recognized him because he'd been there before. There were at least 2 other handgun purchases from that store, which we heard about, the .22 Derringer and the .22 Caltech. James indicated, per Miss Back, that he'd been looking at the Sig Sauer for a few days, or a while. She couldn't really remember which one it was. She testified to both. That he knew that that was the one he wanted to purchase. So he did. You also heard Agent Brandon testify about the cable lock that was found in that Sig Sauer gun case. That the sleeve that the cable lock came in was essentially in pristine condition, that the keys were still inside the lock. Now, if you recall, that 6 hour was used. James bought that used. That sleeve being in pristine condition means that the person before him didn't use it either. You also heard that James did not purchase ammunition on November 26th of 2021 or at any point prior to November 30th of 2021 for that 9mm. There were purchases for ammunition when he would go to the gun range for the 22s, but James didn't purchase 9mm ammunition before November 30th of 2021. Cammie Back told you that she had, that James didn't even talk to his son while they were standing there in the gun store. She didn't see any of that. She had no reason to believe that James was buying that gun for anyone but himself. And if she had, she couldn't have sold it. So obviously she didn't think that. On November 3rd of 2021, James Crumbley and his wife left a hotel that they had been staying in. Well, they had stayed in a couple different hotels, but they left a hotel that they had stayed in after the shooting on November 30th. You heard some testimony, or you heard some information that their residence had been made public, or there was media there, or there were things going on, and you can imagine. I mean, you all can imagine what that was like in the days following the shooting at Oxford High School. You heard Agent Brandon testify today that James and his wife were in and out of that building throughout the day on December 3rd of 2021. You heard testimony yesterday from Detective Willis that they arrived at approximately 11 a.m. and that they were there for the day. They were obviously arrested later that night. But you heard testimony that Luke Kirtley saw at least James Crumbley. You heard that James and Jennifer had both gone in and out of the building. Jennifer is his wife, had both gone in and out of the building throughout the day, various times to smoke, walk out to the car. Sometimes one of them went, sometimes both of them went. December 3rd, 2021 was a Friday. It was a work day. They were in and out. You heard that there were at least 14 cigarette butts found near their vehicle. You saw over 300 exhibits during this trial. You heard testimony from over a dozen witnesses. None of them told you that James knew what his son was planning. None of them told you that James knew that his son was a danger to anyone. None of them told you that James knew that his son knew where those firearms were hidden. None of them told you that James knew that his son had somehow obtained access to the firearms that he had been hiding. None of them told you that. Because on November 30th of 2021, James Crumbley had no knowledge about any of that. He had no knowledge, and he had no reason to suspect what his son was planning to do later that morning on November 30th of 2021. Now, every time I do a trial, I have somebody tell me that they think of a reasonable doubt that I may not have thought of. So, think of your own. You don't have to agree with all of mine. You don't have to agree with any of mine. You can come up with your own reasonable doubt. Based on the evidence that you've seen, the testimony that you've heard, your collective memories, you can come up with your own. You're not limited to what I've come up with, and you can certainly reach your own reasonable doubt conclusions on your own. And as you deliberate, think about the things you did not hear during this trial. Think about the things that you were told you would hear during the opening statements, that you would hear how the shooter gained access to that gun. You didn't hear that. That you will hear from school officials regarding their concerns about the math worksheet. You heard that they were concerned about sadness, not about danger to others. That you will hear that the need for immediate parental intervention was necessary. You didn't hear that. In fact, you heard the opposite. You heard that Sean Hopkins said that James and his wife, that they wanted James and his wife to have their son talk to someone or to at least make arrangements within 48 hours. No one testified that immediate parental intervention was necessary on November 30th of 2021 during the meeting with Sean Hopkins and Nick Ejak. No one testified that there was a need for immediate intervention of any kind, discipline, mental health, or otherwise. You did not hear testimony detailing how the shooter obtained access to the Sig Sauer. You just saw in his journal that he said he had access, but you don't know how that happened. No one testified that the shooter knew that there was any sort of code to open the gun safe. There's been some talk about the code that was used on the gun safe with the Keltec and the Sig Sauer. There was no testimony that the shooter even knew about that code or what it was. You did not hear any mutual concern for the shooter's well-being from his best friend's dad, who you saw text with between James and his friend's dad, who obviously has experience with mental health with his own child, from what you can see in the texts. And even that man didn't express any concern for James's son. In fact, on November 30th of 2021, he texted James, said, "I hope everyone's okay." No one told you that James Crumbley was aware of the texts or videos that were sent to his son's friend. In fact, they all testified, all of the witnesses testified they couldn't tell you that. They couldn't tell you that he was aware. You don't know if the shooter ever actually did do what he told his friend he was going to do. He was going to tell his parents about this, that, and the other. You heard no evidence that he actually did. You heard no evidence that he actually told James any of that. And when you go back for deliberations, think about everything that James Crumbley did not know. He did not know he had to protect others from his son. He did not know he wasn't exercising ordinary care in the way he was storing his firearm because he didn't know that his son was planning what he was planning. He did not know that it was reasonably foreseeable that his son would commit these offenses. He had taught his son firearm safety. He had taught his son to be familiar with those firearms because they were in the house. He had no idea what his son was planning to do. In fact, no one that interacted with James Crumbley's son on November 30th of 2021 knew what was going to happen a short time later. No one. And this is the part of the trial that I dislike the most. The prosecution gets to stand up and make a rebuttal statement, and I have to sit down, and I don't get an opportunity to respond. That's how trial rules work. The court has told you that. That's just how it works. But the hard part for me is that every time I hear a rebuttal from the prosecution, I think of all these things that I want to say. Think of all these responses that I can give. So what I'm going to ask you to do, we've gotten to know each other over the last couple of weeks. You've seen how I am in court. You've heard the questions that I asked. So when you go back to deliberate, think to yourselves, what would Marielle say? What would she say about this? What would she say about that? Because unfortunately, I can't tell you. I join with the prosecution in thanking you all for the time and attention that you've paid to this case. You have heard some of the most emotional testimony and seen some of the most difficult things that I can imagine a juror could see. And you likely may not be able to forget it. But what you're all doing in these chairs is of the utmost importance. And I thank you for the time and attention that you've paid. Early on in this case, during our opening statements, the prosecution and I both asked you to follow the law. And I'm going to ask you again. Follow the law. The judge will instruct you on what the law is. She will give you very clear instructions. Please, follow the law. Review the evidence. Review the instructions. And follow the law. Because I'm confident that if you do that, each of you will have at least one reasonable doubt. And your vote will be not guilty. And your vote should be not guilty. Not just because you have reasonable doubts, but because James Crumbley is not guilty. Thank you.
Thank you, Ms. Lehman. Rebuttal, prosecutor.
You know what my least favorite part of the trial is? It isn't listening to the defense argue that her client is not guilty. She has a right to do that. It isn't even listening to what I believe, and I'm going to tell you what I think is inaccurate. My least favorite part of the trial is that even where we're standing here and our criminal justice system provides for justice for victims, and my job is to advocate for them, and I'm standing up here and I'm doing that. I've been doing that all week and several weeks before, and I'll keep doing it. You know what my least favorite part is? It doesn't take away any of the suffering. It doesn't take it away. So, don't deliver a verdict thinking that it will, because it doesn't. Your job is to follow the law and use your common sense when you consider the evidence. I embrace the high burden of beyond a reasonable doubt. I believe in it wholeheartedly, devoted my whole life to it. I embrace it. It's what we use for every prosecution in this country, every single day of every year, for decades and decades and decades. That's the burden we have. And it is not, despite what the argument is always, any possible doubt. You have to be 100% sure. If you're 100% sure, we probably don't need criminal trials. And you can't be. We can't be. That doesn't make any sense, does it? We can't get inside the head of people who commit violent crimes or any crime and decide what they knew and what they wanted and if they loved their kid. I hope he did. I hope he does, by the way. I assume he does. We all do. We all love our kids. That's not my job. It's not my burden. So I embrace my burden, but I'm not going to embrace something that's just not true. Because it is not true that I have to prove, and the people of the state of Michigan have to prove, what James Crumbley knew. It is not true that the people of the state of Michigan have to prove that he knew his son was going to kill somebody. We've talked about this before. If that were the case, he'd be charged with murder. That's not my burden. That is not what I have to prove. The judge is going to instruct you what burden. It's a reasonable burden, and it's as to the elements that I have to prove. Only the elements. Beyond a reasonable doubt, using your common sense and your reason. The elements, and what are the elements? You're not going to hear that the elements of this crime are that I have to prove what he knew, what he actually knew. That's not the law, ladies and gentlemen. That is not the law. The law is I have to prove beyond a reasonable doubt what a reasonable person would do using ordinary care. That's what I have to prove. There's a couple things I have to correct. The questions defense counsel asks witnesses are not evidence. It's the answers that are evidence, and you have to decide whether that's credible. But Special Agent Brandon did not testify that it was safe. He would call that secure if an unloaded gun was stored separately. In fact, that's not what he testified. What he testified to was that it wasn't storing the firearm or ammunition wouldn't make it secure if you had a 15-year-old who knew how to load and shoot that gun. That was his testimony. You did not hear from people at the school that they were not concerned. That was not the testimony. You did not hear that James Crumbley went home because he was trying to check on his son and he was worried. None of that happened. You heard the 911 call. You have to rely on what you heard, not the questions that were asked. Defense counsel put up a statement from the Journal about my gun and where my dad hid it. And she's urging you to find that credible. But if you do, and we argue you should find, it's all credible. You don't get to pick one statement from a journal and say he was telling the truth there. But all the stuff about how he asked his dad for help, that wasn't the truth. You have to use common sense. And I'm not going to go through every single thing that Ms. Lehman told you, because I know that you were all taking notes and you all listened to it. And I laid out, and I know you remember the testimony. But the one thing I'm just going to ask you one more time is, I embrace my burden, but you have to hold me to the law and what I actually have to prove and what the judge tells you I have to prove, which comes down to common sense and reasonableness. Let's step back. We have a person, we have a father who purchased a gun as a gift. He knows he has it. He knows how to use it. He knows he's in the house by himself after it's purchased. He gets called to the school. And the words on the paper, the drawing on the paper is of that gun. You heard Special Agent Brandon. The testimony speaks for itself, and so does the drawing. He saw the words, blood everywhere. He saw the image on the paper with the bullets and the person bleeding. He understands exactly, because the image there, and you saw it, that's exactly where those bullets landed. The thoughts won't stop. Help me. I want help, but my parents don't listen to me, so I can't get any help. And then that day, just hours before, help me. Use common sense. It doesn't make any sense to stand here and say someone had no idea that he needed help when he saw on the page, help me. It doesn't make any sense. Because any reasonable person, which is the standard you have to use, using ordinary care, would know that. Because it actually says, help me. The world is dead. My life is useless. Those messages you saw, that's exactly what he thought. We know what was going on because of the messages in this journal. And then we know there was a cable lock. You did not hear any testimony about who owned that gun and whether that lock was used or another lock was used. But you do know that whoever purchased that gun had to be 21 years old. You do know that. We've been telling you since this case started, it would take tragically small things to prevent these deaths. And you're hearing a lot about how to store a weapon. And the truth is, this has nothing to do with a safe storage lock, and you don't have to lock a weapon up to make it secure. There's lots of ways to make it secure. But what isn't secure is leaving it around, which we know he did with his other weapon, leaving it around. My dad left it out, LOL. I thought, why not? Loaded, knowing that your ammo is right there. We know that is not secure. But let's talk about one of the ways that we can prevent access to minors. This is the murder weapon. This is the gun. We know we presented evidence of this. I'm going to put it right on the table. This is a cable lock. This little piece of cord. This is me inserting the cable lock. We know that a cable lock was in the home. We know it was provided. This is me inserting a cable lock. That takes less than 10 seconds. Takes less than 10 seconds. 10 seconds. You don't have to go find it. You don't have to go buy it. It was provided. It was right there. You just watched me do it. 10 seconds of the easiest, simplest thing. One of which, by the way, not the only way. Locking was not the only way to prevent this, but it was one way, and it took less than 10 seconds. Let's talk about the gun being hidden. Let's talk about that. You heard the defendant's sister say, yeah, he went and got the gun from his bedroom. These are the other two guns. Ladies and gentlemen, the guns were kept in the bedroom. The family was there when she was told that, and everyone knew the guns were kept in the bedroom. This is where he says he hid the gun, the armoire. This is what it looked like that day. Wet towels folded over it. It wasn't even closed. He says it was in the armoire under some jeans. This is not hiding a weapon. This is just where you kept it. It is not reasonable to conclude that a 15-year-old who spends all kinds of time in the house alone would not know where it was, because it wasn't hidden. This isn't a case where we have a parent who hides a weapon far out of reach from a child who couldn't get to it, doesn't know it exists, ammunition in a totally separate spot. The kid, that's not this case. It's reason and common sense is what we have to use. We know that James Crumbley went home and looked for a gun when he heard there was an active shooter. And we know he referenced there was that meeting at the school. That's foreseeability, and that's a person who suspects their own son. And that is what I have to prove. Foreseeability to an ordinary, a reasonable person using ordinary care. This case is not a statement about guns. It's not a statement about parental responsibility. It's not about kids doing kids things. The kids on November 30th in that building were doing kids things. Hannah, Madison, Tate, Justin, they were going to class. They were talking to their friends. They were dancing in the hallway. Those are kid things. Parenting is the hardest job that we'll ever do. The hardest job, and one of the most important ones, but it's exhilarating and joyful and the best experience of our lives. We look at our kids when they're born and we see hope. But they can break your heart. They're supposed to. They have to leave someday. They don't come with a set of instructions. I'm not here to tell you that this case is about somebody who didn't follow the instructions to be a perfect parent. But we do have a guide. We do have a basic standard for ordinary care. We all have doubts about our kids. We all worry every minute of every day that they're going to do something or something's going to happen to them, and then it might be because of something we did or we didn't do. We are not responsible for everything our kids do. This prosecution in this case is not inconsistent with that. It just isn't. This is a very egregious and rare set of facts. We do have a measuring stick, ladies and gentlemen, and it's the law. And it requires us to use ordinary care. And there is a consequence if we don't. In a very limited way that the law allows a parent to be charged. Your job now is to go back there and use your reason and common sense and follow the law. That's what your job is. You've listened to all the evidence, and at the end, you will conclude that James Crumbley failed. He might love his kid, I hope he does. But stick to what I have to prove. Stick to what I have to prove. And remember that he didn't just fail in his duty to his son. He failed in his duty to protect Hannah and Justin and Madison and Tate. And I don't say their names to evoke sympathy. I say their names because they matter. They matter. And that is why we are here. We are absolutely here about what happened in that school that day. Because if James Crumbley had done even the smallest of things, like the 10-second cable lock, or gone home, or took responsibility for his kid who was in trouble, those kids wouldn't have been shot and killed in that school on that day. I have met my burden. Mr. Keese and I, the people of the state of Michigan, have met the burden to find James Crumbley guilty of 4 counts of involuntary manslaughter. And I ask you to return that verdict. Thank you.
Thank you, prosecutor. I'm now going to read jury instructions to you. Does anybody need a break before I do that? Anyone needs a break? All right. You're going to get a copy of these jury instructions in the jury room. All right? Members of the jury, evidence and arguments in this case are finished. I'll now instruct you on the law. That is, I'll explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any facts in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all of my instructions as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it's your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout this trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt that is based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of the case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what evidence is and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments and commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, my questions to the witnesses, are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law, and to tell you the law that applies to this case. However, when I make a comment or give you an instruction, I am not trying to influence you or influence your vote or express a personal opinion about this case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it's your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's disability, race, national origin or ethnicity, gender, gender identity, or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in this case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they saw, what they thought they saw, or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that's important to how you decide this case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. James Robert Crumbley and Jennifer Lynn Crumbley are both on trial in separate cases. The fact that they are both charged is not evidence that either one is guilty. You should only consider the evidence presented in this case. Each defendant is entitled to have his or her case decided on the evidence and the law that applies to him or her. The prosecutor needs to prove beyond a reasonable doubt that the crimes occurred on or about November 30th, 2021 within Oakland County. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider out-of-court statements against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that's direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it's raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. There has been some evidence that the defendant ran away and tried to hide after he was accused of the crimes. This evidence does not prove guilt. A person may run or hide for innocent reasons, such as panic, mistake, or fear. However, a person may also run or hide because of a consciousness of guilt. You must decide whether the evidence is true, and if true, whether it shows that the defendant had a guilty state of mind. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you're not required to do so. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard that a lawyer or lawyer's representative talk to one of the witnesses. There's nothing wrong with that. A lawyer or a lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You've heard testimony from witnesses Detective Edward Rogrowski, who has given you his opinion as an expert in the field of forensic cell phone analysis. Experts are allowed to give opinions in court about the matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they give for their opinion and whether these facts are true. You should also not think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standard you use to evaluate the testimony of any other witness. In count one, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Madison Baldwin. That is, Madison Baldwin died as a result of storing a firearm and its ammunition so as to allow access to the firearm and the ammunition by his minor child. Second, in doing the act that caused Madison Baldwin's death, the defendant acted in a grossly negligent manner. In count two, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Tate Meir. That is, that Tate Meir died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by his minor child. Second, in doing the act that caused Tate Meir's death, the defendant acted in a grossly negligent manner. In count three, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Hannah St. Juliana. That is, that Hannah St. Juliana died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by his minor child. Second, in doing the act that caused Hannah St. Juliana's death, the defendant acted in a grossly negligent manner. In count four, the defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Justin Schilling. That is, that Justin Schilling died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by his minor child. Second, in doing the act that caused Justin Schilling's death, the defendant acted in a grossly negligent manner. In count 1, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Madison Baldwin. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. The parent knows or has reason to know that they have the ability to control their minor child, and the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and his failure to perform it was grossly negligent to human life. Fourth, that the death of Madison Baldwin was directly caused by defendant's failure to perform this duty. That is, that Madison Baldwin died as a result of defendant's failure to exercise reasonable care to control his minor child so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that he had the ability to control his minor child and knew of the necessity and opportunity to do so. In count 2, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Tate Muir. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that causes an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. The parent knows or has reason to know that they have the ability to control their minor child, and the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and his failure to perform it was grossly negligent to human life. Fourth, that the death of Tate Muir was directly caused by defendant's failure to perform this duty. That is, that Tate Muir died as a result of defendant's failure to exercise reasonable care to control his minor child so as to prevent the minor child from intentionally harming others or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others, when the defendant knew that he had the ability to control his minor child and knew of the necessity and opportunity to do so. In count 3, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Hannah St. Juliana. This legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. The parent knows or has reason to know that they have the ability to control their minor child, and the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and his failure to perform it was grossly negligent to human life. Fourth, that the death of Hannah St. Juliana was directly caused by defendant's failure to perform this duty. That is, that Hannah St. Juliana died as a result of defendant's failure to exercise reasonable care to control his minor child so as to prevent the minor child from intentionally harming others or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew he had the ability to control his minor child and knew of the necessity and opportunity to do so. In count 4, the defendant is charged with the crime of involuntary manslaughter resulting from a failure to perform a legal duty. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Justin Schilling. The legal duty charge here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. The parent knows or has reason to know that they have the ability to control their minor child, and the parent knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and his failure to perform it was grossly negligent to human life. Fourth, that the death of Justin Schilling was directly caused by defendant's failure to perform this duty. That is, that Justin Schilling died as a result of defendant's failure to exercise reasonable care to control his minor child so as to prevent the minor child from intentionally harming others, or the minor child from so conducting himself so as to create an unreasonable risk of bodily harm to others when the defendant knew that he had the ability to control his minor child and knew of the necessity and opportunity to do so. As I explained to you earlier in my instructions, the prosecutor asserts two different theories, to support the charges of involuntary manslaughter. First, the prosecutor claims that the defendant committed involuntary manslaughter because he failed to perform a legal duty. In the alternative, the prosecutor claims that the defendant committed involuntary manslaughter because he was grossly negligent. Those are two different theories and two different ways to prove the same crime. Either or both of these theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It is not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt. There may be more than one cause of death. It is not enough the defendant's act made it possible for the death to occur. In order to find that the deaths of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. You heard evidence that the defendant's son shot Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling. As previously noted, there may be more than one cause of death, and defendant's acts or inactions need not be the sole cause of harm. In order to find that the death of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling was caused by the defendant, you must also find beyond a reasonable doubt that his son's act of shooting someone was reasonably foreseeable. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. I previously indicated to you that it was my order that the shooter's name not be used during the trial. When you go to the jury room, you'll be provided with a written copy of my jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you'll discuss the case amongst yourselves. But ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and your reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide that you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you should write a note, and you can give that note to my clerk. Possible penalties should not influence your decision. If you find the defendant guilty, it is my duty to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my clerk. It's not proper for you to talk directly with me, the lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. We're going to send, you can take your notes with you, and we're going to send the exhibits in with you. I think some of them might require a computer. We'll give you that as well. If you, so we're going to send all the exhibits in. This is also one I like to tell you that you can rehear, we can replay testimony, but I think I told you this in the beginning of the trial. If you want to rehear someone's testimony, you have to rehear the entire testimony, all of the questions from both sides. That's the only way that it's fair, all right? But we can replay that in the jury room. As you discuss the case, you should think about all of my instructions together as the law you are to follow. The defendant is charged with 4 counts of involuntary manslaughter. These are separate counts, and the prosecutor is charging that the defendant committed all of them. You must consider each count separately in light of all the evidence in the case. You may find the defendant guilty of all or any one of these counts or not guilty. I've prepared a verdict form. It's pretty self-explanatory. It lists each of the counts, and this should be filled out by your foreperson. Count 1 is involuntary manslaughter as to Madison Baldwin. You can either check the box not guilty or guilty of involuntary manslaughter as to Madison Baldwin. As to count 2, involuntary manslaughter as to Tate Meir, not guilty, or guilty of involuntary manslaughter as to Tate Meir. Count 3, involuntary manslaughter as to Hannah St. Juliana. You can either check not guilty or guilty of involuntary manslaughter as to Hannah St. Juliana. Count 4, involuntary manslaughter as to Justin Schilling. You can either check not guilty or guilty of involuntary manslaughter as to Justin Schilling. Then your foreperson should sign that. All right? I know you've been in 2 different jury rooms, so probably some of you, the first 8 of you, don't know the others. This is going to be kind of like on the show Survivor when they have the merging of the tribes, right? So we're going to put you all in one jury room. We had you in separate jury rooms just because it's much more comfortable. All right? We appreciate that you were all here the entire time. Jurors have different feelings when they're excluded from deliberations. Some people are happy, some people are not happy. I can tell you a lot of stories about, life happens, so all of your service is important. This is obviously very important and very stressful to both sides, and we couldn't conduct this jury trial without you. So we are going to exclude 3 jurors by blind draw. Okay? juror in seat 5. Juror in seat 5, you are in my jury room, I believe. Do you have any personal belongings? Okay, I'm going to ask you and the other 2 jurors that we're excluding to get your personal belongings and come back in here, all right? Juror in seat 10. You're juror in seat 10. You are in Judge Anderson's jury room, the second jury room. Do you have personal belongings in there? Okay. And you're in seat 15. All right, actually, why don't I ask the 3 of you to get your personal belongings from the jury rooms, and then go with Miss Nellett to my chambers. All right? So you'll go to the jury room that your belongings are in and come out into the hallway, and Miss Nellett will escort you into my chambers. All right? All right. You can be seated. Okay, so do some of the jurors here, anyone 9 through 15, do you have anything in Judge Anderson's jury room? Okay, I'm gonna let these 3 jurors go into my chambers, and then anyone 9 through 15, if you have something in Judge Anderson's jury room, then you're going to go to my jury room. All right? Okay. So I'm going to give them a few minutes. Also, after you go back there, I'm going to ask you to wait a few minutes before you start deliberating. I want to consult with the lawyers to make sure the jury instructions are correct. Sometimes things are left out or there's mistakes, so I just want to make sure. I also want you to know that we're now on your schedule, so what you say goes. If you take a 5-minute break, an hour-long break, whatever you do, we will be waiting for you. There's potentially an opportunity to go later tonight if you want to do that. I want to encourage you to take your time. You can come back tomorrow, you can go later today, whatever you need to do. We want you to be careful, keep an open mind, and take your time. Right? So I'm going to wait and see if those 3 jurors are in my chambers. It's happy here, right? Yes. We try. This is an old building. All set? All right, so if you can all get together in my jury room, I will send jury instructions in there shortly, and then you can start deliberating. You can't deliberate unless you're all there, so. All right,
All right, for the jury.
Oh, sorry. Seated. There is one error in the jury instruction on 4.1. At the end, it talks about in deciding if you believe the defendant's testimony in court. So I'm just going to
yes,
take
Judge.
it out.
Thank you.
All right. Anything else about the jury instruction?
Nothing other than that, Judge.
Nothing, Your Honor.
All right. We have your cell phone numbers, right?
I'll be here, Your Honor.
Okay.
We will be 5 minutes away, I promise.
I think the media is asking for a copy of the jury instructions, which I'll provide if you both agree. If you don't, I won't.
I have no problem with that.
No objection, Your Honor.
All right. Anything else? Oh, you're going to give me all the exhibits.
I have them here.
Okay.
We have the exhibit list with redacted portions for any exhibit that was not admitted.
Okay.
Proceed.
Yeah. Yeah.
We have a judge's copy as well.
Okay.
Yeah.
All right, thank you. Yeah, thank you. Anything else about that? All right, so aside from that correction 4.1, you agree with the jury instructions?
People do, Judge.
You're okay if I send the exhibits in and they are going to start deliberating?
Yes, Your Honor. Thank you.
Okay. All right. Let me make sure the doors are open.
Ms. Williams, the updated exhibit list has been emailed to you, so that was being printed. Okay, thank you.
All right, you've been watching day 5 of the James Crumbley trial, father of the Oxford High School shooter. Today marked a pivotal moment for both sides as they laid the case to rest, and closing arguments have began and now have ended. We also just heard Judge Matthews read jury instructions. Notably, we did see the defense call a witness to the stand. That witness was James Crumbley's sister, Karen Crumbley, who lives in Florida. She was on the stand for about 15 minutes. Central to the prosecution's argument is that the crime was foreseeable, which further points to the Crumbley's negligence in this case. On the other hand, the defense's argument is that James Crumbley could not anticipate his son's actions, advocating for a reasonable doubt. One thing to keep in mind here is that the prosecution must prove one of the two theories in order to secure a guilty verdict. You can see here on your screen, and Judge Matthews also went over this during her reading of jury instructions. The first theory here is that there was gross negligence in the performance of a lawful act. One, the defendant caused death. 2, in doing that act that caused death, the defendant acted in a grossly negligent manner. Here is the second theory. This one is negligence, gross negligence in failing to perform a legal duty. And you can see here there's 4 clauses here that lead to theory 2. The 1 is the defendant had a legal duty to the victim. 2 is the defendant knew of the facts that gave rise to the duty. 3, a defendant willfully neglected or refused to perform that duty, and his failure to perform it was grossly negligent to human life. And then the last one is the death of the victim was directly caused by the defendant's failure to perform this duty. Again, one of these theories have to be proven true in the case. Now things are in the hands of the jury. The judge urged the jury to take their time with their decision before heading into deliberations. We've got a recap of today, plus the previous 4 days on our website at fox2detroit.com. Of course, we'll update you as soon as the verdict's in. Charlie Langton will join us in about an hour here at around 4:30 to tell us what happened today. You can tune in on our website and on our Fox local streaming apps to watch. I'm Bree Teamer, and we'll see you at 4. Live Now on Fox is next.